And now the next case.
Parties on Basler versus Cora. Step forward, please.
29-year-old blackjack dealer Michelle Basler is suing her ex-husband, graphic artist Peter Cora, 32, for not paying his share of their federal income taxes. Peter is countersuing his ex-wife for harassment.
Ms. Basler, you and the defendant were married and divorced.
Correct.
And pursuant to your judgment of divorce, according to the defendant, he says that you were supposed to share the marital debts. Is that correct?
Yes, Your Honor.
And then you get a statement from the Internal Revenue Service saying that you were both deficient in paying income tax for a year while you were married, and they took your whole refund to satisfy that deficiency. Is that correct?
Yes, Your Honor.
And that was a joint debt.
Yes.
So you say he should be responsible for at least half.
Your Honor, a statement came to me from the IRS stating that almost $1,100 went to paying his Social Security.
His Social Security?
Number, not my number. The only reason why I was responsible is because I was married to him at the time, and we had filed jointly for 1994 taxes.
Were you working in 1994?
No.
In the year that was filed? You were not?
No, I was not.
What kind of work was your husband doing at that time?
He is self-employed.
You have children together?
Yes, we do, Your Honor.
How many children?
One.
How old is that child?
He just turned 5.
So you were staying home with him when he was young?
Yes, I did.
So how much did they take altogether?
They took $1,089.30.
Can I see, please, your judgment of divorce?
Sure. Here you go.
What kind of business are you in, sir?
I do graphic arts and printing.
Now, Ms. Basler, this judgment's divorce is clear. It says that the plaintiff, that's him, shall be responsible for 1/2 of various community debts, including Sears, Sizes Unlimited, Broadway, Phone Company, and IRS for 1994 taxes, among other things. Defendant shall be responsible for 1/2 of the community debts and the debt against the 1988 Mercury. This divorce judgment was in 95, was filed in 95. Clearly, this says that you're responsible for half.
Correct.
Okay. That means you're responsible for half.
Correct.
Good.
We're equally responsible for half of all community debts. And I spent over $3,000 in community debt. And I figured she didn't have a job when we were divorced. And I wanted to just, try to be fair. I paid him. I figured eventually one day down the road, it'll all wash out.
Okay.
The first penny taken from her, she blows up.
Okay. So let's see. Plaintiff, that's you. Sears bill. I'm going through each one of them. Let me see what you paid to Sears.
Your Honor, I have a $22 check for Sears that I don't have a copy of, but that was all that I paid.
$22 to Sears. Sizes Unlimited.
$150.34.
$150. So I'm going to give you credit for half of that. Sizes Unlimited. That was your bill?
Yes.
$75. What's next? Broadway.
Total for Broadway was $198.86.
Let's make it an even 200 because I'm so poor in math. Is that all right with you?
Yes.
Half. You get credit for $100, sir. I assume you have receipts for all these things that you paid.
Canceled checks, yes, Your Honor.
Good. So in total, sir, instead of these thousands of dollars that you're talking about, you got $175 that I'm going to give you credit for because that's what the divorce decree says.
Okay.
Right?
Fine. In the judgment, it also stated that we were to share in the payment of her father's house, which I paid a payment of $1,045, and that was the only payment made.
Just a second. Okay, both parties shall be equally responsible for the defendant, that's you, refinancing of her house in California while your father resides in the house. What does that mean?
Basically, we borrowed money on the house, and I agreed as long as her father was living there that I would share in the cost.
What do you mean you borrowed money on the house?
The house belonged originally to Michelle and her sister. Her sister basically wanted nothing to do with the loan that we needed when we moved to Las Vegas.
Just a minute. What you telling me you took out a home equity loan on the house?
Yes.
Well, why don't you just say that? That's something
Okay.
I understand very clearly. You took out a home equity loan on her house.
On her house.
On her house, on her property.
Correct.
And what'd you all do with the money?
We moved to Las Vegas.
Together.
Together.
How much money, sir, would you say you used of the home equity loan?
Between the two of us, all of it.
How much?
Your Honor, I can't give you an exact
Give me an
amount.
idea.
Okay, the first loan was in the amount of 75,000 is correct. Over 40,000 of it went to purchase a home here in Peter's name. I was not on that house. I had given him the money for the down payment. We lived there. And the rest of it was to pay off consumer debt and to live, because Peter didn't have a job from the time we moved to Las Vegas until shortly after we moved in October of 91. It wasn't until the end of January of 92 that he found employment.
Is that right?
That's correct.
Judge Judy will continue in a moment.
$270 a month is an outrageous amount of child support from what apparently is an educated man like yourself in his own business, right, who's got money for a tape recorder.
Real cases, real people. Judge Judy. Michelle Bassler wants her ex-husband, Peter Korer, to pay his share of their federal income taxes. He wants her to stop harassing him.
The reason I find that interesting is because I read your answer, sir, and in your answer, sir, you said that she didn't work, that you supported the whole family, that you worked and took care of everything, she just stayed home.
For the most part, I met the obligations. I was the one earning the money to pay back the loan.
Well, how much did you pay back?
We were paying probably around $1,000 a month, but
How much did you pay back?
we paid back at whatever the loan payments were until there was a balloon at the end of the loan. That's what caused the refinance.
How much did you pay on
The
it?
loan was a 30 due in 3. At the end of 3 years, I had a refinance. Peter made one payment before our divorce, and the rest of the time my sister and I took care of it.
Okay. Now, what's all this other thousands of dollars for harassment, Mr. Korer?
She has taken me to court for several things. She has told the district attorney statements that were absolutely false, and she has dragged me to court. She's made me out to be a deadbeat dad. I have paid every dime of my child support. My child is my primary concern. My divorce decree says 18% of my income. Since my income fluctuates, my child support payments fluctuated. So she...
Oh, did you have lawyers representing you in this divorce proceeding?
Yes, I did.
Did you?
Yes, Your Honor.
Don't you understand, madam, that when somebody is self-employed, you don't say, I'm going to accept 18% of his income. That brings you back and forth every single time a month comes due, because you don't have a paycheck to look at, and you have absolutely no way of checking. And the only way she has to check, sir, is if she takes you to court. So this is a very foolish thing to have in a support order, 18% of your income. Very stupid.
Your Honor, can I play a tape for you?
Just a second.
It's very critical in the harassment charges.
Just a second.
Yes.
Tell me what the tape is going to say to me.
Basically, it goes with her rambling on and on, how I'm going to take you to district court, I'm going to take you to family court, I'm going to keep you in court, I'm going to make your life miserable.
So why don't you go into court, sir, and say, I want a fixed amount to pay every week?
We already have that. The district attorney ordered me to pay $270 per month, period.
Your Honor, that issue is not finished. He has to prove his income. He supplied me with computer-generated income taxes in family court. And when we went for divorce, I was not represented. Peter went to court by himself.
Listen to me. Listen to me. I think that until you get the issue of support resolved, there is going to be continued acrimony. You cannot have a support order that says 18% of your income, especially when you are self-employed. So I would suggest as fast as you can to get the matter of support resolved.
It has been.
No, not according to her. If a district attorney directs you to pay a certain amount of money, sir, that is not a court proceeding. A district attorney is there as an interim advocate. So he has suggested that until this matter is ultimately resolved, you pay $270. But I'm telling you this, sir, if the judge, after hearing this case, determines that you, in fact, earn more than what you told the district attorney, based upon several factors, some of which I don't think I'm going to tell you now, so that they might come as a surprise to you. You must be prepared to pay more than the $270 a month, because that doesn't probably represent 18% of your actual income. We understand each other?
Yes.
Perfect.
Judge Judy is ready to rule.
Your counterclaim, sir, is dismissed. I am
You won't
awarding...
allow me to play this one last piece of evidence?
No, I'm not interested in her telling you she's going to take you to every court in the United States, including the Supreme Court of the United States. $270 a month is an outrageous amount of child support from what apparently is an educated man like yourself in his own business, right, who's got money for a tape recorder. So if she's annoyed that you went through clearly with her a lot of her money, I can understand that. Shouldn't have to trust you. I get $373, Bird. I get half of 1089.
Right, which is 544.65 was what I came up with.
544. Go ahead.
65.
Less
and then
ones?
I took away 175, and
what
I
do you
came up
get?
with 369.65.
Oh, that's right. 369. Judgment for the plaintiff. Thank you very much.
Parties are excused. You may step out.
Judge Judy will continue in a moment.
Thanks, sir.
And on the next Judge Judy.
For the sake of my child, I'm always polite to her. My child is #1 priority. I will not be nasty in front of her, in front of my child to her. And it was ordered in the court, in the divorce decree, that we aren't nasty to each other in front of the child.
You people had better stop torturing each other.
These neighbors went to war over a nasty letter, a $20 debt, and a rusty typewriter with each other.
Never worked when I borrowed it.
What does that have to do with you? Whether she keeps it outside, whether she from her tree, whether she wants to wear it as a lorgnette around her neck. It's her typewriter. She keeps it hanging once with it.
You are about to enter the...
Forward, please.
Jeff and Lori Haskett say neighbor Carol Woolfolk slandered and
Please.
in a letter.
Was a neighbor of yours, has defamed you by sending out a series of letters about you to neighbors, series of, and one to an employer. Do you have copies of those?
I certainly do.
May I see them, please? Did those letters? Did you write this letter?
Yes, I did, Your Honor.
And who did you send it to?
Only to the tenants in the park and the people that CC'd on their
Circulate.
lawyers. That's not true.
Well, there are a lot of
No
this letter. It's sort of a rambling letter. But there are several things in here that I want to address. Things in this quickly. Show me proof of arrests specifically while under the influence of alcohol.
I can't show you proof of that. It's something that she
For drug.
held people in the park like it's an Olympic medal or something. This is something she's admitted to. Goes around and
Baloney.
Just a second. Did you
About
have
this?
any written proof that she or her husband have
I
arrests?
didn't say her husband. I said she.
Has arrests for driving under the influence.
No, this was something that she told
She.
specific. If it's a lie, she told it. Told me.
Did you ever tell her that you were arrested for
Yes,
driving?
sir, I did.
Why did you tell her that?
Okay, because we
Was it
did-
true?
Yes,
Okay,
but that's my business.
just a second. Loss of custody of her
True.
child.
Again, something she told us. Because she's only had the child for a year.
of her child. Welfare fraud.
Again, she admitted to.
That's not true.
Oh, no. Oh,
This is
no.
something she admitted to, and something to that, too, Your Honor.
Yeah, oh, no, I never committed fraud.
Just a second.
I have witness.
Oh, no.
Eviction after eviction. The last several years.
Okay, can I tell you why some of these
To eviction.
over the past few years, I worked legal at some time. Things I know about having me do a bankruptcy for them, okay? And they were thinking the information that came out during that time when they were trying to tell me about their bankruptcy.
Yeah.
This is all.
Ms. Woolfolk, I have a couple of questions. I mean, there are a lot
Sure.
of things in this letter that's
Okay.
You people don't get along as neighbors. Suggest that
you're right.
and that you intend to pursue this matter legally.
Don't at all.
And that, according to the letter, you are trying to get a restraining order as the
Exactly.
plaintiffs. Just pay attention. You are trying to get a restraining order against them to stay away from you and your property.
Exactly.
And I assume that the thrust of this letter, you say, which brings me to the point of this letter, that you are trying to focal restraining order and request the assistance of, I assume, all the people that you sent this letter. Get a restraining. Should you see either one of these two people, or two,
Yes.
in or near my property, please call 911.
Yeah, that's correct.
Right?
Continued harassment.
Just a second.
Intimidation.
So my question to you is, what do the following things have to do with you? DUI arrests, loss of custody of her child, welfare fraud, eviction.
What did they have to do?
Yes.
Or the sale.
Shut.
Okay. They had personally. They had nothing to do with me personally.
Good. So
Okay.
what do they have to do with the focal point of this letter?
The do with me of the letter was to say these people are intimidating me. These people
Well, you've
are
said no.
harassing me.
You've said-
Focal point that these people are accusing me of calling a social worker. Did you read that part?
No,
They're
I read that.
accusing me of turning them into welfare fraud.
No, listen to me. I'm not addressing that.
Accusing me. Okay.
I'm looking at this letter, and you say that they have done and said very hurtful things, hurtful and harassing things
Yes,
to
that's
you.
true.
That a lot of, none of which is germane to any of these that you attribute to them. The DUI arrest, acts of custody, welfare fraud, anything else. That doesn't have anything to do with what your complaints are.
Right.
So you gratuitously put that in this letter.
No, that's
Nothing about.
They accused me of calling a social worker. You understand what I'm saying?
Oh, what you're saying, I think you're full of baloney.
Yeah.
I think that you put this in the letter just to embarrass them. Sure, I understand.
She needs to be
No,
embarrassed.
No, just to,
you know, I wanted to keep her from intimidating me anymore.
No, okay.
I wanted to, well, from
Okay.
harassing me. She
Okay.
stayed in the house 3 weeks, and that
Okay.
was fine
Now,
with
just
me.
a second.
She should have been embarrassed. Stop her.
I was
Hey,
humiliated, embarrassed.
hey, just a second. Hey, you want to say something? You're dying to say something.
Yes,
Yeah,
I am.
yeah.
Well, stand up.
That's not true, Your Honor.
What's not true?
This woman is harassing her.
I haven't gotten to that yet.
Okay, well,
Just a second. I'm talking about this. That's what I'm talking about. That's the first thing I'm addressing.
I
I'm going to address
understand.
everybody's
I under-
letter. I'm addressing this letter. And I absolutely understand that if any of this is true, conduct that should not be tolerated. If any of this harassment is true, it should not be tolerated. It's
right.
What I'm addressing is the gratuitous, gratuitous statements in here about them that had absolutely nothing to do with the problem of harassment. You got it? Absolutely
I
not.
understand.
Judge Judy continues in a moment.
Good. Understand?
I wrote the letter in November. This recording was made January the
I've read the you wrote. Carol, watch your
15th.
back.
Real cases, real people. Judge Judy. Jeff and Lori Haskett are suing Carol Woolfolk for defaming them to their neighbor. Carol claims the Hasketts make discriminating remarks against her.
You have a counterclaim.
Yes, I do.
You have writer estimate, $150.
Correct. That's the typewriter that
That's
they've
the
had.
type.
November the 7th.
How did they get the typewriter, Miss
He
Woolfolk?
they said she came over first and asked me to loan it to her. I have two.
I didn't. Shut up.
Came over. I'm sorry. Okay, I told her lie. So, of course, he comes. Jeff, I never have a problem with. No, never have. It's her. Jeff asked, I said, Jeff, how long you want to use it? A week? Fine. Time went by. Jeff, you going to bring it back? Yeah, I'll bring it back. Want to use it? Didn't show up, didn't show up. When is it going to bring the typewriter back? When they feel like it. This was her. This is when she came to my house, knocked on my door like it. This me out, told me she was not giving me the typewriter back. I was all these thunderous things. She scratched my car with her keys and then ran home with her slant.
Okay, now let me stop you right there.
Okay?
Okay, let me stop you right there. I assume,
Daughter.
from what you say, there was a time when you had a reasonable relationship enough with these people so that you just listen.
Okay.
You had a reasonable enough relationship with them or with him.
With him, yeah.
To lend him reasonable and a piece of valuable property.
Exactly.
What happened?
The
property.
It's, how can I put this delicate? It's not him, okay? If him, I would have got the typewriter back. It's been gone since November 7th. This is January.
Okay.
If it was him.
What caused the problem, the typewriter?
Yeah, that was her. She wouldn't return it.
Just a second. Is that what caused the problem, the typewriter?
Yeah, right.
Okay.
She cussed me out over
Just a second. Okay. Now, would you please take the typewriter from that side?
Typewriter.
Put it on that side.
No, you leave it over there. I don't want it back. I replaced it since November because it's something used.
Let me see the receipt for the replacement.
They've had it since November. I used it to do like evictions.
You have three typewriters. You
That.
have 3 typewriters.
Shh. Hey.
You don't know what I had.
Hey. This is an estimate of repairs.
Yeah, because I bought a used
Dated
one.
1/28/97.
I wouldn't have got that today. Yes.
You got it today?
Yeah, I got it today.
Return the typewriter to her. Just a second. Let us move on. Let us move on. Loss of wages, $1,800. You say you loss of wages for what, Ms.
Because they took me to court for this frivolous.
Which frivolous lawsuit?
This one that we have here. This one here where it all started lawsuit, where they could have returned it, you know, and the thing would have been gone away. This walking down over typewriter, calling me all these MF. You know, I don't have to take the driveway.
Who's
you know,
they?
Her, not they.
Not
her.
trash.
Her specifically.
Okay.
Her specifically.
Who's they?
White trash.
And then
Wait a second. Miss Haskett, did you ever say those words? Just a second.
No, no, I didn't.
No. Well, you were just a second. You were going to say to me, no, said them in front of my daughter. That's what you were going to say, right?
Right. But they got,
Oh, I never said.
white trash. That's what she called me, white trash. My kid heard it too.
that's not.
Oh, they
just a
called
second.
my kid.
That's not my
She can't even
style.
play outside because of you guys. Do
I
is pick
wouldn't
up because you go out and you call
Can
me
you
both
ask
your
me,
names.
Miss Haskett? I want you to answer a question, madam. Why didn't you return the typewriter? Question for me. No!
Not you. Because we paid her $20 to do in January of the year before.
Just a second. You paid her
To bankruptcy.
in January of 1997.
Yes, we did.
Hey! $20. You paid her $20 in January of 1997 to do a bankruptcy for you. Slowly. Of 19. And then what happened?
She never did it.
So, she never did the bankruptcy for you for $20. Oh. Hey!
I'm sorry.
I want you to be quiet.
I'm quiet.
So you borrowed her typewriter. You did.
Yes, ma'am.
And I'm still waiting for you to tell me why you didn't return the typewriter.
Because she never finished the bankruptcy.
So you decided to keep her typewriter. And that's what all this trouble started over. Decided was you two people
That's right.
were dumb. Because if this lady was supposed to do something for you and you paid her $20 and she didn't do it, you had several choices. You could have either written it off, $20 in her a letter, and you could have said, I want my $20 back.
did.
You could have written, and if she didn't give it to you, you could have sued her. But what you chose to do is a very expensive machine, keep it, according to your wife, sir, unless you're calling your wife a liar.
No, but
You
ma'am,
calling your wife a liar?
No, I'm not.
Well, that's what she
I'd
says. She
just like to
says she
finish
says
my
she kept
sentence.
wife a liar. What?
I'd like to finish what I was going to say.
Go ahead.
This $150 to her. She kept outside in the yard.
In the rain.
It was an extra. It was rusty. It never typewriters. I borrowed it.
It didn't even
What
work.
does that have to do with you?
Why don't you bring
What
it
you
back?
say?
Oh, I'm sorry.
What does that have to do with you? Whether she keeps it outside, whether she keeps it hanging from her, she wants to wear it as a lorgnette around her neck. It's her typewriter. She can do whatever she wants with a tree. You went over and borrowed it.
Bingo.
With it. Don't irritate.
I'm sorry.
Judge Judy continued. Moment.
You cannot prove without a voice expert.
In a
I'm
moment.
certainly not
I'll
a
gladly
voice
bring my
expert.
phone bill, and that'll prove it too.
Do I look like I need help from you?
Real cases, real people. Judge Judy. Jeff and Lori Haskett say their neighbor, Carol Woolfolk, slandered them. Carol says they harassed her.
It was very, very wrong of you to write this letter. Because it's not right to divulge things that have been told you in some sort of a confidence. Whether
It wasn't
was
a confidence.
Sure it was. You just
No, they
told,
knew.
No, that's sort of a, hey, I'm really smart.
Okay.
All right? You just told me
Everybody knows.
minutes ago, and my memory is totally intact, that you found out certain of this information when you were
eviction.
5-minute bankruptcy. So that was told to you in what we call a fiduciary relationship, which means you were preparing papers for them and you found out certain information, which means
something?
nothing. You have to acknowledge that it was the wrong thing to do to put that thing
Can I say,
in this letter.
when you're angry, maybe sometimes you do wrong things.
That's
Okay.
right. So thing,
Okay?
do.
Yeah. Right.
That's what the officer told her to do. She
Well,
called
he
Gardena.
didn't. Yeah, he didn't.
You were
come
angry.
specifically to do that.
of course you did. Why don't you
Okay.
just sit down?
But he did tell
Hey,
me to write the letter.
Hey, why don't you just
Didn't tell me specifically. But he did tell me to write the letter to stop the intimidation and harassment.
Listen,
He suggested.
I sit down. There's nothing wrong with
Yeah,
writing the
exactly.
letter. The problem was the other things that you put in the letter. That
Yeah,
you,
you know, you're angry. You're angry.
That's
You've been
absolutely-
wrong.
Me of doing
You know,
criminal activities,
people.
like selling food stamps.
hey,
She bought them.
listen,
You're a liar.
listen to me. Listen to me. You don't come into court, sir, with clean hands. Neither you or your wife. You know what that means? It means that you started this problem. She reacted to it, but you started it. And you started this because you did the wrong thing. It's because now you say that you received death threats.
Yep.
And you wanted me to hear you have written something on that tape recorder.
Carol,
I assume.
I've read the you wrote me up.
In a letter.
You are not going to get enough until we cut through that brilliant. Carol, watch your back.
Does that sound like my voice?
We didn't do it. Prove it. Go
Let's
to the phone
tape my
company, prove
voice
it.
on there right now
I
and
swear on
see
the
what
Holy
it
Bible, I
sounds
didn't do
like.
it. We are not that dumb. We took it to court.
I wrote the letter in November. This recording was made January the 15th,
Doesn't matter.
which means everyone in the park had a copy of that letter and had gone on. Everyone off the typewriter. Actually, Your Honor, I forgot about it. They could have kept it. I had another, like what I was using, Life Goes On.
Miss Woolfolk,
The one that
I am presented with a really serious problem in this case. Each of you is suing the other for $5,000. This problem. You cannot prove without a voice expert, because I'm certainly not
I'll
a
gladly
voice
bring,
expert.
and that'll prove it too.
you could have called for
Watch
more.
just a second. Do I look like I need help from you?
Sorry.
You cannot prove without a voice expert
That's true.
that this recording, as disgusting as it is, without a voice aid by anybody standing on that side of the table,
I cannot prove that. You're
right?
right. Yeah.
Was made. So what I have here is a situation where these people started a problem. They started a problem by taking your property and not returning it. Clearly wrong. I absolutely believe, because she says it, that she called you names. Not, she says, in front of her daughter. So that makes it okay.
Oh,
Hey,
that's not true. I'm sorry.
Could you speak, please?
just
That
a
is
second.
not true.
Is it okay?
Kara,
That is not true.
Just a second.
That is not true.
You're not even listening.
I.
is that true?
It's not
What
true.
What's, you mean,
That is not.
what I don't?
That-
I told you to sit down.
Yeah, well, I'm just-
I told you to
that's not true.
sit down.
not true.
Understand
That's
what I
not
said? Because
true.
this lady is not wrapped too tight
Yeah.
because she doesn't understand
Yeah,
what
I'm
I
not
said.
wrapped.
Do you want
That's not true.
Put her out.
Ma'am, step back. No, this one.
Too tight. I don't care.
Way.
Judge Judy continues in a moment.
Now, Mr. and Mrs. Haskett, you want $5,000?
Yes, ma'am.
You get $5. That's what you're going to get. You started this problem, and that's what you're going to get. $5, which, madam, you are going to have to pay them. Understand? $5.
So I get harassed, and I get
Just a
nothing.
second. Just a second. Now, you have a counterclaim,
That's right.
and she has acknowledged that she called you names which are terrible.
Made life uncomfortable.
She made life
Not
uncomfortable.
as uncomfortable as you're making it for my daughter.
And
Kimberly.
you have a legitimate complaint against them. So I am awarding you on your counterclaim $5. So I understand. You people had better stop torturing each other. You understand the wrong thing? She did the wrong thing by circulating those things in that letter against you. She did the wrong thing. She acknowledges she did the wrong thing.
Yeah,
She says she was angry.
Yeah.
She was angry because of the way you were treating her. And you were treating her, she was angry. Miserable way, considering the fact that you started all the trouble over this stupid machine.
Don't work.
See, it don't work.
Stupid machine for $5 against the other. Thank you very much. This case is over.
Parties are excused. You
Have a judge.
Yeah, that's fine.
yeah, out the back door to your right.
Judge Judy
You may
continues.
step out.
And on the next Judge Judy,
Yeah.
in a moment.
This is illegal to send a letter talk to somebody.
Can't wait to start tax return.
Freedom of the press.
Freedom of the press? If you can prove it.
Oh, that's your thing.
Yeah.
You always defraud people, say.
Don't you
You know,
not-
you don't ever want your stuff out.
Prove it, honey.
See?
Prove it.
Don't you?
You always
I was in the.
Prove it.
DUI.
I asked everyone in the house did they know where my earrings was at. Everyone said no.
Missing jewelry, missing boots, and an unpaid babysitting bill. Cousins at war.
So you stole her earrings?
No, I did not steal them.
Oh, I'm telling you that you did.
They're lost. I don't know where they at. I didn't wear them.
You're a liar. And your mother is encouraging.
Sharon Mall Scott claims her husband's cousins, 16-year-old Tierra Walker and 14-year-old Tanisha Walker, stole her boots and jewelry. Tanisha Walker is countersuing for not paying her for babysitting.
Order. All rise. Quiet in the courtroom, please. All rise.
Your Honor, this is case number 431 on the calendar in the matter of Scott versus Walker. Parties have been sworn in, Judge. You may be seated. Ma'am, have a seat.
Well, you folks are cousins, but clearly don't like each other. Is that a fair statement?
I never said I didn't like them.
That's
Yeah.
a fair statement, Your Honor.
I never said I didn't like them.
Well,
I just have a disagreement.
cousins usually don't resolve their disagreement in court. Mr. Scott, are you part of this lawsuit, sir?
I believe so.
None of this property that was taken is yours. Is that right?
No, the boots and the earrings are not mine.
Sit down.
But I helped contribute.
Sit down. Miss Scott, you allege, I assume that this young lady stole certain things from you.
Yes, she did.
What do you say she stole from you?
She stole my figure-8 earrings that I had purchased in November. They were diamond-cut figure-8 earrings. And she stole my Timberland boots.
Okay. And you claim, how old are you?
I'm 16.
Your name is?
Tierra Walker.
Tierra?
Yes.
And you say, well, I have the earrings, right?
No, I don't have the earrings.
Who has the earrings?
My little sister, Tanisha Walker.
Where is she? That Tanisha has the earrings,
Yes.
and she'll give them back when she pays $450 for babysitting, right?
Yes.
And as far as the boots are concerned, you have her boots?
Yes. Yes, I do.
And the reason I took her boots is because she borrowed my sneakers and didn't return them.
Yes. My mother and my sister had to go up there and get them.
But you still have the boots.
Yes, I do.
So why don't you tell me how this family tragedy began?
Well, it all started in November when me and my husband and my 2 children went over Tracy's house for a couple of weeks to stay until my house came through. When I went over there, I took my jewelry off and I set it on the entertainment system. 2 days later, when I went to put my earrings back on, they were gone. I asked everyone in the house, did they know where my earrings was at? Everyone said no, including my husband. I called Tracy while she was at work, and she said she didn't know anything about them. I was hoping maybe she put them on to go to work in or something. So that was the end of my earrings. I moved out on December 2nd. I got my house. Maybe 2 weeks later, I moved away, and about a week later, Tracy called me saying Tiara ran away again. Tiara's a runaway. She ran away again, and did I see her, or, you know, did I know where she would be at or anything like that? And I told her no. And as the conversation grew on, she said, and she ran away in your Timberlands, my boots. And I was like, my boots? So, you know, I said, well, you're going to have to get me another pair. She said, no, she's going to have to get you another pair. Tiara's 16 years old. She's a minor.
No.
Shh.
I'm sorry.
Shh. Tiara is 16 years old. She's a minor. I don't expect anything to come from her. I expect it to come from her parents. Her husband, Tyrone Walker, said the same thing to me. He told me he would make sure that, you know, I would get my belongings back.
Okay. So it's those 2 things. It's your boots and your earrings.
Yes.
Step up here. How did you come in possession of her earrings?
Okay. Well, she left them, so I picked them up.
She left them where?
At my house. So I picked them up, and I said, well, Sharon, you know, kept telling me that she was going to pay me for babysitting her baby for her. Okay, I babysat, and I babysat. She never gave me no money for babysitting except for 2 times. So I just said I'll take her earrings just in place, you know, just in place of the money. But I said I will return them when she gave me my money.
That's a lie.
Just a second. Who did you say that to? To you? To yourself?
I told my mom, and I told her boyfriend.
You picked up the earrings. What did you do with them when you picked them up?
Nothing. I put them up.
Put them up where?
On top of the refrigerator.
What'd you put them up on top of the refrigerator for?
Because she wasn't getting them back.
She wasn't getting them back?
Yes.
So you stole her earrings?
No, I did not steal them.
Oh, I'm telling you that you did. I'm telling you that you stole her earrings. If she owed you for babysitting, you have the perfect right to say, you didn't pay me the last time for babysitting, and I'm not going to babysit for you again until you pay me. You don't wait until, according to you, she owes you $450 for babysitting.
I said $330. I didn't say $450.
Well, I have a countersuit here for $450.
Well, they must have.
Shh. And that's made up nonsense and say, well, that's the reason that I took the earrings.
Excuse me, can I say something?
Yeah.
Sharon had told my daughter on several occasions that she would pay her money for watching her daughter. Okay, yes. Tanisha agreed to it. Sharon knows that my daughter...
No, don't talk to each other.
Twice. She paid my daughter 2 times out of maybe... It was several times my daughter had
Just a
watched
second.
her daughter.
Listen to me. How many is several?
She had written it down. Okay, a total that she has gotten down so far was 9.
Okay.
2 different occasions Sharon paid her for watching her. The rest she did not. Only because my daughter being Tanisha, you know, nice and whatnot, she watched her child. She watched her child when her child was...
Is your last name Walker?
Yes, my last name is Walker.
And this is your daughter?
Yes. And she
Are you telling me, madam, that you are condoning, as a parent who's trying to set an example for their children, your daughter taking property that didn't belong to her, hiding it in your house by putting it on top of the refrigerator?
No, I did not.
Fine. Good.
Judge Judy continues in a moment.
I don't want to hear from you. You're a liar.
Prove it.
You are a liar.
Well,
liar. You're a liar.
I didn't.
And your mother is encouraging you.
And later today...
You mean the child was removed from your custody? The child was removed?
It was not removed. She abandoned him. She asked her brother to watch our son, and she left him.
Real cases, real people. Judge Judy. Sharon Mall Scott is suing Tiara and Tanisha Walker for stealing her boots and jewelry.
Let us say that I believe everything that you said so far, that your daughter babysat for her 9 times and was paid twice. Right? Is that what you're saying?
Yes.
All right. And how much were you paid on the 2 times that you babysat?
Well, she only paid me $20.
$20 one time.
That was for one day.
Yes.
She paid me $10 the other time.
At the time that she paid you the $20, how long did you babysit for her?
Well, Marvin brought the baby over about 10, and she came pick him up like around 7. 10 in the morning, and she came and picked baby up at 7 in the evening. Mm-hmm.
And you babysat for $20 for that period of time.
Yes.
Now, the next time you said she gave you $10.
Mm-hmm.
So how many hours did you babysit at that time?
Well, that time, I said she paid me about $10 for 3 hours because I told her I would watch the baby while she go out and dance.
So let's say it's about $3 an hour. Now, the other 7 times that you say you babysat for her, tell me about them.
Okay, I babysit the baby 3 times. That was for a 1 week period.
What do you mean a 1 week period?
Okay, I babysit her for 1 week. 1 week.
What's a week? You mean for 7 days you baby?
7 days.
7 days?
Yes. I babysat her baby.
From what time to what time?
They brought the baby over on Friday. Came back the next Sunday.
You mean for a whole week they left the baby with who?
Yes, they did. Me.
With who?
Me.
Tell me about that.
That's a lie, Your Honor.
No, it's not.
My daughter right now was only 7 months. She hasn't babysat my daughter since, I say about 3-4 months now.
Did you ever leave the baby?
No, I did not.
You didn't let me finish the question. How could you answer the question if you didn't let me finish?
Well, I'm just saying, I did not. I never left my baby with a minor for a week.
Well, that's what I'm asking you.
Never.
Did you ever leave the baby with her for a week?
No, never.
Did you ever leave the baby for a couple of days?
No, never. I will always, if she watched my daughter, it would be a couple hours, time period of a couple hours, and I would go pick her up, or my husband would go pick her up.
Let me explain something to you. Tanisha?
Yes.
Your counter suit is for $450 for babysitting. That's what you filed.
I filed
According to you,
$330.
let's make it $330 then. So that's even less. According to you, at $3 an hour, which is what you would say you were paid the last time, you would have had to have babysat for her 110 hours. No way. Now listen to me, Miss Walker. I would suggest that you try to tell your daughters that if they have a dispute with someone, they do not resolve that dispute by self-help, which is what your daughter did. Your daughter took property, she stole it. She stole it, it didn't belong to her. She had no right to take it. Absolutely no right to take it. If she had a dispute with regard to babysitting, she always has a legal recourse.
I understand what you're saying.
Good.
And that's what I told my daughter. But she felt strongly about what she did and the reason for her doing that.
Did you explain to her strongly
You
as
know,
her mother
but-
that still wasn't appropriate?
And it wasn't appropriate of her not to pay my daughter either.
Just a second. Miss Walker?
Yes.
You got a problem, madam. Your problem is if your daughter believes strongly in the virtue of her position, you have to explain to her as her mother that whether she believes strongly in it or not, she's wrong. You don't take property that doesn't belong to you because she may have a dispute with your daughter. Put your hand down. I'm not finished with you yet because we're going to get back to the boots.
Your Honor. Also, Tanisha had 2 rings that belonged to me.
Just a second.
2 rings, a pair of earrings in my boots.
And what about, well, you're absolutely right. You have 2 rings?
Yes.
Who has rings?
I have them.
You have the rings too?
Well, she let me hold them.
And she never returned them.
Well,
because what you did to my sneakers. That's why I didn't return them.
You also have her rings because of something she did to your sneakers?
Well, she let me hold them. She never asked me back. She never asked me.
Where are they?
I don't know. They lost.
Now, the rings I was willing to pay for.
Hey! What do you mean they're lost?
They're lost. I don't know where they at. I didn't wear them personally.
Now you. Why did you take her boots?
I didn't take her boots.
You were wearing her boots. It says here that you were wearing her
She
boots.
left them over my house, Your Honor. So I wore them when I left. And she never did ask me for them back. You never asked me for them back.
Just a second. Did you get back a pair of sneakers?
I had to
I
go
had to
get
throw them
them.
in the
Just a
trash.
minute. Did you get them
Yes,
back?
I did.
Did you return the rings?
The
Yes
rings
or no?
Tanisha lost.
No,
I was going
just
to
a
give
second.
her.
I
No,
want you
I
to answer
didn't.
my question. Did you return the rings?
No, I didn't.
Did you return the boots?
No.
Did you return the earrings?
No.
Good. How much did you pay for the earrings, the rings, and the boots?
The earrings was $350. My 2 rings was $100 altogether, and my boots was $129.
Okay. You have receipts?
Yes, I do.
I don't want to hear from you. You're a liar. You are a liar. Among other things, you're lying
the
when you
receipt
said
for
to
my
me
jewelry.
that you lost the rings.
Well, I
Yeah,
didn't
no,
lose the rings.
liar. You're a liar.
I didn't.
And your mother is encouraging you.
Judge Judy continues in a moment.
Their mother is right now sowing the seeds of disaster with these 2 girls.
And later today,
What about the women who abuse guys financially, emotionally, every way they can, you know? And this snake right here has done that to me.
real cases, real people. Judge Judy. Sharon Mall Scott is suing Tiara and Tanisha Walker for stealing her boots and jewelry.
So your entire suit is for $579. Is
Yes,
that correct? You don't straighten your girl. I'm just telling you this. You don't straighten your girls out fast. You're going to find yourself standing in court with them a lot.
Exactly.
A lot.
Mind your business.
Hey,
See?
shh, don't start up with them. Her mother, their mother, is right now sowing the seeds of disaster with these 2 girls. She's already getting payback time, big time, with this one who ran away.
7 times.
This one isn't far behind. Judgment is for the plaintiff in the amount of $579. Your counterclaim is dismissed because I don't believe a word you say.
Parties are excused. You may step out.
You better not go home.
Out the bed.
And now the next case.
Parties on Malden versus Branch. Step forward, please.
37-year-old heavy equipment operator Ray Malden is suing his estranged wife, grocery clerk Catherine Branch, for stealing money orders. Catherine is countersuing Ray for taking all of their possessions.
This is not a very difficult case. I just have a few questions. Are you 2 people still married to each other?
Yes, we are. I filed papers for a divorce, and it's in default right now.
We both filed papers for divorce, and we're
Well,
both
it's clear.
we're legally separated.
When did you separate?
First time, second time.
Second time.
Probably in October of '94.
Miss Branch, stop
Yes.
playing with your papers.
Oh, I'm sorry.
When did you separate for the last time?
For the last time, it was in 1997, I believe. It was in January of '97. I
Well,
filed papers for legal
I didn't ask you
separation.
when you filed. When did you last live together?
I have the date in my papers. It
You
was
don't
in
remember the
January.
year?
It was in January of '97, I believe.
He says 94. Did you live with him, according to you, in 97?
No.
Did you live with him?
Yes,
Madam.
I did.
Where?
No, I didn't. Excuse me, ma'am. I'm sorry. It was in '95. I apologize.
94, 95. All right. So now we
It's
understand.
in my papers.
You don't have to look. Shouldn't have to look in your papers to know when the last time you lived with your husband was. In what year? 94, 95, 97. That's a wide spread. So you've been separated for
apologize.
several years. Correct?
Several years. Yeah.
He says that when he was giving you a lift somewhere, he had just purchased 2 money orders, the amount of $350 apiece,
370, ma'am.
$370, and that you stole them from his car.
Yes, I did. I took the money orders.
Well, you had no right to do that.
No, I didn't.
So then you have to give him back the money. Good. And this is a very easy case.
I have a reason why I took the money orders, ma'am, Your Honor.
There's no reason for taking money. I mean, I read this, and it's
yeah.
you said he
Yeah.
left you alone with a baby, and he
Yeah,
didn't
he
provide
did.
support, and he didn't do all these
Yeah.
things. He didn't do all. That's what
Yeah.
courts are for. That's why you take him to court. You take him to court for child support. You make sure that he pays it because that's the child's right to be supported.
Yes, Your Honor.
But you don't resort to self-help.
Yeah.
That's stealing.
And
How
I
many
had
children do you
no-
have?
I have 2 beautiful boys by him.
Okay. You pay child support, sir?
Yes, ma'am, I do.
How much do you pay? You should know that as quickly as you know the date that you separated.
$196.85 a week. That's for 1 child. I just was ordered my first child
that is not
back
true.
into the home. The guardianship that was over my child has been terminated. It was terminated yesterday.
What do you mean the guardianship?
There was, because our marriage was so bad, ma'am, there was a guardianship placed over my first child.
You mean the child was removed from your custody?
The child was removed
He was not removed. She abandoned him.
Just a second.
She abandoned him.
Whatever it was, the child was removed from your custody.
Yeah.
And the child by the state?
Yeah.
No.
By the courts.
Not by the courts. She abandoned him. She asked her brother to watch our son, and she left him. And I could not get custody of him because of some technology, whatever it was, some things I couldn't do. Anyway, we went to court yesterday, and she did get custody of him. But there has not been any order made yet. And I am paying child support for my second son.
According to you, he's paid.
He's paying for alimony and for the child support for our second son. And on
well, the first son wasn't with you. The first son was in placement.
No, I've been battling for my first son for the last 5 years.
I don't care whether you've been battling. You didn't have that child in your custody.
Yes, ma'am.
Oh.
So he's been paying alimony and he's been paying support for the second child.
Yes, he has.
Fine. You had absolutely no right to take this $370 in checks, and that's what it totaled, correct, sir?
$370, yes, ma'am.
$370.
Judge Judy continues in a moment.
I know her past life, her life now, and like see, she ain't changed nothing. Ain't nothing changed about her except this fake facade she has everyone to believe.
Now, you're countersuing for $2,500 for some items that were purchased during the marriage that he now has. What is that nonsense?
That's all the items like the washers and dryers, the
That'll be handled.
couch.
Listen to me. That'll all be handled in your judgment of divorce.
That's what I thought.
That's what
and
it
that's what I
will be.
thought, that the $370 would be handled in that area.
No,
also.
that you stole. Judgment in this case is for the plaintiff in the amount of $370. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy.
She's the biggest crook that I've met, that I've been involved with, you know, and it bothers me even to stand here right next to her. I know her past life, her life now, and like see, she ain't changed nothing. Ain't nothing changed about her except this fake facade she has everyone to believe.
The courts in Stanislaus County took my son from me because of the way I used to live my lifestyle, but since I have repented and I do go to church and I'm not perfect,
She abandoned
but you know
him.
what, the courts ordered my son to come back home.
That was offered the use of the credit card to pay for my car repairs.
So, sure, being dead, you accepted.
They were in love for 4 years, but now it's over.
Chivalry
Wants him to pay what he owes.
So that what you're expecting me to believe, sir,
She
all up to date on the Visa and all up to date on the MasterCard.
That's what I want you to
do. You were all...
Girl student Wendy Hickman wants her ex-boyfriend, 3-year-old Mark Fraley, to...
Correct.
Together, what'd you give me your credit cards for?
Well, we dated for almost a little over 4.5 years, and he did not have a credit card. So on occasions when he needed and
have a credit card.
I didn't want a credit card. I didn't need one.
Why didn't you? You had hers.
Didn't have hers. She had hers.
Did you hers?
I didn't use hers without her being there. She was
I
there.
didn't mean that you used it. Would you use her knowledge and permission? Did you use her credit card?
We used her credit cards.
Without her. Ever use her credit card for things that was strictly for you?
Yes.
Did you?
Well, we some car repairs.
Like what? And that was for your car?
Right.
So you did need a credit card for your car repairs?
At the situation, I didn't really need a credit card. I could have paid for it myself cash, but it was, well, the use of the credit card to pay for my car repairs.
So,
offered.
Being dead, you accepted.
Well, that's a different type of, I wouldn't say that. I'd say that the money was supposed to be used towards a vacation that I was going to be going on with the plaintiff. Money was...
How much did you charge on her credit card for your car repair?
About $850.
How much did you pay
that
for
would be
it?
actually incorrect.
Okay. How much did he pay?
How much?
For the car repairs.
How
much
well,
did he charge on your credit card for the car repairs?
For the car repairs, how much did he pay? $100.
And how much of that did you pay?
I'd say I paid probably all.
About 14.
Show me.
I can't show you. I can show you what I did pay, though. I can show you what I've all of it. There's basically, the plaintiff had my checkbook. She wrote checks for me, paid over the year. She just said, okay, well, this is what we're paying, this is what I'm paying, and I just to pay.
Let me just see, sir, your checks for June.
There you go. Continue.
Okay. June.
And this is the statement, you know, paid 908. Your Honor, basically through our relationship, I everything.
What are you showing me here?
Those are copies. I couldn't get canceled checks in time. Bank sent me their paid for statements. So I'm showing you a bank statement, and as well as a wrong check ledger, which shows that I paid $908.
I'm not
copy of my
check ledger, sir. Okay. Now, what about Visa? Interested in you? See the charges on Visa for his car.
They're right here. And I have payments. I mean, this is from October of 95 until July of 96. He was a credit in the red. Those are his payments. So I gave him full credit for everything that he and there's or paid. I just want what he owes me plus the interest. It's accrued since. Did. I agree that it's pretty lame that he charged.
Very lame. Very lame. And nobody's
It wasn't a matter of me charging on her card. It's like, I want this, I'm charging on
Lame.
credit card. And you're paying for it.
Okay. You owe her some money for the car.
The credit card?
But these other charges, are his that he made.
Repairs.
Did she?
I would not have said that, yes, go ahead and use my credit card and I'll pay for this.
On the Your Honor's bill that she breaks down for June, does she break down what would be my charges and her charges?
Mm-hmm.
American Express, wouldn't she want to do that throughout our relationship on the American Express bill that I paid?
Why?
We always do.
Just a second.
Okay, what? Yeah.
She did.
No.
But maybe she did it in this month because, you don't break up. Why? Sir, things start going bad in the months before that.
A couple years before that.
Right? Well, then overnight a relationship longer than you should have. So. People have to be smart, and you stayed with men and women. You don't commingle these assets and expect somebody else. Court, both waste their time going through a 5-year relationship, separates to Kleenex and who bought toilet paper and whether it was his toilet paper or your Kleenex. That's just not going to happen. Who bought? You look like an intelligent young woman. You don't let somebody else use happen, Matt.
I took his word. I thought
dating
he would pay.
for 4.5 years isn't being married.
I realize.
Your credit card. Why after 4.5 years weren't you married?
Realize that?
Huh?
Exactly.
Exactly.
Exactly. Mr. Fraley.
Yes, Your Honor.
I'm going to try to keep it as simple as possible. So, up in June.
In July.
In July of 1996. So you broke?
Yes.
What I would like you to do is, assuming that this was valid, correct? It is not. But assuming it was, I just want you to take out the sheet evidence of payments that you made on the Visa and MasterCard on or after of 1996.
None.
All right. So that what you're in July to believe, sir,
Said everything was paid prior.
is that you were all up to date, expecting me on the Visa and all up to date on the MasterCard. If that's what you want me to believe.
That's what I want you to believe.
No way. No way.
Your Honor, breakups are
No.
I mean, through our 4-year relationship, I paid for, and I think the plaintiff will agree that I never good financially took care of her when we went out.
I would disagree.
Well, she can disagree, basically, but since I was making more money than her, I took more of the financial burden. And that was understood.
Except, sir, that when you broke up, there was an $8,000 bill.
And, okay.
That was a debt. That was a debt that...
Wasn't my $8,000.
...due on Visa. Well, but a good portion, at least a portion of it, sir, was yours. A portion of it here has repairs which were extensive, and you were making minimum payments due on the account. Your car, and you break up and you decide, well, I don't have to make minimum payments anymore on the account. I'm not going to make another payment. So that, which is exactly what you did, because there is nothing in your ledger to suggest that after you kissed each other on the account, you made one additional payment, which is really sort of outrageous.
I never
the goodbye.
Money I paid all along now.
Well, that's your problem.
You know how much...
Judy continues in a moment.
I do believe him when he says that he paid for certain things.
Judge Judy.
Otherwise, you would have been a jerk to stay with him since he was earning 4 times as much as you were, right? In cash. Good.
And later today.
You don't, sir. Ask
your
friend to step up to the mic so that you can do fisticuffs with him. It's like a boy. Dumber. Dumb and...
Real cases, real people. Judge Judy. Wendy Hickman wants her ex-boyfriend, Mark Fraley, to pay her back for credit while they were together.
She's suing you for half of this $8,000, and
For the use of
half of it is yours. But I certainly think that your car repairs are yours. I don't even know. There are a lot of other charges here that are substantial, big ones. Did you go to Homer Lodge and Tahoma, California together? You went together and you charged that on the credit card, $232, right?
Yeah, we did. I paid it.
You paid.
Okay, she would charge something, I'd bring cash, and I'd pay cash. She charged.
Who would you pay cash to?
I'd pay cash for everything else. It wasn't a matter of, okay, let's throw everything on the credit card. I'm penniless.
Oh, just a second. I understand. You went to this lodge, and how long?
I wasn't walking.
Lodge.
It was,
nights.
Yeah, 2 nights.
2 nights. The truth is, I see what you mean. The lodge is paid for on here, but you also had to eat. People. I assume you didn't go skiing or whatever.
I have my own money. It's not like tipness.
No, but he was with you, so I assume he paid.
No, not necessarily. I went.
You know something? Truth of the matter is, I don't necessarily believe you. I think that you put some things on your credit card, some things that are clearly his bills. But according to this, you did go on certain things you put on the credit card. But if you look down the same dates, they're on vacation dates there, like for restaurants, going out to eat, so that he probably paid some of no cash, and you put some of the stuff on your credit card. And whether that balanced itself out of the meals and 50 is anybody's guess. You still had an $8,000 nut. 50. Nobody is going to figure this out. Certainly, I am not going to award you $4,000. Believe him when he says that he paid for certain things in cash. Otherwise, you would have been a jerk to stay with him since he was, because I do times as much as you were, right?
Yes.
Good. So I don't think you look like a jerk. So I'm awarding you $4,000. Consider yourself lucky. That's all.
Parties are excused. You may step out.
$1,000.
I was helping him out. He didn't have the money. He didn't have the credit to get a credit. So I allowed him to use it.
I was making 4 times as much, so how come I didn't have the money?
Credit card? I don't know. Good question. You just don't say on good faith that I'm going to pay you back. You do it. That's just wrong.
Oh, but it's okay to take and take and take, and then that's all right.
And you don't twist a view of our relationship.
And now the next case.
He's on Welton versus Lunaria Restaurant. Step forward, please. All parties.
Harmonica virtuoso Danny Welton is suing restaurant owner Bernard Jacques for not paying for his performance. Bernard claims the harmonica player's here caused customers to leave.
Mr. Welton?
Yes, ma'am.
Rude behavior.
Play the harmonica.
Yes, ma'am, I do.
You do that for a living?
Yes, ma'am, I do.
Your complaint, you had a contract with the defendant to play at his restaurant.
We had a verbal agreement.
According to...
Because I...
Am I speaking? You had a contract with the defendant to play at his restaurant.
Yes, ma'am.
You played there.
Yes, ma'am.
He didn't...
That's right.
That's what this case is about.
That's right.
He's got a defense, pay you. You didn't play and you cost him money. So, and he said it was an oral one. How much were you supposed to be paid?
Initially, my band was...
You agreed?
$350 for the band. I was supposed to get 80% of all covers.
Mm-hmm.
And also, I was supposed to be reimbursed 5% I took out in the Hollywood Reporter.
Mm-hmm.
I got burst for that. Also, something very important and very dear to me, he was supposed to feed my... and gave them nothing. Nothing.
No, that's not true. Even according to you, he gave him something.
Band, and
he gave him stale pizza.
Yeah, well, stale pizza. That was nothing.
According to you, they ate it.
They spit it... Well, actually, they spit it out.
Mr. Welton, let me explain something to you, sir. We are not going to eat and play with each other.
Yes, ma'am.
This was for this performance?
A one-night engagement.
And how many one night are you supposed to do in that one night?
2.
And did you do the first one? Shows?
Yes, ma'am, and it was packed.
Packed. And then there was a problem, to you, sir, with the second performance. So why don't you tell me? According...
There was a drunken lady in the audience who started to heckle me.
Mm-hmm. What did you say about it?
You know, I'll be honest with you, Judge. I do not recall exactly. If I were to say, it would be wrong.
Okay, so you started shouting things.
That's right.
How long have you been
exactly,
a performer, sir?
All my life. Since
So
I'm 3 years old.
I assume that performers do this sort of thing.
Yes, ma'am.
Okay, so
And
what
I
did
know
you
how
do?
to handle them.
You've had people do.
I start throwing lines back at her.
So what'd you...
To keep her quiet, hoping that would squelch. And her boyfriend got mad at me and threatened to charge the problem. And I said, come on. You know, he was going to the microphone. I was, you know, I wasn't going to back off. I've never taken a come up there backwards in my entire life.
So what happened?
Bernard, half a step show at that point.
Bernard, you closed the show down when that's...
We closed the
We were forced to.
Shh. You closed down the show. Is that right?
Your
What's
Honor.
happening? Very smart. Exactly the right thing to do. So what happened next?
Well, weren't that many people there because it's kind of an early type. Actually, there weren't. You get your big crowd the first show, and sometimes I noticed that there's supper club second show. The first 2 times I played there, there wasn't even a second show.
Oh, you played there before?
Never even before.
Did he pay you?
Yes, the first time everything went twice. The second time, he broke his agreement with me. He did not pay me the cover charges. Well.
But you went back for a third time.
Well, I gave him another chance. You know, I'm a sucker that way.
A sucker who never backs down.
That's right. I'm kind of an all-day, not back down sucker.
Judge Judy continues in a moment.
Mr. Welton marched bars screaming profanity that he was not going on until he was introduced because he's very around the bar and he doesn't do things this way. Big star.
Real cases, real people. Judge Judy. Harmonica virtuoso Danny Welton is suing restaurant owner Bernard for not paying for his performance.
You didn't pay him.
Correct.
You didn't pay him anything.
Not even a...
Correct? No, he gave you stale pizza, Mr. Welton.
A biscuit.
Mr. Jacoby, tell me why you didn't pay him at all.
The agreement was for 3 shows, like every entertainer. Once we had to reimburse the people that were there, and we had to turn away. Only did one.
People for the second show.
For the second show.
For the cover charge.
That's correct.
Reimburse the people.
And we had to turn away all the people that were coming for the second and third show. We had to close the bar. We lost bar revenue, and we lost show revenue. In addition to that, his manager, that's his present, had a tab for $80. Here it is, and he signed it saying he was going to pay it. The following day, he never did come and pay it.
Well, that's not his problem. He is not his manager's key.
Presenting Mr. Weldon. And in leaving the property, we have neighbors here. He assaulted our Maître D'. We have the copy of the security witness police report here. And it doesn't
Who's the Maître D'?
And
what is your name?
Gerard Buck.
You have a complaint filed against this. Step up, sir. This gentleman for assault?
I did file a complaint, yes.
How did he assault you?
On the way,
against this?
He elbowed me very hard and kicked me.
That is not true.
I then called the way out. Security made a report and then filed a complaint with the police. Made a report. We called the department.
Were you escorting him off forcefully?
No, the police. You can't go near him. I mean, he's out of control. No,
Your Honor.
You are the manager?
Yes, I am, Your Honor.
You drink a lot.
Pardon? If I may.
What?
No, that wasn't just for me. That was for other people in the audience.
Well, you drink a lot. Buying.
That's correct, Your Honor.
So why didn't you pay the bill?
Because
but you
that he's not going to pay us. And I said, you can deduct it from what you owe us. Because he said...
Oh, was that what you said?
That's exactly what I said to him.
Oh, so you told him to deduct
$80 from the amount of money he
from
owed
the
us.
$300...
Well, we had the 88... Your Honor, if I may explain.
Sure.
It's a 20-year showroom with a large bar off to the right-hand side of the performance. A small and a large restaurant that opens up during the performances. Performers.
Just a second. What is your last name?
Edel, Your Honor. E-D-E-L-L.
Mr. Reed.
Your Honor.
Were you there when this incident occurred with this lady heckler?
Absolutely.
Edel. Well, didn't you tell Mr. Welton that he behaved totally inappropriately?
Absolutely. I don't believe he did behave inappropriately.
He did.
This man threatened him bodily.
No, he didn't threaten.
No, I don't.
Started
Oh, no, Your Honor.
Mr. Edel, just pay attention to me,
Surely.
sir. Him until he's not a comedian.
Yes, I am.
He's a You are?
He's a stand-up comedian, Your Honor. So a comedian.
Listen to me.
Yes, sir, ma'am.
When you're performing, you're in somebody else's house. You, sir, are in his house. You're in some...
Ma'am.
He has invited guests into his house.
Yes, ma'am. A couple of drunken ones.
That's possible. You weren't playing, sir, in a church. You were playing in a bar. And somebody was behaving badly.
Excuse me.
Don't restaurant. Hey, excuse me. I don't excuse you. Pay attention. Say, you don't have to be a genius to figure this out. You just have to use a little common sense. If somebody is drunk in the audience, then what you do is not to have that escalate into a dangerous situation. As you try for you, for the other patrons, for members of the band, dangerous. If a situation appears to be escalating, then you use good management, not that male macho testosterone that judged about so much lately. You walk off the stage, I've heard, and you approach the owner or the manager, and you say, lady out there heckling me, I just taken a quick break. See what you can do about this lady. There's this, I can't continue to perform. You don't, sir. Because her boyfriend to step up to the mic so that you can do fisticuffs with him.
No, he invited himself up to the mic.
I know you said, come on up here.
Well,
you know, it's like Dumb and Dumber.
Judge Judy continues in a moment.
You're supposed to be in charge. You're
Sober
supposed
as a
to
judge.
exercise good judgment. And good judgment is not closing down the show because you invite to come up to the stage somebody who is probably drunk because he's with a drunk somebody, according to you.
well, he charged the stage, so I said, come on, you know.
Lady, you know, Mr. Welton, you keep changing your story. I want to tell you something. You told me your story. You said, I don't from anything. He says, I'm going to come up there, and you said, come on. Dum-dum, back away. Your case is dismissed. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment. And on the next, Judy.
Excuse me. Versus Perry. Thank you. Quite welcome, Judge. Parties have been sworn in. You may be seated. Folks, have seats, please.
Ms. Lockett, according to what I read in your complaint, you and the defendant have a long relationship dating back about 5 years. You have a 2-year-old child together. It is your claim that in 1997 you made a loan to the defendant. Again, in 1999 you made a loan to the defendant. Now that you are no longer a couple, you want those loans paid back. He is counterclaiming. He says you vandalized his car, and years ago, 3 or 4 years ago, you were using his car and got parking tickets. He wants you to pay those 4-year-old parking tickets, right?
That's correct.
Have you nothing better to do with your time? Tell me about this first loan in 1997.
In 1997, Mr. Perry and I worked at a company together, and I quit before he was fired, and he was caught stealing money from the company, and they had made an arrangement for him to make payments, and I used to go with him every week to drop off the payments because he was not allowed to set foot on the premises anymore, and after a while he decided to stop making payments, and they demanded the money in full, and he asked me to loan him the money, and I did.
How much did you give him at that time?
$2,150.
Now, what arrangements were made to repay that money?
He was supposed to start making payments to me as soon as he got back to work, like within the next month or so.
Well, did he ever do that?
No, he never made any payments to me. He lost his job soon thereafter, and after that, he was fired from like 4 other positions, 2 for stealing apparel or money as well. And every time it was time for him to make a payment to me, there was always something else that he had to do with his money so that he could not pay me my money back.
So then you had a child with him?
We had a child together.
No, afterwards. After he lost all his jobs, you knew he caught stealing. Just listen to me. After you knew he got caught stealing, according to you, he promised to pay you back this money in a month, and he never did. So he didn't make payments in all of 1997. He didn't make payments in all of 1998. He lost all these jobs. That's why he didn't make payments. So then you decided to start a family together. Does that sound like very good judgment to you?
No, I was young, and I was in love. So no, it's not very good judgment, and I would be the first one to say that.
All right. When was the last time you asked him for this money?
The last time I asked him for the money, it was December of 2000. And we were on the phone talking, and I said, you know, it's entering another year. Do you think you could come up with some of my money? And he said, well, I don't plan on paying you anytime soon, and that the first time he would be able to make me a payment would be 2003 because he planned on giving me a lump sum of money. And that, okay.
Now, after 1997, and he didn't pay you back a penny, then, according to you, you lent him more money.
Yes.
When?
In 1999, he called me from jail. He had been arrested on a traffic violation of some sort. He said he had some of the money with him,
in jail, that he was going to be able to use some of that for bail money, and that as soon as he got out of jail, we were going to go to the bank. When I got to the jail, I bailed him out. His sister and I drove him to the bank. He made up some story about the police keeping his identification card, and he could not pay me the money back again. So after everything was over, he had it was a fine due for $300, and he refused to pay the fine. And he told me I should just go on and sign my bail money over too, and he would pay me back that at a later date. And I never signed.
So he had a fine.
A fine.
Of the same amount as your bail money, which is $300. So you just signed your bail money.
I didn't sign it over. I refused to sign it over. And after a while, they said if he didn't make payment, that it was going to be forfeit. So it was forfeit anyways. And he just never gave me the money back for that.
When you were arrested in 1999 on this traffic problem that you had, were you arrested in your car?
Yes.
What kind of a car were you arrested in?
It was not my car. It belonged to my sister.
Just a second. Was that my question?
You said what type of car? It was
Yeah, I didn't ask you whose car it was. I said, what type of car is
Make
it?
and model?
Yes.
89 Nissan Sentra, I believe.
The Toyota Camry. It was a Toyota Camry he was arrested in, a blue Toyota Camry.
Oh, yes, I remember it well. Do you currently own a car?
Yes, I do.
What kind of car do you own?
I own a black 1991 Eagle Premier.
How much did you pay for the car?
$2,500.
And what kind of work are you doing now, Mr. Perry?
I'm a market analyst.
You work for a company?
Yes,
How long have you been working for that company?
3 years.
Who has physical custody of your child?
Miss Lockett does.
Are you currently under a support order for your child?
Yes, I am.
Are you up to date in your support payments?
Oh, yes.
Is that correct?
No, he owes money on it still. He contacted me and told me they said they were going to garnish his income tax because he still owes back money on child support.
How much does he owe on his child support?
I don't know how much he owes on it. I don't know.
When did he start to make child support payments?
He started to make child support payments when my son was almost a year old, so he owed money from June. I didn't get my first payment until October of '99.
That's not correct, Your Honor. She's being dishonest at this point.
Okay, so there were a couple of months, but since October of 1999, he's been making the support payments.
Oh, it's garnished, so yes, I get it directly.
Oh, it is garnished,
yes,
right,
it
from
is
his
garnished
salary.
because he refused to pay
that's
it.
perfect. All right, Mr. Perry, let's start out with this $2150.
Okay.
What company were you working for at the time that Miss Lockett indicates that you had some difficulty?
I should say, Your Honor, that Miss Lockett is making up the bulk of her story.
All right, what company was he working for?
Bagel.
Bagel. Where are they located?
It's in Rochester, New York.
And what was he doing there?
It wasn't as high as a manager, but he was in a position higher than me, so maybe like a key holder or something of that nature.
Okay. Do you remember the name of his immediate superior?
It was Ron, but he's no longer with the company.
That's convenient.
Oh, I'm good at this. Believe me, I'm good at this. Do you recall whether or not they reported this to the police?
I don't know. I'm not sure.
Also very convenient. Sorry, Your Honor. I'm sorry.
Do you remember the entire amount that it was alleged he stole?
No, he never told me how much. He never told me how much money they said he stole.
Okay. Now, Mr. Perry.
Yes, Your Honor.
Before I go and try to make heads or tails of this thing, why don't you tell me? You said there wasn't the whole truth about this incident at Bagel, but it was only partial truth.
No.
So tell me your version of what happened in 1997 when you worked for Bagel.
Your Honor, Miss Lockett is manipulating facts that have happened.
No, I'm asking you, just tell me what
There's
happened.
nothing that happened at Bagel. So to tell you, answer your question specifically.
Nothing happened.
Nothing happened at Bagel. She can provide absolutely no documentation because there was never any incidents of me stealing money or doing anything of that nature at Bagel. I resigned from Bagel. She is lying. She cannot prove
Your Honor,
any of
that's not true.
anything that she is saying is totally a lie. As far as that goes, there is partial truth to what she's saying.
So then let me hear the partial truth before you irritate me and I have to go investigate myself.
I was arrested on a traffic violation, and she did bail me out of jail.
I'm not there yet.
Oh, that's the only truth.
I'm talking about 1997, an alleged loan to you of $2,150.
That's all a lie. That's all a lie.
That's not true.
Okay. You have a bank withdrawal for $2,150
I have
on
a
about
bank.
that time?
Yep, a bank statement that I withdrew.
Can I see it? Did you give that money in check or cash?
I gave it to him in cash. He went with me to the bank, actually. He picked me up from school and drove me to the bank so I can give him all of my money.
What's the area code in Rochester, New York?
716.
Thank you.
Real cases, real people. Judge Judy. Catrice Lockett says Jason Perry owes her for paying back an employer who accused him of stealing. Jason denies the charge and the loan.
Good morning. This is Judge Judy Scheindlin. I have a case before me that involves a former employee of yours. I don't know how long you've been there, but this person was employed back in 1997. Jason Perry, P-E-R-R-Y. Okay, great. I'm taking testimony now with regard to some money that he paid back to Bagel in October of 1997. A payment of $2,150. Is that right? Okay. What was the total amount it was alleged that he took? Do you remember? Right. Okay. You have been an absolute angel. Thanks, Lisa. Bye-bye. You stole $5,000. Your parents paid back the rest. $2,150 was paid by her. Do you? Because that was the last payment. According to somebody who has, in fact, been there for a very long time and knows you, sir. See what happens when you lie? You think I'm stupid?
No, but that's
Good.
not true.
So, it's not true. No, I called somebody and I said, listen, are you familiar with Mr. Perry? Oh, yes, I am. There an incident in 1997 with regarding some money that he paid back to Bagel? Oh, absolutely. Do you recall how much money he paid?
Oh, my God.
Oh, my God. Judgment for the plaintiff on her complaint in the amount of $2,435. I'm not even getting into anything else with him, because once somebody lies, they don't get a second chance with me. Your counterclaim's dismissed, sir. That's all.
You may step out.
I can't believe this.
She was lying through her teeth, and I don't know who Judge Judy called. That's ridiculous. But this whole thing has been a farce.
I feel like I got my justice, and I want everyone to watch out for this man because he will suck you dry.
And now the next case.
All parties in the matter of Chase versus Brooks. Step forward.
33-year-old bus driver Tammy Chase is suing her former friends, Susie and Larry Brooks, for car payments. Tammy says the Brooks repossessed the car.
Miss Chase, the defendants were friends of yours.
Yes.
And some time ago, you were talking about buying a new car. According to what I've read in your papers, the defendants suggested that they had a car, and if you wished to take over the payments on the car would be yours when the car was paid for.
Yes.
And you did take over the payments and take possession of the car.
Mm-hmm.
According to you, you made all those payments, and despite that, they came and repossessed the car. You won all the payments that you made at the time that the car was in your possession. They say you were late with your payments and sometimes came up short, so they repossessed the car, right?
Right.
When did you take possession of the car?
In May. I made the first payment in April, though.
And what were the monthly payments?
It was $387.68.
And how many months did you have the car?
From April till October.
7 payments you made in total. Did you pay by check or cash?
Cash, 1 check, and money orders.
Let me see the checks and the money orders.
It begins here. And it goes on to the other pages.
And how many payments do you claim that you received for the car?
I claim that she made all 7 payments.
Okay, so there's no dispute as to that?
No.
She made all 7 payments?
Right.
If she made all 7 car payments, why did you take back the car?
Because she made the payments, but she made them late.
Yeah.
And she also made them, she didn't pay them all in full. She was short.
But you said she made all the payments she was supposed to make.
She never paid the full amount each month, and she never paid it on time.
How much short do you claim she was?
Well, 1 month I got a check that was a $70 check that bounced.
Which month was that?
This was in August. When I called her and asked her about it, she said to talk to her boyfriend because it wasn't he owed her the money and it wasn't her responsibility.
Did she ever make up that check?
No. Her boyfriend did.
I don't care whether she or her boyfriend did. So you got the full amount for August.
No, I got that. First of all, the payments were late. Our agreement, I have a written agreement stating that if she was late, I would take the car back.
And that was a 5-day grace period.
How much do you claim
That I
she
never
paid
used.
you in total towards the car in the 7 months she had the car, madam?
Probably.
Not probably. You must have a record.
I don't have a record because I've never given her a receipt because I've never seen her since June. So I couldn't have given her receipts.
Look, Miss Brooks, I'm not asking you about receipts. If somebody is short when they give you money, then you keep a ledger. The ledger says, this is what she's paid me, this is what she owes me. What, are you kidding me?
No, I'm not kidding you. I couldn't do that because, first of all, she never paid me. She paid my husband. She never paid my husband.
He's not allowed to talk. Right?
Okay, okay.
You're
Well,
doing
can I
all the
tell you-
talking.
Can I tell you how it started first so that you can understand where we're at right now? There's a situation that gets to this point.
At anything other than the car. You can't
That's
take
what
back...
I want to tell you about.
Go ahead.
Okay, what had happened was we have a written agreement here stating that if she was late on the car, we would, at any time after the grace period, we would take back possession of the car.
Which I never used the grace period
Excuse
at
me,
all.
it's my turn.
Well, then
Okay, then in July she started making late payments. I would call her on the 5th and say, Tammy, if there's going to be a problem with making the car payment, you need to call me and let me know. She would call me the date of the thing and say, I need 5 more days grace period, I don't have all the money. So there was always a problem. So then there was a problem with reckless driving in the car. So we took the car back once. We had the car back in our possession for 1 week, and then we gave it back to her. Then when we gave her back the car, then the problems continued to start. So what we decided to do, I told her, Tammy, instead of making the payments, I said, bring me back the car. It's not working out because every time I would call on the phone, there was a verbal abuse. I'll pay you whenever I want to. It was a big problem.
But you can't take the car back and then not give her back any money.
I told her, when we got the car repoed, I said, I will give you $200, the money that you pay for this month, I will give it back to you in full. It's not working out. It's nothing but problems.
Just a second. So you were willing to give her back the money she paid for the last month and you were going to take back the car. What about some of the other money that she paid towards paying off your car note?
Well, we never asked for a down payment on the car. We've been paying on the car for 3 years.
Yeah. You've been paying on the car for 3 years and she paid on it for 7 months. But you have the car.
Right. We have the car, but it's not necessarily because of the car payment. It was because of what she was doing in the car. We could not be responsible.
Let us assume that you are correct, that she did not live up to her agreement to pay the note on time, and that at least 1 month she gave you a $70 check that bounced. It bounced, did it not?
Yes, ma'am.
All right. So that
But we
clearly
still
is a late payment.
Correct.
Because it bounced. So that's in violation of your agreement.
Correct.
Fine. You take back the car. What you're suggesting is that when you take back the car, she loses all of her money. Is that what you're suggesting? You have the equity in the car. You have the car. I'm speaking. You're not going to get all this money back. I mean, you have to pay something. You had the use of a car for 7 months. How much do you think you should have to pay for your use of that car? Because you used it for 7 months. You're not going to get all your money back. That means you had use of a car for 7 months for free.
Okay, first of all, I used it for 6 months because I made the first car payment in April. I didn't get it till May.
6 months.
I don't know. I've never thought about it. I figured I should get the money of the payments that I put into it, I should get back.
That means you had free use of a car.
Can I just state one thing? Okay, the car, they did not repossess the car. They did not make payments to the finance company for 3 months. That's why it
Doesn't
was
make any
repossessed.
difference.
The money I was giving them, though, they weren't paying the finance company to the car.
Doesn't make any difference. You breached the agreement with them. You breached the agreement with them. They were within their rights to take back the car. You want me to read you the agreement?
No, I know
Well,
what
you know
the agreement is about, but the month that the check bounced is one of the months that they didn't even pay the finance company.
It has nothing to do with you.
Can I at least get my stereo out of the car?
Yes, absolutely. I have no problem with that. I have no problem with that. Within 24 hours of the order, you will return the stereo to them. How much did you pay for the stereo, by the way?
$171, the receipt.
Okay, and I'm going to give you $100 per month for the 7 months that you paid for the car. That is what I consider your equity in the car. Judgment for the plaintiff in the amount of $700 plus the stereo. That's all.
Parties are excused. You may step out.
She did not make the last 4 car payments that I made to her.
I brought her receipts to show the judge. She never asked me for them. Like she said, that was our responsibility, and I have the proof, and she didn't ask for it.
Don't trust it.
Don't help other people out because it backfires.
Case number 262 on the calendar in the matter of McCracken versus Labrum. Parties have been sworn in, Judge. You may be seated. Folks have seats.
No good deed goes unpunished. Miss McCracken, according to your complaint, you moved in to the defendant's home with your family. You were having a difficult time. You were living in a small apartment.
Right.
You have 3 children?
No, I have 4, Your Honor.
Did all 4 children move into the home?
Yes.
So they allowed you to come and live in their home with an agreement that you would pay some modest rent.
No, that's not true.
No rent.
This is what happened. This is what happened.
Just a second.
Kathy.
Just answer my questions.
No.
Let me
that's,
talk.
Okay, that's not true.
So there was no agreement to pay rent?
No agreement at all.
Fine. So that they invited you to come into their home with your 4 children out of the goodness of their hearts?
No, we had made an agreement. Okay, this is the agreement. She took my dog. I think it was August. Yes, it was August when I moved into an apartment. I couldn't have the dog there. I stayed there in the apartment for about 9 or 10 months. I don't have
I just get to the point.
Okay, I'm sorry.
What was the arrangement? Either you were going to pay them rent or you weren't going to pay them rent.
I can't answer that because I had moved in and Kathy had not given me, we had not sat down and talked about the amount yet because they were too busy going through my stuff.
Oh, right. Just a second. So what you're telling me was when you moved into their home with your 4 children, there was no agreement to pay rent. That's what you said.
No, I'm sorry. Ma'am, I'm nervous. I am nervous. I'm tired. There was an agreement. We had not discussed. I can't say a total amount because we had never came to agreement on the amount of money. She needed to go over her mortgage payments to find out exactly how much it was going to take to save her house because her husband was a loser and
Miss
didn't work.
Miss McCracken, don't editorialize for me.
Okay,
The moment you moved into the house,
was-
I'm speaking, at the moment you moved into the house, you did not give them any rent. Let's do that.
Oh, no. I gave them money before I went in to the house. And I gave them food stamps.
Just a second. Did you give them any money when you moved with your 4 children into their house? Yes or no?
Yes, ma'am.
How much money did you give them? I'm not talking food stamps.
$60 I gave Kathy before I even moved into the house because she needed to send it to Las Vegas to her friend named Jet.
All right, $60. What other money did you give her?
I got her son some diapers and...
I'm not talking about Sun Target. I'm not talking about any of that stuff. So
I was only
if
there a few days.
But your stuff was here much longer.
Miss Labrum,
I'm sorry.
I don't want you to talk to her.
Okay, I'm
Because
sorry,
you
Your
won't
Honor.
give it to me.
This is what your lawsuit is about. You say that he assaulted one of your children.
Yes, he
which
did.
That's
forced
not
you...
I'm sorry.
Yes,
I'm going to put you out.
Okay, I'm sorry.
Which forced you to move out of the house. And when you moved out of the house, you didn't take a lot of your stuff with you, and you're suing also for $5,000 for your stuff and for the assault on your son.
Your Honor, that's correct. Kathy assaulted my son Saturday night, my son Michael. She hit him in the face with a book. They were in the garage going through my stuff. She claimed this book belonged to her, and she attacked my son and hit him in the face with it. My son turned around and called the police the next morning on her, and John lied. John lied to the police and told him that Kathy did not hit my son because he didn't want his wife going to jail because he knew he didn't have a job and they'd lose the whole house and everything.
If that were the case, why didn't you move out that day?
I'm going to tell you,
I'm sorry.
Miss Labrum, do it once more and you're out. Do you understand? You don't want to be out of here.
I'm sorry, Your Honor. I was really upset.
Okay. Now, is that the attack that you're talking about?
No,
That caused
Your
you to
Honor.
move out?
No.
Well, let's hear about the attack that caused you to move out.
This happened the next day. My son, after he had called the police on Kathy for hitting him in the face with a book, the next day John took it upon himself to tell my son to get the F out of his house.
And how old is your son?
16.
Okay, is he here?
No.
Where is he?
He's incarcerated.
For what?
I don't really want to say, Your Honor. It doesn't matter.
It does matter.
It does.
Okay. Okay.
Listen to me. Sit down. Maybe that'll keep you quiet.
Yes, Your Honor.
The next stop is the door. Okay. So tell me about this alleged assault by John.
John told my son what happened.
To get out?
Yes, to get out. Michael said, no problem. He's laughing. And he started to get up and walk out. John jumped up and rushed my son. Tried to push him through the window.
Were you there?
Yes, I was right there. Kathy was right there.
And you
John,
witnessed it.
he
And you said he jumped up and pushed him.
Yes, he tried to push him through the window. And then my son turned around. They were fighting. Both of them were fighting. And Michael ended up getting John on the ground. And he started choking him. I mean, you got a 40-year-old man jumping a 16-year-old kid. That's uncalled for. And I didn't know what to do. I'm not going to jump in the middle of that. I mean, I didn't know what to do. I would like for my son to explain, because he's the one that helped get Michael. You be quiet. I'm sorry.
Listen,
he helped get Michael.
listen to me. I'm basing my decision on what you tell me. You were a witness. And there was an argument between this man who told your 16-year-old son to get out of the house because he had just called, I'm speaking, because your 16-year-old son had just called the police on his wife. You were living in the house or whatever. Clearly, it was a bad idea. I'm not interested in the assault. I'm not interested in the assault. Let's get to the property. You ultimately moved out.
I moved out right
day.
after that. Right
Fine.
immediately. I grabbed what I could and I took my kids and got out of there because
you didn't take. Listen to me. You didn't take all your children. One of your children stayed with them.
No, we all left. He went back. My other son. That's why I'd like to call him up here.
Just a second. Your other son went back. For how long?
Well, about a month and a half.
Step up here. Tell me your last name.
My last name is McCracken.
How old are you?
I'm 18 years old.
You went back and stayed in the defendant's home for, according to your mother, a month and a half after this incident.
Yes.
Hmm?
Yes.
Why?
Because I was having problems with my own mother.
Real cases, real people. Judge Judy. Gail McCracken says former landlords Kathy and John Labrum won't return her personal property. Gail also says that John violently attacked her 16-year-old son.
Okay. Now, you weren't afraid of the defendant?
Oh, no.
You weren't afraid of his wife?
No.
So you were having difficulty with your own mother, had absolutely no fear of the defendants, and went back to live with them?
Yes.
Did they charge you any rent?
No.
They were very nice to you?
Yeah.
They took care of you?
Yes.
Good. Sit down.
Okay.
Perfect.
Thank you.
I also want to bring up the fact that I don't know why John turned against my dog. This is how this all started.
God.
I had them take care of my dog. Kathy agreed to take care of my dog while I lived in this apartment. Okay? And then half the time, John would call me up and say, Auntie Gail, oh, Auntie Gail, would you mind babysitting their little boy? Well, they would bring their son to me and leave him with me for 3 or 4 days, and I'd have to call him and say, you guys, you have to bring some diapers out.
Is this after you moved out?
This is before.
I'm not interested in before. You want to tell me something about your dog?
Okay, this is what happened. Because I had to live in the apartment, they took my dog, and while they had him there, he ended up with cancer. I had to get treatment for him. And then John kept calling him Neck afterwards, and I'd like to present this.
Listen to me. When you left, listen to me. When you left, hey, you're not listening to me. Your dog was living in their house for a long period of time, even when you weren't living there.
Right. Kathy agreed to this.
I don't care what she sounds like. A very nice person to me. Now, you say something happened to your dog. You want to tell me about what happened to your dog after you left their house, after the altercation?
Yes, I do. I went to go, that Friday, I had the Fresno Rescue Mission. They had provided me with a truck and a driver and another guy to help move my stuff. I went over there to get it. Kathy decided not to let me have my stuff. And we argued about it, and I said, yeah, I just want to get my stuff, that's all. And she says, give me the key. As soon as she got the key in her hand, she ran over there and hit the garage door and shut the garage. I tried 3 times to bounce it back up.
The dog, madam. Oh, yeah. You want to tell me about the dog, which is what I asked you.
She goes, oh, here, take your dog with you that I've been taking care of. And when he came out, he had a stab wound, and it's just blood running everywhere. He was oozing. And the vet said that that stab wound helped the cancer to come back. And I had to have him put down not even a month after this.
Miss McCracken, something wrong with you. I don't believe that somebody who took care of your dog for months because you couldn't keep it, kept your 18-year-old son for months without charging him any rent because they felt sorry for him. I'm speaking. I'm speaking. You told me in your complaint that they stabbed your dog to death. Now you tell me.
Not to death. I never
now you tell me that they stabbed your dog with a screwdriver, is what you say here. Our dog died. This is devastating. Now you tell me that this stab wound caused the cancer to come back, which is what the dog
said, Your Honor. He was a family pet.
I'm going to deal with this case very quickly. Mr. Labor,
Yes.
you say that you wanted the stuff out of your house.
Absolutely.
Where is the stuff now?
She has mostly everything. We have like maybe 20, 30 boxes of basically letters and knickknacks and stuff like that.
Okay, where are all these letters and knickknacks?
They are on our back covered patio.
Okay. Miss, shh. You're showing him a tape. Is it on the tape that the boxes are there?
No.
May I speak?
No, I didn't ask anything yet.
I'm sorry.
The tape,
Good.
The tape is the day that they picked up what they could on one load and some of the damages to our home and the infestation of cockroaches, which that's why I was going through their stuff to rid the roaches so they didn't infest our house.
Can I please present this to you, please? These people are not the nice people that you're claiming. I mean, I'm not
claiming that they're nice people, madam. I'm just saying that you're not going to pull the wool over my eyes.
I'm not trying to pull the wool over anybody's
Sure you
eyes.
are.
All I've tried to do is get my stuff back from day one.
Perfect. You're going to get all your stuff back within 3 days. You provide the mover. After 3 days from today, if you do not show up to pick that up, your stuff can be thrown out. Do you understand?
Yes, Your Honor.
Listen to me. Thrown out.
I hear you.
You have
I don't
3
think it's
days
funny.
from today.
I do understand you. I
3 days.
Thank you.
3
But, Your Honor,
days.
I want to say one thing. I don't think it's funny at all. My dog's
Oh,
dead. My kids have gone through nothing but pure, I can't say the word, that they put us through because I had to leave because he attacked my son. And the police didn't even do anything. I mean, how does a grown man attack a kid?
Listen to me, madam.
It's crazy.
Listen to me, madam. I don't believe that there was an attack on your son. What I believe was that there was an altercation between these two people, and the altercation was precipitated by the fact that your 16-year-old son called the police on his wife after they had been good enough to let your family move into their home without paying them a dime. Things couldn't be as terrible as you suggest because you're 18. I'm speaking. Because your 18-year-old son, rather than going with you, I'm speaking, went back to live with them, expense-free, for a month and a half. For a month and a half.
Built-in babysitter.
Built-in babysitter. No, he said he was going back to live with them because he was having problems with you.
He also didn't tell you everything that he witnessed, Your Honor.
Miss McCracken, you're not getting a quarter, not a penny, not a sou.
I don't
You're getting
care.
your
I
stuff
just want
back.
my stuff. That's all
Perfect.
I've
Then
ever
we don't
wanted,
have to
Your
talk
Honor.
anymore.
May I speak? Please.
No.
Please.
But Your
No.
Honor,
No, not yet. Madam, you are getting closer to that door.
My heart is...
You're getting closer to that door. When I want to hear from you, I'll call you. You got it? Now, let's talk about damages to the home. That I want to see. Now your wife can stand up here. She's getting closer to being able to speak. Closer, not there yet. Stand up. Okay. I'd like to see the tape.
Here you go.
Sure than a porno.
That's the carpet right there. There's no padding. The dog chewed the padding all up.
Did you allow the dog to come into your house?
Yes.
Yes.
That's the garage
But she
door.
agreed to pay the damages, though. That's the
Oh,
gar-
well, I'll get to that in a second. What is that?
That's the garage door where the dog just scratched the heck up out of the door.
Yes.
They're lying.
Miss McCracken.
I didn't put those scratches there.
That was never there. You're lying, John.
Miss McCracken, I want you to be quiet. Okay. You say there was an agreement with Miss McCracken to pay for the damage done by the dog. Is that
Correct.
right?
That's correct.
Who was that made with?
Me and Gail. Gail and I were the ones that made all agreements. That's why
All
John
right,
is
so
really the
tell-
wrong person to be talking.
Just pay attention to me.
Okay.
Now. So far, he's not doing a bad job. I want to hear what arrangements you made with her with regard to paying for any damage the dog did to your home.
May I speak now, Your Honor?
Now I just asked you a question.
Thank
you can
you.
answer my question.
Okay. The arrangement that we made was when I took the dog, 2 dogs, both male, not neutered, she told me it would be for approximately 2 weeks. These dogs were there for 9 months. One, we had to not allow to stay because the 2 dogs would constantly fight. That's why the bedroom was damaged, because she said that when one has to, you have to keep one inside, one outside, because they would fight. So I'd have to take one, lock it in the bedroom, take it outside, so the other one could go to the bathroom. I cleaned up their blah, blah, blah. Meanwhile, she had agreed. She said, any damages that these dogs do while on your property, I will pay for. And also, during the surgery that she said that the dog had, I cleaned its wounds.
Oh, no, you didn't.
Oh, my
That's
God.
why I'd taken back to the vet twice.
So the
Ms.
agreement was
McCracken,
she would pay
I'm
for
going to
any
dismiss
damages.
your lawsuit in total. Do you understand that? I think that, you, quite frankly, you got some nerve to sue them. I
Your
really
Honor,
do. I'm speaking.
I would like to produce this, please.
Oh, she's dying to show me something.
Well, to show she wanted me to move in to help her finalize her divorce, okay? She's scared to death of him. This is her rap she laid on me to move into the house.
I don't, Madam.
Neither one of them were working at the time, Your Honor.
Listen to me. She took care of your dogs for 9 months.
Your Honor.
I'm speaking. She took care of your kid for 2 months after you moved out because he was afraid to live with you.
He was never there.
Oh, Miss McCracken, you've got a lot of nerve. Now, either you people are dumb to have allowed this to happen in your house.
It's embarrassing.
Or just, or I don't know what. Clearly,
Big heart.
clearly, there's something wrong with you.
No, I have a big
Clearly,
heart.
there's
No,
something
yeah,
wrong
you
with
have a
you.
big heart.
And I don't understand
Gil?
what it is. All right, so let's talk about it. I do believe that there was an agreement, because otherwise you would be crazy to keep these dogs, that whatever damage the dogs did, she would take care of.
She never
Because
had all those
that
dogs.
sounds logical to me.
Absolutely.
It doesn't sound reasonable to me that you would keep these dogs that were doing damage to your house, and one dog was returned to you. Is that right?
The one
Speak.
dog she'd only
Just-
had for a little time. and
It
he
was
tore up the
returned
carpet,
to
and
you.
I took him to the SPCA. 'cause I
It
couldn't do
was
anything with him.
returned to you.
I just want to say she
No, I
stated
don't
that
want
the
you to
dogs
say
were there
anything.
9 months. There was only one dog there.
I understand that.
Okay, the other dog was only there a little bit.
I
okay?
said that.
Oh, something wrong with you. She
I'm
stayed
mad.
away from her longer.
I'm very mad.
No, you can be very mad, but
And
you
he's
have absolutely
lying.
no
I don't
basis to be
appreciate
very
you
mad.
talking about my mother like that, all right?
I want to tell you something.
All right?
He's got him. You have a nerve filing a complaint against them for $5,000. I have no idea why you think that you are entitled to claim $5,000 in damages against these people. Absolutely none. You moved with your 4 children into their home, which, believe me, to have
Big
5
mistake.
people in the home, not paying a quarter, by the way, not a quarter, nothing, except your food stamps.
Oh, I stocked their whole refrigerator and had to leave and had nothing, no money, no nothing.
Kids have to
And you
eat.
took all the food with you when you left,
kept
Gail.
it, Kat,
All
for
right,
money.
quiet. Okay, the only thing she's getting out of this lawsuit is getting her stuff.
Thank God. Thank
3
you,
days.
Your Honor.
And
I
what you're
appreciate
getting on your counterclaim is the $120 that you got as an estimate to repair the carpet. Don't be foolish again. You do not invite strangers into your home. Do you understand?
Strange.
Yes, Your Honor.
Very
Don't
strange.
invite strangers into your home.
She also agreed to have our house sprayed for the roaches she brought in, too.
I thought, you
Listen
know
to
what?
me.
I
Listen
told
to
him
me.
in
You
the
may have had
beginning.
roaches in there, and I don't.
I've never before.
And,
Right.
and maybe not.
Absolutely
But
not.
is,
I
agreement
told
she
him
made is
before
an
I would put
agreement,
everything in
though?
storage until and
Don't
get rid of it,
do
bomb
it.
it, and do it all. And
We're
no,
not.
bring it in
Do you
here. They
understand?
needed my money
Never.
for their house.
Ever.
They were going to lose their
embarrassing that-
house.
Parties are excused. You may step out.
I was a schmuck to believe that these people were actually my friends.
I could just scream at her.
Mrs. Ebeling. Parties have been sworn in, Judge. You may be seated. Gentlemen, have seats, please.
All right, let me see if I understand the family relationships here. Ms. Kreutz, the defendant is your former sister-in-law.
That's correct.
She was at one time married to your brother.
That's correct.
Is the brother here today?
Yes, ma'am.
Where is he?
Sitting
Is that
right
you?
there.
That's me.
According to your complaint, you received a telephone call from Miss Ebeling asking if you could loan her $5,000 because your brother had gotten himself arrested.
Correct.
Something that had to do with what?
What a federal indictment.
All right, stand up. If you've been to court, then you know that you stand up when you come to court. Mr. Ebeling, was the case ultimately in the federal court dismissed? Were you convicted? Did you...
I pled guilty and I served. I did everything that I was supposed to do.
You pled guilty and were you sentenced?
Yes, I was.
You have been sentenced. Were you
Yes.
sentenced to jail time?
I got 400 hours of community service and a $40,000 fine.
Okay. Now you may have a seat. She called you and said, could you lend me $5,000 because your brother's in jail. I have $5,000 That's the way it ultimately came out. I have $5,000. We need 10. Could you lend us 5? And you did. So far, that is correct. Is that right?
No, I didn't ask for a loan.
Wrong.
Shh. I don't want to hear you.
Sorry.
Do it again and you're gone.
Yes, ma'am.
Well, tell me what you said to her when you called.
Oh, we had been talking. This makes me very sad to be here today because...
I don't care if you're sad or not. I'm sad to be here, too. Could you please just
Okay.
tell me what you said to her?
All right. Well, Betty and I had been talking since Paul's arrest, and his family would not come up with any money. They wanted me to put up, originally the bail was $50,000. I haven't been married to him since 1987, but we have a child together. I did not really feel it was my responsibility, but I wanted to do the right thing. Then his mother, unfortunately, became very ill.
Just a second.
She died.
I asked you a question.
Okay.
And I said you called the plaintiff about money.
I said the bail had been reduced to $10,000, and I didn't feel it was my responsibility to put up the entire money. And
Okay.
she said Paul's
Look at
mother
me.
had passed away. All right, Paul's mother had passed away. And she said, the money that's in the account, there was a money market account, is now theirs. It's his money. I will send you the check.
Wrong.
I did ask her when she sent the $5,000 if she wanted the money returned into the family account to put it in a cashier's check, and she did not.
Wrong.
Just a minute. Don't. If his family chose not to be supportive of him,
right,
either they're evil people or they have good reason. I don't know which one it is, and quite frankly, I don't care.
Right.
Whatever he has done in the past to either his sister, his mother, his brother-in-law, anybody else so that they want nothing else to do with him,
Right.
that's between them and their brother. You, unfortunately, are stuck with him because you have a child together.
Right.
A child whom I assume he assists in supporting.
He assisted, yes.
So he paid child support?
No.
How did he assist?
He assisted. Actually, my son lived with his father sometimes and sometimes with me, and we sort of shared the responsibilities.
Okay. So despite the fact that you were no longer husband and wife, you had an amicable enough arrangement between the two of you to share custody of a child.
That's right.
So that if you wanted to help him, that's
Right.
what you did. They have no obligation to do that. Your answer says that despite the fact that she gave you $5,000, you said she gave you the $5,000 from their mother's money. She says that's not true. What she says is that when she called and said, can I have my money back because the bail was exonerated, you got back the $10,000,
Yes.
correct?
Yes, I did.
Right? And then you told her that your ex-husband had gifted it to you.
Right.
Had said, you keep it.
Because it was his money. That's what he said.
That's what he did. You keep it because it's my money, and I'm telling you, you don't have to give it back to her.
Right, that's exactly.
Is that right?
Exactly.
Wrong. What was your ex-husband convicted of?
Insurance fraud.
What kind of insurance fraud? Tell me about the underlying facts of the case.
He had a lawyer friend of his who bought a yacht and who was a insurance lawyer. And he had $1.5 million yacht built. And he was supposed to pick it up in Italy. And anyway, he convinced my former husband to go to Europe with him and subsequently sink the boat and collect the insurance and get a bigger boat. Why he did that, I have no idea.
Is this the first time that your former husband has been arrested?
Yes.
What kind of work had he done prior to this?
He's been in the securities, advising businesses on writing business plans and things like that. And actually, when I met him, he was buying car collections for very wealthy clients in Beverly Hills and all over the world, actually.
I got it.
Okay.
So far, do I have it pretty much correct?
Pretty much.
You took out the money. You said, I'll lend you the $5,000. Once they got the money back, your brother said, don't return it to her.
Correct.
Because my mother died and there was money.
Correct.
When did your mother pass away?
September 2nd, 2000.
And when did you give the defendant the money?
September 16th, 2000.
And how much money did your mother have?
At the time of her death, there was $23,000 in the account.
Now, in whose name was this account?
My mother and myself
Paperwork.
Now you're out. Out! That way.
Paperwork.
Judge Judy continues in a moment.
Maybe she didn't like your father. Maybe she knew.
I don't think so.
I don't know. Anybody who goes to Europe to sink $1.5 million boat in order to collect insurance proceeds is somebody that maybe your mother wouldn't be proud of. Is that a possibility?
And later today,
I don't want you to grow up to be an idiot. I want you to try to grow up to be a smart young man, because I don't want your father to think that he's wasted all of the time and energy in raising a moron.
real cases, real people. Judge Judy. Elizabeth Kreutz says her ex-sister-in-law, Fran Lewis Ebling, owes for bail on behalf of her ex-husband. Elizabeth says he was arrested for purposely sinking a yacht.
Well, there is one account, and that account is in the name of Emma and Elizabeth. Your former husband's name isn't on this account. Is this the money you're talking about?
Yes, that's the money that he said is jointly theirs.
But it isn't. The mere fact that he is a sibling does not indicate that he is entitled to half of the money in this account, and he knew that.
I understand what you're saying, Your Honor, and I have been put in the middle of this situation.
I understand that you've been put in the middle of the situation, but you had no right not to return the money to her. What?
I disagree with you.
I don't give a rat's what you disagree with, sir. This is an account. The account is not in your name. When someone dies and there is a joint bank account with rights of survivorship, it goes to the person who survives. If your mother had wanted your name on this account, she would have put your name on this account. Are you telling me that your sister fraudulently took your name off the account?
No, but I set the account up. I know how it was set up, and I know what the intention of the parties were.
Well, let me
And I
explain
know,
something to you,
Judge-
sir. That is what they call hearsay. You cannot suggest that your mother really wanted you to have this money, or a piece of it, put your hand down, but decided just to have it in two names. So, you tried to accomplish indirectly what you couldn't accomplish directly, and you put your former wife in the middle. She appears to be a very nice lady. I assume, what do you want?
Well, I went to St. Louis right before my grandmother died in August of 2000.
Go up there, stand up, please.
Yes?
And I talked to my aunt about the situation that was going on. And my aunt said to me that they could front the money for the bail because that was going to be out of his inheritance anyway. That's what they said
inheritance?
to me.
But I want to know, what inheritance? If this is the inheritance, sir, listen to me carefully.
I'm listening.
This isn't inheritance.
Okay.
This is a joint bank account that your grandmother had with one of her children.
I'm not disputing.
One child, not two, just one. Maybe she didn't like your father. Maybe she knew.
I don't think so.
I don't know.
Okay.
I don't know. Anybody who goes to Europe to sink $1.5 million boat in order to collect insurance proceeds is somebody that maybe your mother wouldn't be proud of. Is that a possibility?
Could be.
Is that a possibility? Could be.
But she
You owe her
loved
the $5,000. Pay it. Judgment for the plaintiff. That's all.
Parties are excused. You may step out.
He duped me, and he's done other things to me.
I know what the intentions of the party were firsthand because I set it up.
I'm sorry that I made that very intelligent judge unhappy with me.
I guess the judge was right.
Follow your mother's advice, because she usually knows best.
And now the next case.
All parties in the matter of Bonfiglio versus Mills. Step forward, please.
Waitress Luis Bonfiglio is suing 18-year-old student Adam Mills for vet bills. Luis says Adam's bull mastiff and German shepherd attacked her dachshund.
Mr. Mills, what kind of dogs do you have?
A yellow lab mixed with mastiff and a German shepherd.
How much does the yellow lab weigh?
160 to 170 pounds.
And the other dog?
The other dog, probably around 90 pounds.
Where do you live?
Aptos. It's near Santa Cruz.
You live near the beach?
Yes.
And you were walking your dogs on the beach. Is that right?
Yes. That's
Without
correct.
a leash?
At first, they had a leash, and then...
Without a
yeah.
leash?
Correct.
And they somehow came in contact with the plaintiff's dog, this dog,
Yes.
and injured this dog.
Yeah.
Is that right?
Yes, correct. Very badly.
And you were visiting that beach?
Yes, it was Dudley's first day to the beach.
Do you live in that area?
I live in San Jose.
Geography
It's about
isn't my
30
thing.
miles from Aptos. So I took my dog to the beach for a picnic, and he was on a lead, and before I knew it, two shepherds, or shepherd-looking mixes, came running at him and just attacked him out of the blue.
Okay. Did you see Mr. Mills at all?
Yes, I yelled at him to come and get his dogs off my dog, and he just turned around and walked away. So people, bystanders, building sandcastles, took his dogs off mine, and I dropped my camera in the sand and broke it, as you can see here.
Who are you, sir?
I'm Adam's father and
You know anything about these dogs?
Yes, I raised the dog with Adam.
Do you know anything about the day of this incident?
Oh, I was not there. I've been told.
Were you present?
No.
You're just here for moral support?
Yes.
Character witness for the dog.
I'm not interested in your opinion of the dog's character. The dog injured her dog. Now I'll hear you.
Yeah, that's a lie. Actually, when she called me after the dog started attacking, I immediately came running to the scene.
You did
and
not.
did
Don't interrupt him, because he just, in his own zeal, said something that is really dispositive of this case. What he said was, when the dog started attacking, I came right over.
But the dog was provoked.
They, take your hands out of your pocket.
They're not in my pockets.
They can't be provoked, sir. I guarantee you that this lady did not take a stick and provoke your dog.
The dog provoked my dogs. From the beach where I was, I saw her dog jump out at my dog.
And just a second. How old are you?
18.
Okay. So I don't want you to grow up to be an idiot. I want you to try to grow up to be a smart young man, because I don't want your father to think that he's wasted all of the time and energy in raising a moron. Do you understand? When you walk two large dogs that cumulatively weigh 250 pounds, take your hands out of your pockets, 250 pounds on the beach, and you choose to walk them without a leash, whatever damage they cause, you're responsible for. Do you understand? If instead of a dachshund, she had been walking with a 2-year-old child, and your dogs ran up to the child, and the child poked the dog in the face, and your dogs mauled the child, would you stand there like an idiot and tell me that the child provoked your dogs?
Yeah.
Of course not.
Child is a different matter.
No! When you have the... Put your hand down. When you have the responsibility of 250 pounds worth of animal that is capable of causing injury, and you choose to walk those dogs unleashed so that you do not have control over them, you are responsible for any damage that they do. Do you understand that, sir?
Yes, but...
Period.
Could I say something in the dog's defense? So.
Oh, I'm dying to hear. Listen, I thought I just had an 18-year-old idiot. Perhaps I'm wrong. Stand up.
Well, I agree with what you've said so far, but the dog has been raised around children and around people. It would not attack children. And
let me explain something to you, sir. Do you ever read the newspaper?
Yes.
Do you ever hear about people who have little children that they love?
Yes.
That are eaten by, let's say, a large Mastiff or a Rottweiler or a Pit Bull that never hurt any child before? You read about those tragedies?
Yes.
Animals are different from people.
Right.
Sometimes something spooks them.
Okay, this dog lives in the country. It chases gophers and mice, and to me, the rodent-like appearance of this dog is just... When it leaped at him, it set him off.
The apple doesn't fall far from the tree, so it's the dachshund's fault that the dachshund looks like a weasel. Is that what you're telling me? Is that what you're telling me? Listen, Miss Bonfiglio, I looked at your complaint. You asked for a lot, because not only do you want the vet bills paid, and the dog was seriously injured. I read that, and I understand that.
I have pictures of the surgery.
I'd like to see pictures of the surgery just so I can complete my file. You indicate that because of what happened to the dog, A, your camera was destroyed because the camera went flying. B, you had non-refundable tickets to attend a wedding, but the dog had surgery, so you canceled those tickets. And for this incident...
The day of surgery.
Shh. And for this incident, you're demanding $2,000. Well, there is currently legislation pending in a lot of jurisdictions, and some of the legislation has to do with the value of pets. And a pet owner can sue, just like you could sue on behalf of a child, for pain and suffering and wrongful death, not just the value of the pet.
But my vacation was ruined.
Shh. Why don't you listen to me?
Judge Judy will continue in a moment.
I believe that if people act irresponsibly like these two people and allow 250 pounds of muscle to walk unattended on the beach, that they are responsible for any consequence that occurs as a result of their irresponsibility. I also believe that the dog went through some very serious pain as a result of the attack by these two dogs. I see the scars. Maybe they haven't, but I see the scars that were caused by your... Shh! Do you look like you're losing? Does it sound to you as if you're losing?
I don't know what he's got up his sleeve.
I don't care what he has up his sleeve. All I'm doing is telling you that you're a winner, and you keep interrupting me.
I'm sorry, Your Honor.
If I could speak.
I'm listening.
I don't see the connection between the dog attack and them missing a Moody Blues concert.
Well, let me tell you something. I don't either.
This is my
but I
baby.
do believe that being attacked and causing this kind of injury and this kind of surgery was painful for this animal. Don't you think that that's true?
Yes, I do think that's true, and I
Don't you
feel
think-
sorry for the animal.
You don't feel sorry enough, because I'm going to read you your answer that your father probably helped you write.
No,
As far as I'm concerned, Mrs. Bonfiglio's dog was a visitor on my dog's beach and provoked the whole situation. Judgment for the plaintiff in the amount of $2,000. Thank you. That's
Your
all.
Honor.
Parties are excused. You may step out.
Well, it was my dog's first day at the beach, and it was totally ruined, and he's lost his confidence now.
My dogs have never been aggressive in the past.
I was petrified. This is my baby.
I don't really think size matters.
It looked like he was being killed by these two dogs. I was petrified.
I think that Mrs. Bonfiglio should invest in a real dog with some substance.
He's recovered. He's very brave.
I think the dog's an aggressive little dog, one of those types that, you know, yap, yap, yap.
We shall go back, and hopefully this man's dogs will not be on the beach.
47 on the calendar in the matter of Wills versus Cooper. Parties have been sworn in. You may be seated. Ma'am, have a seat, please.
Mr. Cooper, what do you do for a living, sir?
I'm the head of domestic sales for a multi-million-dollar company.
And how long have you had that job?
Since about November of 2009.
How much do you earn? Get commissions?
Yes.
Bonuses?
Not yet.
Have you gotten a commission?
Not yet.
So your base salary is $35,000.
Right.
Who do you live with?
I live with my parents.
What do they do for a living?
My mother works for the county, and my father owns a construction company.
When were you and Miss Wills planning to get married?
We hadn't set a date. It was something we had talked about loosely. We were trying to get all of our ducks in a pond first. At the time, I was unemployed. I wanted to make sure we moved out first, lived together. So we didn't have a date set.
And when you were together, where were you living?
I lived with my parents.
So even when you were dating and discussing marriage, you were living with your parents?
Correct.
And where was Miss Wills living?
With her parents.
Now, you accumulated a whole bunch of tickets.
Correct.
Where?
In Riverside County.
Why?
They were mostly tinted window tickets that I had forgotten about.
What does that mean, tinted window tickets?
My windows on my truck were illegally tinted.
Why were they illegally tinted?
It's the way I bought it.
How many tickets did you get for that?
I think the total was maybe 4.
What else did you get tickets for?
That's all I can remember. It's been so long.
How long ago was it?
It's been well over a year since we paid off the tickets.
Now, you use the word we loosely, I assume, because you didn't pay for the tickets.
Right.
Tell me how that came about, Mr. Cooper.
When we were planning on getting married, I was planning on becoming a police officer. Something like this was holding me back, and we were planning on going to Vegas. I got pulled over, and he said I didn't have a license, which I was unaware of, and we were still going to Vegas.
So you had no license?
Right.
You were pulled over, and you were driving?
Right.
Without a license?
Right.
What do you mean you weren't aware of the fact you didn't have a license?
I never received a letter from the DMV in the mail.
Of course you did. If you've been living with your parents your whole life, you got it in the mail, you ignored it.
I just moved back home.
You ignored your tinted windows. You moved back home from where?
Temecula.
Who were you living in Temecula with?
Friends of mine.
Is that where you got the tickets for tinted windows?
That's where I assumed my mail was forwarded, and I had never received it since then.
How long were you living with friends in Temecula?
Well over a year.
And what's the current address on your driver's license?
Riverside.
And were you living in Riverside when you got your driver's license?
Yes.
How old are you?
25.
And how long is a driver's license valid for?
I don't know.
4 years, 5 years, 10 years, as long as a driver's license is valid in the state of California.
I do not know.
Do you have your driver's license with you?
I don't have it on me, no.
So what you're trying to tell me, Mr. Cooper, is you went to motor vehicles and changed your address when you were living in Temecula?
I changed my address to Temecula. When I came back home, I never changed it back.
They send your mail where your driver's license indicates that you live. My question to you, Mr. Cooper, is, are you trying to tell me that a man who accumulates tickets for the same offense, time after time, doesn't know how long his driver's license is good for, but was a good enough citizen to go to Temecula and advise the county in Temecula that you had temporarily relocated with friends to change your address on your driver's license? I just want you to tell me that that's what you want me to believe.
That's not what I'm telling you.
Fine. Then your mail went to Riverside, not to Temecula. And when it went to Riverside, your parents, somebody responsible who works for the county, and your father who has his own business would have said, hey, idiot, your driver's license is suspended. You get where I'm going?
I understand.
Perfect. Now, let's move on with the tickets. So you were planning to be a police officer, just what we need. And this was holding you back because you were on your way to Vegas and you got pulled over and you had no driver's license. Did they impound you?
I was on my way to Vegas when I got pulled over.
Oh, I thought you were on your way to Vegas.
It was something that we had planned to do.
Oh, so you weren't on your way there.
No.
You got pulled over in Riverside.
Correct.
And they said your license has been suspended because you didn't pay all these tickets.
Correct.
Who was in the truck with you?
Nobody.
So what happened to your truck?
I turned around and went home.
They let you drive home with no license?
I was a quarter-mile from my house.
They let you drive home with
Correct.
no license. And what did you do when you got home?
Tried to figure out why I didn't have a license.
And did you figure it out?
I did.
What did you figure?
The accumulation of all the tickets that I had.
So you must have called somebody to find out. Did you ask your mom to help you?
No.
How did you find out?
Went to the DMV. The DMV told me.
You went yourself.
Right.
How did you get there?
I had a friend drive me.
Great. And when you got to the DMV, you found out that you had accumulated these tickets with fines. To what amount?
Roughly $2,600-ish.
$2,600-ish. Got it. So then what did you do?
Had to find out what the tickets were for. Had to find out how to pay them off.
How did you pay them off?
I didn't pay them off.
Well, they were paid off.
Correct.
How did that happen?
Larissa paid them off.
Tell me how that happened.
Before we went to Vegas, she said that she didn't want to drive, and I was gonna set up a payment plan, but it would take too long to pay off all the tickets. So the end result would be...
Which means you wouldn't have a license.
Correct. Which means I couldn't drive to Vegas.
Go ahead.
Okay. Then Larissa didn't want to drive to Vegas. We were going with a group of friends. So she offered to pay them off for me.
What did she say?
She said...
No, don't look there.
Oh, I'm sorry. I'm trying to remember the best I can, too. She said something along the lines of that she had a credit card or she had money, because I don't have a credit card, and that she offered to pay them off for me.
Not offered. She said something to you.
She said she will pay them off for me.
Okay. Now, how were you supposed to pay her back?
I wasn't supposed to pay her back.
That's a lie,
Well,
Your Honor.
You were going to make a payment plan with the people in Temecula.
Riverside.
Or Riverside.
Correct.
Well, these tickets were from Riverside. Fabulous. Good. You were going to make a payment plan with the people in Riverside, and they are strangers to you.
Correct.
Why wouldn't you at least make a payment plan with your girlfriend and say, listen, if you pay them off for me, I'll at least give you what I was going to pay to the county.
Correct.
Why didn't you... Stop saying correct. Why wouldn't you say that to her?
I didn't need to. She offered it as a gift.
That's a lie.
Why wouldn't you say that to her?
Because I didn't.
Why?
Because it was a gift.
He did say that to me, Your Honor.
Just a second.
Judge Judy continues in a moment.
I assumed it to be a gift. It was brought to me as a gift. I wouldn't offer to pay my grandma for a sweater for Christmas.
Don't be a wise guy with me. Why didn't you ask your mother who works for the county or your father who has his own business?
They said no.
Because you're a bum.
And later today, Real People, Judge Judy. Larissa Wills says ex-boyfriend Denby Cooper owes for a large loan to pay off traffic tickets.
Now, what I'm asking you is, why wouldn't you say that to her? Sweetheart, they're my tickets. I got them. I was wrong. I don't want you to take out money from a credit card. As it happens, she's mother's credit card and then paid her mother back. But I don't want you to be out the money. It's my fault. It's my responsibility. If you pay it off up front so that I can have a license, you know, I'll pay you and your mother back slowly. Why wouldn't a person like you do that?
Because I didn't, Your Honor. Because I assumed it to be a gift. It was brought to me as a gift. I wouldn't offer to pay my grandma for a sweater for Christmas.
Why didn't, listen, don't be a wise guy with me. Why didn't you ask your mother who works for the county or your father who has his own business?
Because they wouldn't pay for me.
Why?
They said no.
Because you're a bum.
I'm not a bum.
Sure you were. You weren't working.
Right.
You were 24 years old. You're a bum. And you had no business going to Vegas. How are you going to Vegas if you were 24 years old, had no job? What were you going to do in Vegas? Stand on a corner?
No.
What were you going to do in Vegas?
Go out with friends. We had a group of people who were going with us.
And how were you going to go out? What were you going to use as barter?
I had money.
From what?
I was working part-time.
Part-time where?
At a cell phone repair company.
On the books or off the books?
Off the books.
Were you getting unemployment insurance?
Yes.
Ah! Always follow the money. That's why I love this job. How long were you working off the books while you were collecting unemployment?
Not very long.
I want the president to listen to this. Go ahead.
Not
How
very
long?
long.
Not very long.
Less
How
than-
long is not very long?
Less than a month, 3 weeks. It wasn't a daily job. I fixed cell phones from home.
You had enough to go to Vegas along with the government's help.
Correct. We split the tab.
You're a big boy. You eat a burger and a half. And you were going out with friends. That's not cheap in Vegas. So the couple of 3 days a week that maybe you worked for a cell phone company while collecting unemployment and saying you were looking for work, you must have earned really good money fixing cell phones.
No.
How much did you pay off for his tickets?
It was $26.78.
How much did he pay you back?
$200.
Judgment for the plaintiff in the amount of $2,470. You get a ticket. It's your responsibility to pay it. Bye.
Parties are excused. You may step out.
I'm very happy with it.
I was a little disappointed.
I guess he just didn't want to pay me back for the tickets, and I couldn't get a hold of him.
It was a gift.
He told me to never call him again.
I didn't want to talk to her anymore.
He was mad at me because we broke up.
After she broke up with me to be with somebody else, I had no desire to want to be with her anymore or talk to her.
We just weren't good for each other.
Don't trust women?
Never loan people any money without a written agreement.
And now the next case.
All parties in the matter of McClellan versus Lotz. Step forward, please.
Sammy McClellan is suing her ex-boyfriend, David Lotz, for loans for child support, rent, and an airline ticket.
Miss McClellan, you met the defendant, according to the complaint that I read on the internet. You began to date him and made a series of loans to him. You no longer are involved in any sort of relationship. You want your money back. Mr. Lotz says that there was never any agreement to pay you back any of the money that you gave to him, and the one issue with regard to an airline ticket, you were unable to use it and you gave it to him as a gift. Mr. Lotz, when did you and the plaintiff begin a relationship?
I don't know if I would call it a relationship per se. I talked to her online, and I think I saw her maybe a total of 4 times.
And how long did it last?
Until the time that I thought it was just non-conducive to have any contact with her whatsoever.
Why was that?
Just erratic behavior by emails, text messages, and I have 2 small sons, and I just didn't think that any type of relationship would be an appropriate environment for her to be around them.
At what point did you decide that? Did you decide that before or after you took money from her?
Well, it would be after.
While you were taking money from her, everything was fine?
We really didn't have a relationship. As I said, I saw her 3 times, 4 times.
Was it clear to you, sir, that she had more of an interest in you than you had in her?
No, not necessarily.
How much money did you give her over the course of the brief time that you spent with her?
None.
How many gifts did you purchase for her?
None.
How much money did you take from her?
It was roughly $2,000.
And what did you take the money for?
I had some past bills, and well, the $2,000 that would include the plane ticket that was a gift.
Forget the plane ticket. I'm not interested in a plane ticket. She had a plane ticket that she couldn't use, and it was going to go to waste, and she gave it to you. Who cares? I'm interested in cash. How much cash money did you take from Miss McClellan?
About $1,700.
Let me hear the first amount of money that you took from her. When was it, and what was it for?
I'm not sure of the exact date, but I had some.
I don't need an exact date. Give me a month and year.
Roughly 4 months ago, last year.
Well, 4 months ago would not be last year, sir. If your math is off. When was the first time he took money from you?
It was on, actually, March 2nd.
And what was it for, Mr. Lotz?
I had some past due things that I had to pay.
Like what?
Various things. I don't know right now. I mean, we had a discussion.
I want you to start to think. You didn't think you were coming to the beach today. And you knew what she was suing you for. So let's start to think and not act like a goofball. Okay, sir? What was the money for? You saw her, according to you, 3 or 4 times. In at least 2 of those 3 or 4 times, she gave you money. What was the first one for?
I believe the first one is I had some utility stuff and some insurance.
How would she know that you had issues with your utilities and your insurance?
We had extensive conversations via the internet and Facebook. That was basically the bulk of the relationship.
You mean that you needed money?
I was going through a very hard divorce, and I confided in her as a friend, and so she knew the situation of everything that was going on.
Don't tell me what she knew. If you're courting a woman on the internet, which is what you were doing.
I don't know. I think that's a
well, unless
misrepresentation
you're some sort of a pervert, I would assume that if you were on the internet involving someone in the intimacy of your life, you were doing either some sort of courting or some sort of conning, or you're a pervert. You have 3 choices. Those are the only 3 choices I can come up with. Courting, conning, or a pervert.
I don't see it that way.
I don't care what you see. So somehow she knew you needed money for your utilities and insurance. This had nothing to do with child support, did it?
No, I was paid for. I took care of that. It was paid.
When was it paid, sir?
I pay the first week of every month.
I told her about a hearing that was coming up March 2010 and the child support payments I needed to make right away. That's what you wrote. That's not what she wrote. That's what you wrote. That's not a utility. Your children are not utilities. They may be utilities to you, but child support is not a utility or insurance. How much did you give for child support?
It was $600.
That's a better answer. Now, these are the 2 sons that you didn't want to be around somebody that was as kooky as the plaintiff, right? These are the 2 small sons that you're very attached to, or do you have other sons?
Just them.
Just them. She didn't make them, did she? She didn't make them.
No, ma'am.
Whose responsibility is it to support them?
Mine.
Right. And what do you do for a living?
I'm a chef.
So you eat regularly. And the court sent an order of support that you were supposed to pay. Why didn't you pay it?
I was having some financial difficulties.
So you were conning her, or you were a pervert? Right now we fit into the conning part. $600. It's not her responsibility to support your children. What other money did you take from her, Mr. Lotz?
My rent.
Rent. Who did you live with?
Myself.
So let's see. You're not paying child support, and you didn't have any money for rent. So what category are you? You're either courting her, conning her, or you're a pervert. How much money did she send you in rent?
$11.50.
How much did you send back to her?
You know, it was a gift in my estimation.
How much did you send back to her? The answer is none. Now, in what month did she give you the $11.50 for rent?
It was March.
So in March, she gave you money for child support and rent.
To be honest, I don't remember.
Is that right?
Yes, ma'am.
Now, at what point did you believe that she was a threat to your 2 children? What month was that?
It would have been in June.
Did you see her in April?
No, it was. No, I'm sorry. It was May. I'm sorry, Your Honor. It was May.
Everybody fits into one of those categories on the internet. Now you know where you fit. Judgment for the plaintiff in the amount of $17.50. That's all. Thank you.
Parties are excused. May step out.
Well, I was kind of shocked about the plane ticket because it was never a gift.
Well, if you can't buy love, sue.
The rest of it was never a gift.
That's, what I misinterpreted as a gift, maybe. She thought was a loan.
He knew it was a loan. I've got text messages stating that he was going to pay me, and he didn't.
I confided in a person I thought was a friend, and obviously that wasn't the case.
I wasn't really dating him. He was just a friend.
Well, I think she's a very caring person.
Just knew he was kind of going through a rough time, thought I'd just kind of help him out. thinking I would get my money back.
She's a little confused about things.
He kept sending me text messages saying that he sent the money and it wasn't in the mail, and then he started telling me I was threatening them.
It can be perceived that way. I didn't think about it then, but now in hindsight, maybe.
I think we could be friends, but never.
Parson, parties have been sworn in. You may be seated. Folks, have a seat.
Mr. Haney, the defendant, according to you, was a friend of yours. You allowed her to move into your home on a couple of occasions with her children when she was in some financial distress. You claim now that she owes you for a variety of things, some old loan, rent, utilities.
Correct.
Ms. Parsons says there was never an agreement for her to pay you anything. You are angry over two things. You are angry that she rejected your advances. She was not interested in you in a social way, and that bothered you. And second, you are angry because she reported you to the authorities for abusing one of her children. How long do you know her?
I've known her for about 7 years. We dated. A girl I was dating at one time lived in the same neighborhood that she did, same apartment complex. Me and the other girl broke up. Her and I talked. We went our separate ways. We didn't see each other for about 5 years. And one night at a nightclub, run into her. Then we started talking, and next thing you know, we were dating.
And when was that, sir?
I'd say roughly in the neighborhood about February a year ago.
So why don't you tell me about first the loans and then the arrangement with regard to rent and utilities?
She was calling several times, telling me that she had made a mistake, that she felt that she left me to go with this other guy that dumped her in Ohio.
Are you going to tell me about the loan?
Yes. That's where we're going to.
Let's get there.
She called me up needing money. Her kids needed school supplies for school.
When was this, sir?
Last year, before school. Her and her boyfriend agreed they would pay it back as soon as they can.
So how much did you give them at that time?
I gave them $100.
And then tell me about the rest of your lawsuit involving the rent and utilities.
Well, she left with him, went to Ohio. He threw her out. She came back to Charleston.
When?
February 15th. She asked me could she move back in. I said, okay. Are we talking boyfriend, girlfriend, or you want in a room? She said, well, what's the difference? I said, well, I'm not going to charge my girlfriend to live with me, you know? That's kind of stupid. And she said, oh, I see. If I sleep with you, then I don't have to pay. I said, no, it's not like that either. You know, if you're in a relationship, you know, you were helping before. There's no sense in, you know, I'm paying all this and you just lay around and do nothing. And she said, no, I just want the rooms. I said, fine. I rented the U-Haul to go get her stuff from Myrtle Beach, gas. Every time I turn around, she would, can I borrow $20 for this? Can I borrow $10 for that? I need cigarettes. I need gas. I want to rent a movie. There was no sexual advances to her in any way.
When did she move out, sir?
April the 29th, I evicted her.
Why?
Because she wasn't paying me any money.
Did you have a discussion with her?
Yes.
Tell me about the discussion you had with her.
She simply said she didn't have the money. I said, Tanya, you got a job. I helped you get a job.
Well, what kind of work did you get for her, sir?
She was a cashier.
Where?
At Speedway, well, Conoco, whatever they call it now, and they've changed the name.
Did you know how much she was making?
About $100 a week.
And how much of the $100 a week did you expect her to give you, Mr. Haney?
I told her, even if it was $5 a week.
You wanted to see something, $5
right.
a week.
Make an effort.
Okay, so you wanted her to give you $5 a week.
Correct.
Okay, for the 12 weeks that she was living there.
Correct.
Okay, fine.
Now.
And she didn't, so then you threw her out.
No. She had $1,000 coming to her for back child support. She kept telling me, as soon as that gets here, I will pay you up, get you caught up.
Get you caught up with what?
What she owed me.
Well, what did she owe you?
The loans.
So there's only one loan of $100 that was a year before, sir. That's all the loans that I'm hearing
Correct.
about.
But the dollar here, 20.
Dolly, I'm not, listen, my parents didn't send me to law school and college and post-law school for 10 years to talk about the dollar here and the $2 there. That's gone. It's in the wind. Do you understand? What
Here's
else?
a list of every time she borrowed money from me, I wrote it down.
Listen.
She knew it.
Listen to me. You think that I believe that list that you just filled out? Do you think, Mr. Haney, that I believe that every time you gave her $5, you went over to a book and filled out $5, Tanya, for cigarettes? You think that I believe that? You think that my father raised an idiot?
No.
Good. Then let us move on, sir. Let us move on, sir.
Okay. I went and had an eviction notice signed on her.
And you say it's because she did not...
Owes me rent.
Rent, because she did not pay you rent.
Did not pay me rent.
Okay, now...
Didn't pay me for fixing her car.
Okay.
Buying the shoes.
All right, Miss Parson, now I would like you to tell me, madam, I want you to tell me about what happened on the 29th of April or immediately preceding the 29th of April.
When he got me this job at Sunoco gas station, he agreed that he volunteered to watch my children for me while I was at work because I work third shift. And my son is 6 years old. He has a bedwetting problem. He called me one morning at work and asked me to bring home a small brown bag to mail off cigarettes to somebody, and in the same conversation told me that he had spanked my son for bedwetting. He had done it 3 times in that night, and he spanked him twice out of the 3 times.
Is that the corporal punishment that you're talking about, the spanking?
He also put him in a tub filled with cold water.
Why do you think that that's an appropriate thing to do, sir?
For one, he didn't wet the bed 1 time that night. Yeah. He did it 3 times.
Do you think that he did it on purpose, sir?
I don't know. Just like I told him...
Just a second. If you don't know why he wet the bed, that means that you don't know whether he suffered from some sort of a psychiatric disability or a physical disability. You had no idea.
No, but at the same time, the first time he wet the bed, nothing was done. Because he got up in the middle of the night, changed his own clothes, got back in bed, and urinated again.
What does that tell you, Mr. Genius? What does that tell you, Mr. Genius? Did that tell you that the 6-year-old was maybe perhaps embarrassed?
Well, you know...
Well, what?
We have gone... him and I have talked about it. Logan, what's wrong? You know, is there something wrong? No, I'm just lazy. Because he has heard...
I want to ask you a question. Did you get your degree in psychology from an accredited university?
No, I did not.
Did you take any parenting classes before you decided that this was an appropriate way to treat a 6-year-old bedwetter?
No.
Do you have any children of your own?
Oh, yeah.
How many?
I have 2.
How many did you raise?
My daughter comes with me every weekend.
How many did you raise?
None.
Mr. Haney, it is inappropriate for you to physically discipline anyone else's children in the first place. In the second place, until you understand what all the problems might be with a child that causes them to bedwet, the very idea that you would resort to physical punishment suggests to me that you're missing one of the cans of a 6-pack. Do you understand me, sir?
Oh, yeah.
Now, did you report this to any authority?
The cops were called out. I called the cops out to the house. And
when?
Probably about a week or so later.
Why?
Because of the disagreement me and him were having.
Disagreement about what?
He was threatening to kick me out.
Let me explain something to you, Miss Parson. I believe you probably understand that Mr. Haney had some feeling for you. Correct? Right?
Before I moved in, it was understood.
That's not what I asked you. You're a young, attractive girl, and he's an older fool. And I believe that you needed him. You used him.
No,
of course you did. You used him.
I did not use him.
Of course you did.
Everything was on the table before I even moved in.
But he wasn't using you. He let you move into his house. You weren't paying rent. He was babysitting for your children. How do you say that I wasn't using him? You were. You were using him, and you were using him because, Miss Parson, you understood that he had feelings for you. That's why it was very important to you to have your agreement with him before you moved in that this is strictly platonic.
No, Your Honor.
Oh, Miss Parson. Oh, yes, my dear.
Judge Judy continues in a moment. And later today...
You stayed on the property.
Yes, ma'am.
Alone.
Yes, ma'am.
The gentleman sitting next to her over there was the one that was moving in.
He
That's
never
my
lived there,
second
Your
cousin,
Honor.
Your Honor.
Real cases, real people. Judge Judy. Dwayne Haney says his ex-girlfriend Tanya Parson owes for rent and a loan. Tanya says Dwayne threw her 6-year-old son into a cold bath after he wet the bed.
Listen, you chose him because he's better than a shelter. Give you a room, he's going to babysit for your kids, you got food, you got everything that you need, and the reason he did it was because he had feelings for you. Isn't that right, Mr. Haney? Look at my face.
Yes.
Isn't that right, sir?
Oh, yeah.
Now, when you met her 5 years ago, were you attracted to her?
Yeah.
And at that time, you were 39 and she was 20.
Correct.
Is that right?
That's about right.
That's not a good match, Mr. Haney.
I understand that, but...
So you know what happens when an old guy wants to go out with a young girl? Costs some money.
Well...
And in your case, you know how much it cost you? $160. It's a bargain. It's a cheap lesson, Mr. Haney. Truth of the matter is, you were looking for something more. Mr. Haney, look here, sir. You were looking for something more. Unfortunately, it didn't happen. That doesn't let you come to court like a crybaby and say, now I want all the money for cigarettes and gas I gave her over the 3 months that she lived with me, and this $100 I gave her for school supplies a year ago, because I guarantee you this, Mr. Haney. Had Miss Parson decided to come across and move into your room, you would have forgiven the $100 loan and all the $5 cigarettes and gas. But the fact that she rejected you and the fact that she ultimately decided, well, I'm going to even make it a little bit more difficult for him. He spanked my kid and he shouldn't have done that, which, by the way, you shouldn't have done. That doesn't make a lawsuit. That makes a bad relationship. So, Mr. Haney, this relationship didn't cost you a fortune, sir. It cost you a couple $100 and a good lesson. Find somebody age appropriate. Your lawsuit's dismissed. That's all.
Parties are excused. You may step out.
It wasn't what the way the judge put it out to be, that I just wanted to sleep with the girl. No, I didn't.
It was agreed upon when I moved in there that it was going to be strictly platonic.
I felt sorry for her because of her kids. I gave her a place to stay. She agreed to pay me the $200 a month.
Once I got in there and he was asking me where was I going, who was I with, why was I with this person, why was I doing what I was doing, and I told him that that was none of his business, it continued to go downhill.
The judge ruled, that's it, end the case.
And now the next case.
All parties in the matter of Collins versus Collins. Step forward, please.
Store manager Angela Collins is suing her ex-husband, construction worker Jack Collins, for his share of foreclosure fees. Jack says it was Angela's fault the trailer was repossessed.
Miss Collins, this is your former husband.
Yes, ma'am.
You claim that he owes you $750 because you were forced to pay certain assessments on a home that you jointly owned before the divorce.
Yes, ma'am.
And that you were forced to settle with the whatever company recently. You had no knowledge prior to the divorce that this was going to be a problem, and you feel as if it's only fair for him to pay his fair share.
Yes, ma'am.
And he says it was your house, deal with it. Right?
Yes, ma'am.
When were you married?
In 98.
1998. And when were you divorced?
2002.
And when did you separate?
Probably about 2000.
Who lived in the home?
Me and him, and our 2 children.
How old are your children?
They're 11 and 12.
See from the papers that the children don't live with either one of you, is that right?
You're right. They live with my mother.
Why?
She adopted them.
Why?
Because she couldn't handle them. She didn't want me to have them, and she didn't want them, so that's why she...
Stop tapping.
...tried to sign. She wanted to sign adoption, wanted me, pretty much forced me into signing adoption papers over to her mother for financial reasons, you know, and it just didn't make no sense. She didn't want me to have custody of the children, but she didn't want custody of the children, and they didn't want me to see them. I still don't see my children.
Then that's what happens when you sign away your legal rights to the children. Okay, so you separated in 98, and you stayed in the property.
Yeah.
Is that right?
From February to May.
Alone?
Yes, ma'am.
Are you sure? Are you sure about that?
I'm positive.
The gentleman sitting next to her over there was the one that was moving in.
He never lived there, Your
cousin,
Honor.
Your Honor.
When I started seeing him and his mama kept coming there and they wouldn't leave, and that's the reason I ended up moving out. We was just dating, Your Honor.
You say He was in and out of jail for burglary and drug use. I stayed in our manufactured home that was on his parents' property and continued on my life with a new spouse.
No, we was not married. We're still not married. We was just seeing each other, and he never lived there.
Did he stay there?
No, ma'am.
Did he come to visit?
Yes, ma'am.
Did he stay over occasionally?
Yes, ma'am.
Of course he did. All right. So, did you pay the mortgage during the whole time you were living there?
Yes, ma'am.
Okay, and what happened in May?
Him and his mother kept coming over, and they kept kicking in the front door, and then he got real, he got upset because I was seeing him, and they kept showing their butt, and he tried to run me off the road, and they kept kicking in the front door, so I just moved out.
Why didn't you take the trailer with you?
I didn't have nowhere to take it to.
So you just left it?
Yeah.
When he left, did he say to you, this is your problem, this is your trailer?
No, actually, he said him and his father was going to move into the trailer and keep the trailer.
But what happened to the trailer? It got repossessed?
It got repossessed with half my stuff in it, Your Honor.
Did you pay them this $1,500?
Yes, ma'am.
Let me
Here's the
see.
receipt right here.
Okay. I'll hear you, Mr. Collins. Why shouldn't you be charged for half of this?
Your Honor, I told her whenever I left there, I had went and bought another car. I loaded all my stuff up in a small car. And I told her, I said, as long as you have my children, you can stay on this property as long as you want. And I'll help you pay the note on the trailer as long as my kids are living there. But whenever he moves in, y'all all need to move out. You understand what I mean? I'm not going to sit there and support him and her. So when she decided that I wasn't going to be that dummy and support him and her, then she just left.
How old are you?
30.
You're a big boy. If you buy something from a bank and you take out a mortgage, what you do when you divorce is you make sure that when you get a divorce, all the loose ends are wrapped up. They moved out. They left the trailer on your mother's property. What happened to it?
The repossessors, they were supposed to pay us storage fee for even having the trailer.
What happened to the trailer?
They come repossessed it.
When?
I don't even know.
I don't know.
I moved.
I don't know. I don't know what my name is after this case. Listen to me. You owe her half the money. I mean, certainly when they've written off $10,000 worth of mortgage fees, neither one of you are going to get star credit ratings, but at least you're not going to have judgments against you, and at least under these circumstances, you're not going to have your income tax return if you have any refund taken, or they're not going to come and detach your driver's license. They can't take your children because you've already given them away. Judgment for the plaintiff in the amount of $750. That's all.
Parties are excused. You may step out.
I think she was very fair. I got what I deserved.
I left the trailer there to her, so I think she was responsible for the payments.
We just can't be in the same room together.
Every time I turned around, we were arguing. I couldn't get along.
I'm his second cousin, but that's on my mother's side, and I don't even associate with nobody over there on that side of the family.
It's been so long ago, I'm over it.
Parties have been sworn in, Judge. You may be seated. You okay?
Mm-hmm.
Okay. Have seats, please.
Miss Arias, for some reason only known to you and those nearest and dearest to you and some being up there, you were dumb enough to give the defendant your ATM card and your PIN number. He is neither related to you by blood or marriage, correct?
Correct.
And it is your claim that without your permission, because you gave it to him for one thing, because he needed gas for his car and he didn't have any money, and without your knowledge and permission, he emptied out your bank account and just kept using your card. And you want your money back.
Yes.
Mr. Arrieta says that he did, in fact, take money out of your ATM, using your ATM card. And he took money out of your bank account. And he took it out to pay for a variety of things. And he did it with your permission, because you gave him the card and said, whatever you need, just don't shake your head, please. Whatever you need, here's my card, and you can take it out. That's your position. Is that right, Mr. Arrieta?
Yes, it is.
And how much money did you, in fact, take out of her ATM?
I believe it was around $750 and up, could have been.
700. Did you understand what he said after $750?
And up it could have been.
And up it could have been.
Mm-hmm.
Up it could have been. Is that some sort of language that
could
I'm
have
not
been
aware
more.
of?
Could have been more.
It could have been more. That I do understand.
Okay.
How much money did he withdraw from your bank account?
A total of $1,103, $104, I'm sorry, with 33 cents.
$1,104.
Yes.
Well, Mr. Arrieta, he's not exactly sure. He said it could have been $750 and up from there.
Yeah. Well, he pulled out a bunch of receipts. He should know.
First, I'd like you to tell me how you know him.
We've been friends for about 6 years now. We went to high school together since freshman year. We've never had problems, always got along just fine. There's times where we don't see each other, times we do run into each other.
I don't need a whole story.
Yeah.
That's how you've been friends. for
Yeah,
7
we've been friends.
Do you work?
Yes, I do.
What kind of work do you do?
I'm a receptionist at a hospital.
How long have you been employed as a receptionist at a hospital?
For about 10 months now.
And you have a responsible job?
Yeah.
You go to work every day?
Sure.
And you take your paycheck and you pay your bills?
Yes.
Put your money in your account? You went to the bank and opened up a checking account? Is that right?
Yes.
And they gave you a secret PIN number? And they were very careful when they gave you a secret PIN number. You know, they made you go like this.
Yeah.
You know, so that the lady who was, or man who was giving you the PIN number, they couldn't see what you were doing.
Yeah.
Now tell me, why you were dumb enough to give Mr. Arrieta your ATM card and your PIN number?
Basically,
Not
the,
basically. Tell
the
me
reason,
exactly.
the reason
When?
why.
Yes.
The reason why is because he had called saying that, you know, he and my sister here had a previous relationship where she had a kid out of the relationship and a paternity test was never done. Now, he won a settlement. He was in an accident a while ago. He won a settlement and he called on the 19th saying, I have the money now. I want to pay for this, you know, the blood test to get done, the paternity test. So when he called, he didn't have the money. He had to go pick it up at his lawyer's office. And when he called me, it's because he needed the money to put gas in his car to get there, which was out of town.
So he came over to your house?
No, I was at work. But he came to my house because he had previously tried to borrow my sister's credit card.
And did you tell him when you wanted him to return the card?
I told him to return it that same evening when I got out of work, which he agreed because he was going to come by.
All right, Mr. Arrieta, now I'd like to hear your version of the events, sir.
Well, I've known the defendant
I want you to.
I've known the defendant for several years, as she explained. I did have relations with her sister. It wasn't
I'm not interested about her sister and your relations with her sister.
The day that I asked for the card, I went to her sister. Her sister gave me a card which didn't work. It was declined. And then so...
What did you go to her sister's house for? To get a card for what?
To get a card for... I told her I needed some money, that I didn't have no money for the weekend. So she said, well, I'll give you some money. Because my thinking was because she thinks...
I don't care what you were thinking, sir.
Well, I asked her for some money.
I don't think that you think.
I asked her for some money, and she was willing to give me some money. Her card declined. That's when I called her and I told her.
Called who?
Called Priscilla.
Put your hand down. When did you call her?
I called her. I never had to call her. Priscilla had told me to go straight to her work, that her sister was willing to give me the card.
When you got there, did you see Adriana?
Yes, I did.
And tell me exactly what happened when you saw Adriana.
When I saw her, she smiled at me, gave me a hug. Hey, how you been? I miss you. It's been a long time. Spoke for a little bit about things, and then...
No, tell me what you spoke about.
We spoke about her nephew, which she claims to be my son.
No, what did you say and what did you say?
I said hello. She said hello back. And that was basically...
I want you to think hard.
For the card?
No, think hard. Think hard. You said hi, she said hi, gave you a big hug, and then she said what?
She didn't say nothing. I asked her how her job was going.
And she said?
She said it was going great. She works at the eye doctor.
And then you said?
I came over here to get the card that your sister told me to get because hers declined. She gave me her card and her PIN number.
And then where did you go?
Immediately after that, I went to go get repairs for my truck. Went to get a cell phone.
What, are you an idiot? Are you stupid?
No.
What?
No.
Do you come from a long line of idiots?
No, I didn't.
What?
No.
What kind of work do you do?
Me? I don't work.
Me.
I'm a chef.
Me.
Me?
I know what I do for a living. I know what he does for a living. I want to know what you do for a living. I don't want to know what this idiot does for a living because he can't keep a straight face. I want to know what you do for a living.
I'm a part-time chef.
So that means you work in a restaurant?
I work voluntarily sometimes here and there for
You work
weddings.
voluntarily, so who takes care of you?
I'm sorry?
What word don't you understand, Mr. Arias, that I just said?
Can you repeat the question?
Who takes care of you?
I live with my parents.
How old are you?
22.
What does your father do?
He's a machinist.
And your mother?
She doesn't work. She's a housewife.
And you have brothers and sisters?
Yes, I do.
How old are they?
My brother's 26, my sister's 23.
Is your brother living at home?
No, he's not.
What does mean? Are you thinking of the answers?
Yeah, because sometimes he tries to...
Try not to think of the answers. Try just to tell the truth.
Yes, he does.
Good. He lives out of the house.
Yes.
And your sister?
She also lives out of the house.
Lives out of that. She's 23.
Correct. 23.
All right. And is she married?
No.
Is she working?
Yes.
What kind of work does she do?
She works as a receptionist for a doctor.
And how long has she been living out of the house?
6 years.
And your other brother? How long has he been living out of the house?
4 years.
So the only one that can't get their act together is you?
Yes.
Judge Judy continues in a moment.
Why you would want to tie yourself to this idiot forever by forcing him to have a paternity test, I will never, never know whether he is the father, whether he's not the father. The guy's a jerk.
And later today...
Where's the phone?
We don't have it anymore. She said that we were not going to get the phone back, that she got to the phone before we did, and that he's dead.
Real cases, real people. Judge Judy. Adriana Arias says former friend Nicholas Arrieta used her ATM card to steal from her account. Nicholas says he had permission to take the money.
Now, you take from your parents, you consider that their responsibility to support you. Is that right?
No, that's not the way I feel.
Well, then why do you continue to take from them?
I don't take from them.
Of course you do.
No.
Do you pay for the electricity in the house?
If I have money, I will pay for it.
How do you have money if you don't work? Is not an answer.
Part-time.
Part-time what?
When I do part-time chef, when I do cooking, sometimes
when
for
was
weddings.
When was the last time you did part-time
2 weeks
work?
ago.
For whom?
For a friend.
Friend's name, telephone number.
George.
George what? And what kind of cooking did you do for George? What is his phone number?
Should I give you the whole food meal, the course of what I cooked?
What kind of work did you do for him at a
I
restaurant?
cooked. No, I
Where?
cooked. At his home.
Oh, you went to his house?
Yep.
Why you would want him declared the father of a goldfish, I haven't a clue. I haven't a clue.
My son's 4 now, so it was a long time ago.
Yeah, but why you would want to tie yourself to this idiot forever by forcing him to have a paternity test, I will never, never know whether he is the father, whether he's not the father. As far as I'm concerned, you made a mistake, write it off. Write it off. The guy's a jerk. However, he's a jerk that owes your sister $1,104, judgment to the plaintiff, that's all.
Parties are excused. You may step out.
I called him and, you know, I'll call you back, never called back, so I kind of figured something was up.
It was a gift, so why should I pay her back?
He's basically worthless. He has nothing going for himself, and he brought this upon himself.
And now the next case.
All parties in the matter of Sims versus Cruz. Step forward, please.
Serviceman Billy Sims is suing the daughter of his late father's girlfriend, 21-year-old Christina Cruz. Billy says Christina stole a cell phone off of his father's dead body.
Mr. Sims, your father passed away in June of this year?
That's correct, Your Honor.
According to your complaints, he passed away. He had a heart attack in his car.
That's correct, Your Honor.
And the defendant was in the car with him, along with her boyfriend?
I'm not exactly sure if she was either in the car or if she was following behind him in another vehicle, but they were traveling together.
How did they know each other, do you know?
The defendant's mother had a relationship with my father.
Is that right? So your mom and his dad
were dating.
When his father had the heart attack, were you in the car with him?
Yes, Your Honor.
Oh. And this is all about a cell phone.
That's correct.
Because it is your claim that the defendant took your dad's cell phone after he had the heart attack and died.
Yes, Your
in
Honor.
their presence
Yes,
in the
Your
car. And Ms. Cruz says that she has the cell phone, but that he gave it to her.
Okay.
June what did your father pass away?
It was June the 18th of this year, Your Honor.
What time?
I have a copy of his death certificate.
May I see it, please?
Sure. The coroner put his time of death at about 2:30 p.m. Of course, the...
Okay. Did there ever come a time when you got property that was on his person at the time that he died?
Yes, Your Honor.
When was that?
The following day, on the 19th, that morning, the county coroner called me and my brother to come and get his personal effects. Now, we had to get his vehicle.
Okay. What personal effects did you pick up?
Okay, I picked up his wallet, his checkbook.
Okay, wallet. Was there anything in the wallet?
his identification and some of those things.
Any cash?
There was no cash in his wallet, Your Honor.
Do you know where your father was going on the 18th of June?
Yes, I do, Your Honor. He was doing, my father was retired. He spent most of his time just doing yard work for people, doing handyman jobs really for little or no pay. And he was assisting the defendant's mother on doing some of this work.
Okay. When was the last time you had spoken to your father from the cell phone?
The morning before his death, probably maybe about an hour or an hour and a half before his actual death.
Did you call him or did he call you?
He called me twice, Your Honor.
From his cell phone. Prior to that, for what period of time had your father had this cell phone?
He's probably had the phone almost 2 years. He's had this cell phone, Your Honor.
And is that the phone that he uses primarily for his communication with you?
That's correct, Your Honor.
All right, now, Ms. Cruz, it is your claim, your defense, and you say you do have the phone, and you did use the phone, but that it was a gift to you.
Yes, Honor.
Now, I'd like you to tell me your version of the events when Mr. Sims' dad picked you up, because that's what happens. He picked you up along with this person?
Yeah.
Who was this
my
person?
Witness. Oh, that's my boyfriend.
So let me hear. He came and picked you up at your mom's home?
No, he came over my house and picked us up, and we were going to go swimming. But first, we were going to do some stuff for my mama.
Okay. Now, tell me about the cell phone.
And he took me and my boyfriend to the side. And
To
said,
the side of what?
Of his truck.
Yes.
And said, y'all are like my kids and everything, and I'm going to give you my cell phone. We have a deal. You pay me $50 a month. And we agreed on it. All three of us agreed on it.
Just a second. So you're saying he took you from the side of the truck and said, you're like my kids.
Yes, Your Honor.
And I want you to have my cell phone. Is that right?
Yes, Your Honor.
Did he have another cell phone?
No, he
just had that one cell phone?
Just that one and the house phone.
Well, but he had the cell
Yeah.
phone. That was his cell phone.
Yeah.
And as long as you knew him, he had only used that cell phone. Is that right?
Yes, Your
Is
Honor.
that right? So on that day, he said to you, you're like my kids, I want you to have the cell phone.
Yes, Your Honor.
Liar! You're a liar.
There was other witnesses there.
Bald-faced liar. You took his cell phone off his dead body.
No,
and you
was not
probably also took the cash out of his wallet before the police got there. Not a question in my mind. Why would a man, unless he anticipates his own death, who has used a cell phone for 2 years to communicate with the rest of the world, all of a sudden take you and this person who was sitting over here and say, I want you to have my method of communication? Why in the world would he do that? You're like my kids. If you're like my kids, then he goes and buys you a cell phone and said, here's a cell phone.
No, because he got tired of carrying it around and everything.
It was too heavy. It was too, just a minute. Please do me a favor. Put your hand down. I don't have to listen to that baloney anymore. It's baloney. Could I please see the expenses that you are claiming for the cell phone?
Yes, Your Honor.
Did they use it, by the way?
Yes, Your Honor. They used it. Those 3 days, there were approximately about 400 minutes that were used. And I have those.
Well, just a minute. How much was the cost?
The total cost for the cell phone minutes, it was 35 cents a minute. I don't have that itemized. But
Well, just a minute. Did you ever get a bill from them for this?
yes, Your Honor.
Well, I want to see the bill that you
Okay.
got.
This has the outstanding minutes that he had left over in excess that we had to terminate because it could have been transferred over to his next of kin. That's what the first statement says. That's from the wireless people.
No. I understand what you're saying, Mr. Sims. Listen to me. What you're saying is he had sort of credits, that it didn't cost you hundreds and hundreds of dollars because they took the phone, but that you, as his beneficiary or next of kin, could have used those minutes if you wanted to from his cell phone plan. Is that
Yes,
what your
yes, Your
plan is? Get a life. Where's the phone?
We don't have it anymore.
What'd you do with it?
The guy that was staying with Billy, his daddy, took it. And it's my brother.
Your Honor, there was no one staying with my father. He lived alone. But we asked her the Friday when we first found out that she was the one that had the phone. When she returned the phone call, she said that we were not going to get the phone back, that she got to the phone before we did, and that he's dead, and she's just as entitled to it as...
Let me tell you something. Some people will be happy, productive, moral people their whole lives, and they will raise, hopefully, happy, productive, moral offspring. And some will not. We're not talking about a lot of money, but we are talking about those people who have the capability of being moral people and those who lack the capability of being moral people. Yes, we're talking about a $40 phone bill, which you're going to get, and let's say your father really had a state-of-the-art telephone. A really good one costs $150, is that right?
Yes,
really
Your Honor,
good
it's
one?
on the estimate.
$150 plus 40 is $190. You don't get paid for the minutes, right? And I want you to you have to feel sorry for them. I want you to feel sorry for them. Don't be angry with them. They're never going to be able to get smarter. They're never going to get morals that anywhere relate to what civilized people do, because anybody that could take property off a dead person, which is what they did, will never change. Because I don't believe that anybody, your father's age, drives a car and rides around with not a dollar in his wallet.
That's correct, Your Honor.
I don't believe that that happens. That doesn't happen. So if you're a death scavenger, you're never going to change. Judgment for the plaintiff in the amount of $190. That's all.
Parties are excused. You may step out.
We didn't took it. He gave us it.
There are people in this world that are going to act that way, so instead of being angry, pity them, and that's what I do.
I felt sorry, too, because he died on me.
I'm very happy with the judge's decision, and I'm glad that we can finally put this part of my father.
He walked to the stand with the careful, deliberate movement of a man who had rehearsed his composure. He was sworn in. He sat down. And for a moment, before Moss asked her first question, he looked out at the courtroom with the expression of someone who had been carrying something very heavy for a very long time and had finally arrived at the place where he was allowed to set it down. Moss asked him a simple question first, deceptively simple. Lieutenant Colonel Holt, in your time serving under General Whitfield, did you ever witness him respond to an internal misconduct report filed by a subordinate officer? Farrell was on his feet before she finished the sentence. Objection, relevance, scope. I overruled him. Holt straightened slightly in his seat. Then he said, yes, once, in the spring, about 2 years before I requested my transfer. And what did you witness? I witnessed the general call that officer into a closed meeting. Privately, no documentation, no JAG representative present. When that officer came out of the meeting, they submitted a formal withdrawal of the misconduct report within 48 hours. The gallery didn't erupt. It didn't need to. The silence that followed that testimony was louder than any reaction could have been. I watched the jury. All 12 of them. A retired school teacher in seat 2 whose reading glasses were pushed up into her hair, a logistics manager in seat 7 who had been taking careful notes since opening statements, a young construction foreman in seat 11 who hadn't written anything down because he didn't need to. He was the kind of juror who absorbed everything and revealed nothing. Every single one of them had just heard the same thing I had, a pattern, not an incident. A pattern. Farrell cross-examined Holt for 40 minutes and accomplished almost nothing. Holt was not a dramatic witness. He did not perform. He did not editorialize. He answered every question with a flat, precise economy of a man who had spent decades writing military reports and understood that the most unshakable testimony is the kind that contains no flourishes, no anger, just facts placed one after another like stones across a river. When Farrell finally sat down, he looked mildly frustrated in the practiced way that experienced defense attorneys look mildly frustrated when they are actually deeply concerned. Whitfield, beside him, had not moved. Not once during Holt's entire testimony had Marcus Whitfield's expression changed. He sat with his hands folded on the table in front of him, his posture perfect, his face composed into something that was not quite calm and not quite contempt, but existed in the precise space between those two things. He was the most controlled defendant I had ever watched in active testimony, and I have watched many. That level of control is either the sign of an innocent man who is genuinely unafraid, or the sign of a man who has spent years practicing the performance of innocence. By the end of that first day, I had formed a very clear opinion about which one Marcus Whitfield was. Day 3 was when everything changed. Sarah Ellison took the stand on a Wednesday morning. The courtroom was so full that my clerk had to turn people away from the gallery doors. She walked to the witness stand wearing her uniform, her posture straight, her face carrying the particular stillness of someone who has made a private decision to get through something no matter what it costs them. She was sworn in. She sat. She folded her hands in her lap, and for the first time since this trial began, Marcus Whitfield looked directly at her. Diane Moss began gently. Background, service record, the nature of Captain Ellison's role within Whitfield's command structure, the kind of foundational testimony that builds context before it builds a case. And Sarah Ellison answered every question in a clear, steady voice that carried to every corner of that courtroom without strain. Then Moss asked her to describe the night she filed the misconduct report. And the steadiness in Sarah Ellison's voice shifted, not into tears, not into anger, but into something more unsettling than either. Into the particular flatness of someone recounting something they have gone over so many times in private that all the raw feeling has been worn smooth the way river water smooths a stone, until what remains is just the shape of what happened. Just the facts of it, delivered without decoration, because no decoration is needed. She described finding financial records that didn't reconcile, procurement documents that had been altered, equipment costs that had been inflated, and the difference quietly redirected. She had gone to her direct supervisor first. He had told her she was misreading the numbers. She had gone back and checked again. She hadn't been misreading anything. So she filed the report, and after you filed that report, Moss said quietly, "What happened?" Sarah Ellison looked at the jury for the first time. Not at Moss, not at me. The 12 people whose decision was going to determine whether what had been done to her meant anything. She said, "General Whitfield called me into his office alone. He told me that my military career was a structure, and that structures could be built or they could be demolished, and that the choice of which one happened to mine was entirely within his authority." The courtroom did not make a sound. He told me that the report I had filed contained errors, that I had misunderstood the documentation, that if I chose to stand behind it, the investigation into those errors would reveal a pattern of negligence in my own record that would make my position untenable. She paused, just for a moment. There were no errors in my report, and there was no negligence in my record. We both knew that. He was telling me that he would manufacture them. I have presided over testimony that has made jurors cry, testimony that has made the gallery gasp, testimony that has made defense attorneys physically flinch in their seats. What Sarah Ellison's testimony did was something quieter and more devastating than any of those things. It made the room go completely, absolutely still, the kind of still where you become aware of your own heartbeat. And in that stillness, every person sitting in that courtroom arrived at the same understanding simultaneously. This man had looked a decorated officer in the eye and told her calmly and directly that the truth did not matter. That rank was the only currency that counted. That she could either abandon what she knew to be right, or he would destroy her for knowing it. And then I saw something I had not expected. Douglas Farrell, composed and unshakable defense attorney who had spent 30 years winning cases that looked unwinnable, leaned slowly toward his client and said something very quietly into his ear. Whitfield did not respond, but his jaw tightened just slightly, just once. And in 23 years on this bench, I have learned that the moment a controlled man's jaw tightens in a courtroom, what you are actually witnessing is the precise instant that his certainty begins to crack. Cross-examination was scheduled for the following morning. What happened during that cross-examination, what Marcus Whitfield did, what he said, and what it cost him, is something this courtroom had never seen before. And I mean that without any exaggeration whatsoever. Douglas Farrell was good at his job. Let me be precise about that before I tell you what happened next, because it matters. In 30 years of watching attorneys work inside courtrooms, I had developed a clear sense of who was performing competence and who actually possessed it. Farrell possessed it. He was the kind of defense attorney who never asked a question he didn't already know the answer to, never attacked a witness he couldn't discredit, and never, in 3 decades of practice, lost control of a cross-examination. That Wednesday morning, he lost control of one. He approached Sarah Ellison at the stand with the measured confidence of a surgeon picking up a familiar instrument. His strategy was visible to me immediately. not because I had any inside knowledge, but because it was the only logical strategy available to him. He wasn't going to attack her character directly. The jury liked her. Attacking her directly would cost him 4 or 5 votes before lunch. Instead, he was going to attack the documentation, the chain of custody of the records she had flagged, the timeline of when she claimed to have discovered the discrepancies versus when she filed the report. He was going to build a picture, not of a liar, but of an officer whose judgment was clouded, whose conclusions had outrun her evidence. It was a good strategy. For the first 20 minutes, it was working. Farrell moved through the procurement documents methodically, pointing out date inconsistencies, asking Ellison to confirm details she occasionally had to pause to recall precisely, creating the impression, subtle, never stated outright, of a witness whose certainty was less solid than her delivery suggested. The jury was listening carefully. The school teacher in seat 2 had put her reading glasses back on. The logistics manager in seat 7 had stopped taking notes and was watching Ellison's face instead. And then Farrell made the mistake. I saw it coming approximately 4 seconds before it happened, which in courtroom time is both forever and not nearly enough. He had been building toward a specific document, a procurement authorization bearing Ellison's own signature, which the defense intended to use to suggest she had approved the very transactions she was now claiming to have flagged as suspicious. It was the centerpiece of his cross-examination, the moment the whole morning had been constructed around. He placed the document on the screen. He let the jury see it. He turned to Ellison and asked her to confirm that the signature on the bottom right of page 3 was hers. She looked at it. She looked at it for a long moment, long enough that the room noticed. Then she said, "That isn't my signature." Farrell smiled, gently, patiently, the smile of a man who has anticipated this exact response. "Captain Ellison, this document was authenticated by—" "I know what the authentication says." Her voice was still level, still precise. "The signature on that document is not mine. I can tell you specifically why. The loop on the E in my last name closes completely. It always has. Every signature I have ever made on a military document closes that loop. The signature on page 3 does not close it. Whoever signed that document was copying my signature from memory and made a single mistake." The courtroom took a breath. Farrell stood very still. "Are you suggesting," he said carefully, "that this document was forged?" "I'm not suggesting it," she said. "I'm telling you it was. What happened next is the moment I will carry with me for the rest of my time on this bench." Marcus Whitfield stood up, not completely, not all the way out of his chair. He rose approximately halfway, caught himself, and sat back down. The entire movement lasted perhaps 2 seconds, but in a courtroom, 2 seconds of a defendant partially rising from his seat during cross-examination is not nothing. It is the opposite of nothing. It is a 6-alarm signal visible to every person in that room. The jury saw it, all 12 of them. I watched their eyes move to him simultaneously, the way eyes move toward sudden motion. The way attention is commanded not by volume but by the unexpected. I brought my gavel down once, not hard. I didn't need to bring it down hard, General Whitfield. My voice was quiet, deliberate. The way I speak when I need a room to understand that what I am saying is not a suggestion. You will remain seated and you will remain silent for the duration of this testimony. Are we clear? He looked at me. That same assessment from the first morning, that same reading of terrain. But something had changed behind it now. The absolute certainty was gone. In its place was something I recognized, something I had seen in defendants before. Always at the exact moment the architecture of their defense begins to come apart around them, he said, "Your Honor, I need to speak with my—" "Sit down, General." The gallery was completely silent. Not the polite silence of a room following courtroom protocol, the held-breath silence of a room watching something they had not expected to be in the room for. Several of the journalists had stopped typing. The 2 retired generals in the 3rd row had uncrossed their arms. Whitfield sat down. Farrell turned back to Ellison. His composure had been rebuilt in the seconds his client had just consumed, but it was visibly thinner than it had been. He spent another 10 minutes on cross-examination and achieved nothing further. When he finally said no further questions, he returned to his seat without looking at Whitfield. That afternoon, the prosecution called their final witness. A forensic document examiner named Patricia Coles, 20 years specializing in signature authentication for federal cases. She took the stand with the comfortable authority of someone who had done this enough times that a courtroom held no more tension for her than a conference room. She walked the jury through her analysis of 14 documents bearing Captain Ellison's signature. She used enlarged side-by-side comparisons projected on the courtroom screen. She pointed out the specific characteristic Ellison had described, the closed loop on the E, and she showed the jury with methodical and devastating clarity that 6 of the 14 documents did not contain it. 6 documents. All 6 dated within the 8-week window following Ellison's misconduct report. All 6 related to the procurement transactions at the center of the case. Someone had built a paper trail designed to implicate Sarah Ellison in the very misconduct she had reported. Someone had forged her signature 6 times across 6 separate federal documents. And someone had done it carefully enough that it had passed through 3 levels of administrative review without being flagged, which meant that whoever had done it understood exactly how those review processes worked. Farrell's cross-examination of Coles lasted 11 minutes. He established nothing useful. When he sat down the second time that afternoon, the difference between the attorney who had stood up that morning and the one now seated at the defense table was visible to anyone paying attention. The defense's entire constructed narrative that Ellison had approved these transactions, that her report was motivated by a desire to cover her own administrative failures, had just been taken apart, document by document, loop by loop, in front of 12 jurors who had been paying very close attention. I called a recess. As the courtroom began to move and breathe again, as the gallery found its voice and the journalists started typing with sudden urgency, I looked at the defense table. Douglas Farrell was leaning close to Whitfield, speaking quickly and quietly, his hand partially covering his mouth. The body language of a man rapidly revising a plan. Whitfield was not listening. He was looking at Sarah Ellison, who was being escorted from the witness stand by the prosecution's paralegal. She didn't look back at him. She had said what she came to say. She was done performing for him, and Marcus Whitfield, decorated, commended, 32 years of commanding people and rooms and outcomes, was sitting in my courtroom looking at a woman he had tried to erase, understanding for perhaps the first time that she had not been erased. She had simply been waiting for this room, for this moment, for 12 people who had no loyalty to his rank and no reason to protect his record. Closing arguments were scheduled for Monday morning, but on Sunday evening, something happened that no one in that courtroom had anticipated. Something that would force me to make a decision from this bench that I had never been required to make in 23 years. Sunday evening, the call came to my clerk's office at 6:47 p.m. Douglas Farrell was requesting an emergency pretrial hearing for Monday morning before closing arguments. He cited newly discovered information material to the defense, standard language. The kind of language that gets filed in desperation when a case has turned against you and you need 48 hours to rebuild something that the last 3 days have systematically dismantled. I granted the hearing. You always grant the hearing. The integrity of the process demands it regardless of what you privately suspect the motivation is. What I did not expect was what Farrell placed on my desk when that hearing convened at 7:30 Monday morning. 45 minutes before the gallery opened and the jury was called in. It was a letter, a single page, printed on plain paper, no letterhead, the kind of document that announces its own irregularity before you read a single word of it. The letter was addressed to Douglas Farrell and signed by a name I did not recognize, a name that meant nothing to me in that moment, but would mean everything before the morning was finished. It claimed to be from a current Department of Defense procurement officer who had personal knowledge that the forensic document examiner, Patricia Coles, had been approached prior to her testimony and offered a financial incentive to mischaracterize her findings, witness tampering, against the prosecution's own expert. I read the letter twice. Then I set it down on my desk and looked at Farrell across the room. "Mr. Farrell," I said, "where did this come from?" "It arrived at my office yesterday afternoon, Your Honor, delivered by courier, no return address." "And you're presenting an anonymous letter as grounds to delay closing arguments." I'm presenting it as grounds for an immediate investigation into the integrity of the prosecution's forensic testimony, Your Honor. If Coles was compromised, if I let that word sit in the room for a moment, you're asking me to act on an anonymous, unverified, unattributed document delivered without provenance the night before your client faces closing arguments in a case where your defense has been significantly damaged. Farrell said nothing. He was too experienced to argue with accurate characterizations. I looked at Whitfield, seated beside him. He was watching me with that same careful, measuring expression. But there was something new in it now. Something I had not seen there before in all the days of this trial. Something that looked almost like anticipation, like a man watching a door he expected to open. That look told me everything I needed to know about that letter. I denied the motion, not carelessly. I documented my reasoning in full. The letter was anonymous. It contained no verifiable claims, no corroborating documentation, no identified source willing to be deposed or cross-examined. Accepting it as grounds for delay would set a precedent that any defendant could exploit by manufacturing last-minute anonymous allegations against prosecution witnesses. The motion was denied, and closing arguments would proceed as scheduled. Whitfield's jaw tightened the same way it had tightened during Ellison's testimony, but harder this time, visibly harder. And for just a moment, just the space of a breath, something moved across his face that was not composure and was not calculation. It was fury raw, genuine, unperformed fury. The kind that lives underneath every layer of control a man has spent decades constructing and surfaces only when those layers are no longer sufficient to contain it. It lasted approximately 3 seconds. Then it was gone, packed back down behind the composed expression he wore like body armor. But the jury wasn't in the room to see it. I was. Closing arguments began at 9 o'clock. Dan Moss stood before the jury for 41 minutes. She did not use notes. She did not pace dramatically or raise her voice for effect. She simply walked the jury back through everything they had witnessed over the preceding days, piece by piece. The calm and thorough certainty of a woman who had built something solid and was now inviting 12 people to walk through it and test every wall. She talked about Raymond Holt and what his testimony had established, not just a single incident, but a documented habit of using private meetings to make inconvenient reports disappear. She talked about Sarah Ellison, about what it costs a person to stand in a room with someone who has the institutional power to end everything they have built and say out loud, what you are doing is wrong. She talked about the 6 forged signatures and what their existence proved, not sloppiness, not administrative error, but intent. Deliberate, careful, sustained intent to construct a false record around a woman whose only offense was telling the truth. And then she said something that made the courtroom go very quiet. She said, General Whitfield's defense has asked you to believe that Captain Ellison is confused, that she misread documents, that her report was built on misunderstanding rather than evidence. There is one question I want you to sit with before you begin deliberations. If Sarah Ellison was simply confused, if her report was simply wrong, why did someone need to forge her signature 6 times to prove it? She let that question stand alone in the room. Then she sat down. Farrell's closing was competent. It was measured. It attacked the chain of custody on the forensic evidence, questioned the timeline, suggested reasonable doubt in the spaces between established facts. It was the best closing argument available to a defense attorney working with the material he had left. It wasn't enough. I could see that in the jury's faces. Not in dramatic expressions. Jurors are carefully composed during closings, as they should be, but in the quality of their attention, in the way they listen to Farrell with the polite focus of people who have already privately made up their minds and are waiting for the formality of the process to catch up with their conclusion. The jury was out for 6 hours and 14 minutes. In a case of this complexity, with this volume of documentary evidence, 6 hours is not long. 6 hours means the deliberations did not require extended debate. It means the verdict was not a close thing. When they filed back in, I watched their faces the way I always do. The forewoman, the retired school teacher from seat 2, her reading glasses finally set aside, carried the folded verdict form with the careful steadiness of a person who understood the weight of what she was holding. She handed it to my clerk. My clerk handed it to me. I read it. privately, expressionlessly, the way I have read hundreds of verdicts over 23 years. Then I looked up at the courtroom, at the journalists, at the military observers, at the two retired generals in the third row, both of them now leaning slightly forward, their earlier composure completely gone. At Douglas Farrell, seated with his hands flat on the table, his face carefully neutral. At Sarah Ellison, whose hands were folded in her lap and who was looking straight ahead with the stillness of someone who has been waiting a very long time for a single moment. And at Marcus Whitfield, who was looking at me with an expression that had finally abandoned all pretense of assessment, all performance of control, and had become simply the face of a man who understood that what happened in the next 30 seconds was going to define the rest of his life. I asked the forewoman to read the verdict. On the charge of obstruction of a federal investigation, guilty on the charge of destruction of classified evidence, guilty on the charge of deliberate retaliation against a protected whistleblower, guilty. The gallery erupted. Not into cheers. This was a federal courtroom and the people inside it understood where they were, but into the sudden collective release of held breath that sounds in an enclosed space remarkably like a wave breaking. Journalists typing furiously. The military observers exchanging glances that contained entire conversations. One of the retired generals in the third row closed his eyes briefly, just for a moment, in a way that I chose to read as relief. Sarah Ellison did not move. She sat completely still at the plaintiff's table, her hands folded, her eyes forward, and then slowly, quietly, in a way that the gallery likely didn't see from their distance, she exhaled, just once, a long, slow release of something she had been holding since the morning she walked out of Marcus Whitfield's office and decided that she was not going to disappear. Whitfield stood for sentencing 3 weeks later. I sentenced him to 9 years in federal prison, dishonorable discharge, forfeiture of all military benefits and pension. The medals that had caught the courtroom light on that first morning, 32 years of commendations accumulated across 2 wars and 4 decades of service, stripped. When I read the sentence, he finally looked away from me. It was the only moment in the entire trial that Marcus Whitfield was unable to hold my gaze. I have thought about this case many times since that morning. Not because it was the most legally complex case I have presided over. It wasn't. Not because the evidence was difficult to interpret. By the end, it wasn't that either. I think about it because of what it represented, because of what it said about the particular kind of danger that lives inside unchecked authority, the way power, when it goes unquestioned long enough, stops feeling like a responsibility and starts feeling like a right. The way a man can spend 32 years being told that his judgment is beyond challenge and arrive, eventually, at the genuine belief that the rules governing everyone else simply do not extend to him. Marcus Whitfield was not stupid. He was not careless. He was not a man who had stumbled into wrongdoing through weakness or panic. He was a man who had made a calculated decision that a 29-year-old captain with a clean record and a true report was a smaller force than his rank, his reputation, and his willingness to use both his weapons. He was wrong. And the reason he was wrong was sitting at the plaintiff's table on the morning of the verdict, hands folded, eyes forward, having survived everything he had deployed against her without becoming anything less than exactly who she was when this started. I have been asked in the years since what I remember most about this case. It isn't the forged signatures. It isn't Whitfield's jaw tightening on that Wednesday afternoon. It isn't even the verdict. It is Sarah Ellison's exhale, that single quiet breath released in a federal courtroom on the morning the truth was finally, formally, and permanently acknowledged. That is what justice sounds like when you are close enough to hear it. And that is why, no matter how many cases come through these doors after it, this one will never entirely leave the room. I have presided over murder trials, cartel executions, child abductions, and crimes so cruel they hollowed out entire families. But there is only one case that still follows me home at night. One case where I remember staring at the defendant and thinking, this man is either completely innocent or far more dangerous than anyone in that courtroom realized. And believe me, by the end of that trial, even I questioned whether justice alone was enough. The case arrived on my bench in late October. Cold rain hammered the courthouse windows that morning. Reporters crowded the front steps before sunrise.
By 8 a.m., every seat inside courtroom 6B was filled. I remember standing behind the courtroom doors before entering. My hand rested on the brass handle, and for reasons I still cannot fully explain, I hesitated. You learn certain instincts after decades on the bench, tiny things, the sound of a witness breathing, the way a defendant watches the jury, the silence before someone lies. Sometimes your instincts whisper before the facts arrive. That morning, mine were screaming. The defendant's name was Daniel Mercer, 38 years old, financial consultant. No prior criminal record, married for 11 years to a woman named Rebecca Mercer, and accused of murdering her younger sister, Olivia Bennett. The prosecution claimed Daniel orchestrated the entire killing with terrifying precision. The defense claimed Olivia's death was a tragic accident fueled by paranoia and family conflict. But that wasn't why the nation became obsessed with this trial. No, people became obsessed because of the video. A single 27-second video recovered from Olivia Bennett's phone 3 days after her death, a video the jury had not yet seen, a video I would later watch in complete silence while 16 grown adults inside my courtroom forgot how to breathe. But I'm getting ahead of myself. When I first saw Daniel Mercer enter my courtroom, nothing about him fit the image of a killer. That is exactly what unsettled me. He walked calmly beside his attorneys, hands folded neatly in front of him. Navy suit, clean haircut, expression controlled, too controlled. I noticed he made eye contact with everyone except Olivia's parents seated behind the prosecution table. Not once. In my experience, guilty people often overperform emotion. They cry too quickly, speak too dramatically. They want the room to feel their innocence. Daniel Mercer did the opposite. He behaved like a man attending a corporate meeting, measured, precise, cold. And then there was Rebecca, his wife, Olivia's older sister. I will never forget her face. She sat in the front row wearing a gray coat despite the warmth inside the courtroom. Her hands trembled constantly, not violently, just enough for someone observant to notice. People assume judges only listen to testimony. That's not true. We study human behavior. Every glance matters. Every silence matters. And Rebecca Mercer looked terrified of her own husband. The prosecution attorney, Michael Reeves, noticed it too. I could tell immediately Reeves was one of the sharpest prosecutors I had seen in years. Not theatrical, not loud. The dangerous ones rarely are. He stood slowly during opening statements and walked toward the jury with almost unsettling calmness. Then he said something I remember word for word. Some killers use weapons, some use fear, and some learn how to make fear look like love. The courtroom went silent. Daniel Mercer didn't react, not even a blink. That disturbed me more than anger would have. Reeves began building the timeline carefully. Olivia Bennett had moved into the Mercer's guest house 6 months before her death after losing her job in Seattle. According to friends, Olivia and Daniel clashed constantly. Olivia allegedly believed Daniel was controlling Rebecca emotionally and financially. There were reports of arguments. One neighbor claimed she heard Olivia screaming, "You're lying to her." Another claimed Daniel once told Olivia she was destroying this family. Still, none of that proved murder. Then Reeves introduced the first photographs from the crime scene. I watched jurors shift uncomfortably in their seats. The images showed Olivia's body recovered at the bottom of a cliffside trail near Blackwater Ridge Park. The official cause of death was blunt force trauma from the fall. At first glance, it appeared accidental, but prosecutors argued Daniel staged the scene. They claimed he drove Olivia there late at night after an argument and pushed her. The defense attorney, Christopher Hayes, immediately countered. And Hayes was good, very good. He stood with confidence I rarely saw in defense counsel facing national media pressure. "Ladies and gentlemen," he told the jury, "this case is built entirely on assumptions, emotional speculation, and a family tragedy the prosecution is desperate to transform into murder." Strong opening, effective. Several jurors nodded subtly. I noticed Daniel finally react for the first time then, a faint smile, tiny, barely visible. But I saw it, and something about that smile unsettled me deeply. Over the next 3 days, witness testimony painted a disturbing picture of the Mercer household. Friends described Rebecca becoming increasingly withdrawn after marrying Daniel. Coworkers testified Daniel monitored her spending. A former neighbor claimed Rebecca once appeared at her door crying before abruptly leaving when Daniel called her phone. Still, none of it directly connected to Olivia's death, and juries need evidence, not instincts. That is one of the hardest truths about justice. You may sense darkness in someone long before you can prove it. On the fourth day, Rebecca Mercer finally took the stand. I remember the atmosphere changing the moment she walked toward the witness box. Even the spectators leaned forward. Rebecca looked exhausted, pale, hollow-eyed, like someone who had not slept in weeks. Michael Reeves approached gently. Mrs. Mercer, did your sister fear your husband? The defense immediately objected. I sustained it. Reeves adjusted instantly. Smart prosecutor. Did Olivia ever express concerns about your marriage? Rebecca froze. And that's when I noticed Daniel. He wasn't looking at the prosecutor. He wasn't looking at me. He was staring directly at Rebecca. Completely motionless. I have seen intimidation before, gang members, violent offenders, abusive spouses, but there was something uniquely terrifying about the way Daniel Mercer watched his wife in that moment. No anger, no threat, just control. Rebecca swallowed hard before answering. Yes. The courtroom shifted. She said Daniel controlled everything, Rebecca whispered. Who I spoke to, where I went, what I spent. Hayes rose immediately. Objection. Character evidence. Overruled. Reeves continued carefully. And did you agree with your sister? Rebecca opened her mouth, then stopped. Her eyes moved toward Daniel again. I noticed her hands shaking harder now. And then something happened I still think about to this day. Rebecca looked directly at me, not the jury, not the attorneys, me, and I recognized that expression instantly. Fear mixed with desperation, the expression of someone silently asking for help. Years on the bench teach you how to identify liars, but they also teach you how to recognize trapped people, Rebecca finally answered. No, but she said it too late, too weakly, and the jury noticed every single one of them. That afternoon, court recessed early after an evidentiary dispute involving Olivia's recovered cell phone. The prosecution wanted to introduce newly extracted data. The defense fought aggressively to block it, aggressively enough that even I found it unusual, because until then, Hayes had projected confidence. Now he seemed nervous, very nervous. And when experienced defense attorneys become nervous, judges pay attention. That evening, I remained alone in chambers reviewing motions. Rain hit the courthouse windows again. I remember loosening my tie and reading through the digital forensics report one more time. Then I found a sentence buried near the bottom of the document. One sentence, 23 words. And the moment I read it, I understood why the defense was panicking. Recovered deleted media file timestamped 11:42 p.m., approximately 17 minutes before victim's estimated time of death. I stared at those words for a very long time, because according to Daniel Mercer's statement to police, he claimed Olivia was already dead by then, and suddenly the entire case changed. But nothing, absolutely nothing, prepared me for what we would see when that deleted video was finally played inside my courtroom the next morning. I have replayed that video in my mind more times than I care to admit, not because it was graphic, not because it showed violence, but because of the voice. A terrified human voice can reveal truths no cross-examination ever could. And when Olivia Bennett's recording echoed through my courtroom the next morning, even the jury forgot to take notes. The courthouse was different that day. You could feel it before proceedings even began. Reporters lined the hallway shoulder to shoulder. Camera crews whispered near security checkpoints. Court officers moved with unusual tension. Word spread overnight that prosecutors had obtained new evidence, dangerous evidence. I entered the courtroom precisely at 9 a.m., but no one was speaking anymore. That silence told me everything. Daniel Mercer sat exactly as he had every previous day. Perfect posture, hands folded, answers calm. But after years on the bench, I noticed the smallest change immediately. His jaw was tighter. People think composure means absence of fear. That is incorrect. Real fear often becomes quieter. And Daniel Mercer looked like a man calculating outcomes. Rebecca Mercer appeared worse than before. Her eyes were swollen from crying. She avoided looking toward either table. Then Olivia's parents entered. I will never forget them, Harold and Susan Bennett. Parents forced to sit 10 feet away from the man accused of killing their youngest daughter. Harold walked with visible stiffness, like his entire body had aged 20 years during the trial. Susan clutched Olivia's photograph so tightly I thought the frame might crack. Judges are trained to maintain emotional distance, necessary distance. Without it, this job destroys you. But some mornings test that discipline. This was one of them. Michael Reeves stood first. Your Honor, he said carefully, the prosecution moves to admit People's Exhibit 42. The defense objected immediately. Christopher Hayes rose so fast his chair nearly tipped backward. Your Honor, this material lacks contextual foundation. We have authentication from digital forensics, Reeves interrupted. Hayes pressed harder than I expected. Too hard. That caught my attention. Experienced attorneys usually adapt when evidence is strong. Hayes instead looked almost desperate to stop the jury from seeing the file, and desperation inside a courtroom always carries meaning. I reviewed the admissibility one final time, then I looked toward the jury. Some appeared nervous already, others curious. One older juror gripped his pen tightly enough to whiten his knuckles. Finally, I gave the ruling. Exhibit 42 is admitted, and just like that, the atmosphere changed completely. The courtroom lights dimmed slightly as prosecutors prepared the monitor. No one moved. No coughing, no whispers, only the faint hum of the projector. Then the screen flickered. At first, the footage was dark and shaky. A phone camera, someone walking quickly outside, heavy breathing wind, and then Olivia Bennett's face appeared briefly on screen. I heard an audible reaction from the gallery. She looked terrified, not emotional, not upset. Terrified people often misunderstand fear. Genuine fear has a distinct quality. It strips away performance, and Olivia Bennett was not acting. I'm recording this because if something happens to me, she whispered, breathing hard, it was him. Every juror froze, even Daniel Mercer stopped blinking. Olivia turned the phone slightly. Trees, darkness, a gravel trail. Then her voice again. He followed me out here. Christopher Hayes immediately objected. Hearsay, overruled. I remember Daniel looking at me then. For the first time in the trial, I saw emotion behind his eyes, not sadness, not panic, anger, cold anger. The video continued. Olivia glanced over her shoulder repeatedly as she walked. Then she whispered something that changed the entire courtroom. Rebecca doesn't know what he really is. Silence, absolute silence. The jury stared at the screen without moving. I glanced toward Rebecca Mercer. She had begun crying silently into both hands. And still, the most disturbing part had not yet arrived. Olivia suddenly stopped walking. The camera shifted downward slightly. Her breathing accelerated. Then a man's voice emerged somewhere behind her. Calm, controlled. Olivia. Every hair on my arm stood up. I cannot explain it any other way. Maybe because the voice carried no emotion whatsoever. No shouting, no rage, just calm pursuit. Predators often sound calm. That is something most people never realize. Olivia whispered, "Stay away from me." Then the voice again, "You're making this harder than it needs to be." At that moment, several jurors visibly recoiled. One woman near the back covered her mouth. The video shook violently as Olivia started running. Branches snapped, heavy breathing. Then suddenly, a scream, sharp, sudden. The recording cut to black, and the courtroom fell into complete silence. No one moved for nearly 5 seconds. I looked toward Daniel Mercer, still calm, still controlled, but now something else existed in his expression, calculation, as though he were reassessing every person inside that courtroom. Michael Reeves let the silence linger intentionally. Smart move. Silence can be more powerful than argument. Then Reeves spoke quietly. The prosecution calls Detective Laura Mitchell. Detective Mitchell had led the homicide investigation from the beginning. 30 years in law enforcement, methodical, unemotional, exactly the kind of witness juries trust. She explained how Olivia's phone had been damaged during the fall, delaying recovery of deleted media. Then Reeves asked the critical question. Detective, based on GPS data, where was the defendant's phone at the time this recording was made? Mitchell answered without hesitation, approximately 70 yards from the victim. A murmur swept across the courtroom. Christopher Hayes objected again, attacking signal reliability and tower accuracy, reasonable strategy, but I could see the problem forming already. Individually, each piece of evidence could be challenged. Together, different story. That's how strong prosecutions are built, brick by brick. Mitchell continued, investigators also recovered surveillance footage from a gas station 20 miles from Blackwater Ridge Park. The timestamp showed Daniel Mercer purchasing bottled water and cleaning wipes less than an hour after Olivia's estimated death. Agony, not definitive, but psychologically devastating, especially combined with the video. Then Reeves delivered the question I knew was coming. Detective, during your interview with the defendant, did he state he had not seen Olivia that night? Yes. And according to digital evidence, Mitchell looked directly toward the jury. That statement was false. Christopher Hayes stood immediately for cross-examination, and this was where the trial became truly fascinating, because Hayes did not behave like a losing attorney. He behaved like a man protecting something larger. I noticed it instantly. He approached Detective Mitchell slowly. Detective, did investigators ever recover fingerprints, DNA, or direct forensic evidence proving my client pushed Olivia Bennett? No. Any eyewitnesses? No. Any recording of physical violence? No. Hayes nodded calmly. Then he turned toward the jury. So despite weeks of investigation, the state cannot prove what actually happened on that cliff. Powerful point. Several jurors shifted uncertainly. Reasonable doubt had entered the room again, and Hayes knew it. Then he attacked the video itself. Detective, fear can influence perception, correct? Yes. People experiencing emotional distress can make assumptions. Yes, Olivia Bennett never states on video that Daniel Mercer attacked her. Correct? Mitchell paused. Correct. That pause mattered. I watched the jury carefully. Some were pulling back emotionally now. This is why courtroom trials are psychological warfare. Every inch of momentum matters. Every doubt matters. Then Hayes delivered the line that changed the trajectory of the entire defense. Isn't it true Olivia Bennett had a documented history of anxiety and paranoid behavior? The prosecution objected instantly, but I allowed limited questioning due to prior evidentiary rulings, and that's when the courtroom atmosphere turned darker. Because Hayes wasn't really defending Daniel Mercer anymore. He was beginning to dismantle Olivia Bennett herself. He introduced therapy records, text messages, witnesses describing Olivia as obsessive and emotionally unstable. Classic strategy. Dangerous strategy. Sometimes defense attorneys put victims on trial instead of defendants. I've seen it countless times. Said something about Hayes' aggression bothered me deeply, not legally, personally. He pushed too hard. Almost like he needed the jury to hate Olivia. And when attorneys need jurors emotionally manipulated that badly, there is usually something else they fear. Then came the moment I still cannot fully explain. During a brief recess, Rebecca Mercer approached the bench unexpectedly while deputies escorted jurors out. She looked pale, terrified. "Your Honor," she whispered, barely audible. "He knows something." I frowned slightly. "Mrs. Mercer, you need to speak through counsel." Her breathing quickened. "You don't understand," she said. "Daniel already knows what they found." I asked the obvious question. "How?" Rebecca looked over her shoulder toward the defense table. Then she said 7 words that chilled me instantly. Because someone inside this courtroom told him. And before I could respond, she looked directly at defense attorney Christopher Hayes. I have spent 26 years listening to criminals explain themselves. Most lie, some cry, a few confess. But only one defendant ever looked directly at me after his world collapsed and smiled as though the trial was finally becoming interesting. That defendant was Daniel Mercer, and what happened after his statement nearly destroyed everyone involved in the case. The courtroom remained frozen after his words. You still don't know what actually happened that night. I remember hearing someone in the gallery whisper, "My God." Deputies positioned themselves beside Daniel immediately, but he showed no resistance, no panic, no anger, just that same terrifying calm. Manipulative personalities often believe they are the smartest people in every room, but truly dangerous ones, they enjoy proving it, and Daniel Mercer looked like a man preparing to reveal something. I ordered the jury removed temporarily while counsel approached the bench. Chaos erupted instantly once jurors exited. Michael Reeves demanded Daniel be remanded without further bail consideration. Christopher Hayes, visibly unraveling now, insisted his client was being prejudged emotionally rather than legally, but Hayes no longer looked like a defense attorney in control of a case. He looked like a man realizing he had attached himself to something monstrous. Then Daniel interrupted everyone quietly. "You're all missing the point." The courtroom fell silent again. I should tell you something important here. Judges are trained never to engage emotionally with defendants during proceedings. Distance preserves objectivity, but Daniel Mercer tested that discipline constantly because every sentence from him felt calculated to provoke psychological reaction. He looked directly at Rebecca first. "You told them about the camera." Rebecca began crying again. Daniel nodded slowly. "I wondered when you'd finally break." That sentence disturbed even the deputies standing near him, not because it sounded threatening, because it sounded disappointed, as though her fear had inconvenienced him personally. Then he turned toward me. "Your Honor," he said calmly, "I'd like to testify." Christopher Hayes spun around immediately. "No." Daniel ignored him completely. "I want the jury to hear the truth. Years on the bench teach you when attorneys are afraid of testimony." Hayes was terrified. And suddenly I understood something critical. Christopher Hayes had not been protecting Daniel Mercer because he believed he was innocent. He had been protecting himself. Those offshore payments, the evidence leaks, the desperation, Hayes knew damaging information long before the prosecution uncovered it. And now his client was becoming unpredictable, dangerous territory. I recessed court for lunch before ruling on Daniel's request. But I barely touched my food inside chambers. Instead, I reviewed every behavioral note I'd written since the trial began. Daniel never reacted emotionally to Olivia's death, never expressed grief, never asked about her family, never denied fearing exposure. Only one thing consistently affected him: loss of control. That pattern matters because in abuse cases, control is often the true addiction. not violence control. When proceedings resumed, the courtroom was overflowing beyond capacity. Reporters stood along walls. Additional deputies arrived. The atmosphere felt less like a trial and more like a bomb waiting to detonate. I allowed Daniel Mercer to testify against counsel's recommendation. Christopher Hayes looked physically ill. Daniel took the witness stand calmly, no hesitation, no visible fear. Then Michael Reeves began. Mr. Mercer, did you kill Olivia Bennett? Daniel smiled faintly. No. Did you threaten her? She was emotionally unstable. Classic deflection. Reeves pressed harder. She accused you repeatedly of controlling your wife. Daniel shrugged slightly. Rebecca needed structure. I saw several jurors react instantly to that word, structure, not support, not guidance. Structure. Psychology often hides inside vocabulary. Reeves noticed, too. And what exactly did that structure involve? Daniel leaned back slightly. Managing finances, scheduling, household expectations. Reeves stepped closer, monitoring her phone. Silence, tracking her location. Silence again, recording conversations. Daniel finally answered, I protected my marriage. That line sent visible discomfort across the jury box because everyone understood what he really meant, control disguised as protection. Then Reeves shifted direction suddenly. Tell us about the night Olivia died. For the first time, Daniel hesitated, tiny pause, but enough. She called Rebecca repeatedly that evening, he said. She sounded paranoid, accusatory. Did you meet her at Blackwater Ridge Park? Yes. A ripple swept through the courtroom. This was the first direct contradiction of his original police statement. Reeves moved immediately. So you lied to investigators. I omitted details. Why? Daniel's expression darkened slightly. Because I knew how this would look. Smart answer, generously smart. Then Reeves delivered the question that changed everything. What happened on the cliff? And suddenly, Daniel Mercer's composure shifted, not broken, sharper, colder. He looked toward the jury carefully before answering. Olivia was trying to destroy my marriage, she said. She manipulated Rebecca for months. Did you push her? No. Then explain the video. Daniel folded his hands. She recorded me following her because she wanted evidence. She was obsessed. Reeves fired back instantly. She sounded terrified. She enjoyed drama. That sentence nearly caused Olivia's mother to scream from the gallery. Court officers intervened immediately, but I kept watching Daniel because he wasn't speaking like a grieving man defending himself. He was speaking like someone dissecting a problem, clinical, detached. And then Reeves revealed the final piece. Mr. Mercer, are you aware the prosecution recovered deleted security footage from your garage? For the first time in the entire trial. Daniel blinked rapidly. There it was. Real surprise, real fear. Christopher Hayes closed his eyes immediately, almost like a man awaiting impact. Reeves approached the evidence monitor slowly. Footage timestamped 43 minutes before Olivia Bennett's death. The screen illuminated, black and white garage footage appeared, Rebecca's SUV parked inside. Olivia visible near the driver's side. Then Daniel entered frame. The argument had no audio, but the body language alone was explosive. Olivia pointing aggressively, Daniel moving closer, Rebecca attempting to separate them. Then suddenly, Daniel shoved Rebecca violently into the garage wall. The courtroom erupted. Rebecca covered her mouth in horror. Several jurors physically recoiled. But the truly devastating moment came seconds later. Olivia stepped between them, and Daniel struck her across the face hard. The impact sent Olivia crashing against the SUV. Gasps exploded everywhere. Even deputies looked shaken. Michael Reeves paused the footage there, frozen frame. Daniel Mercer standing over Olivia with absolute fury in his face, not calm anymore, not composed, exposed. And that's when the prosecution destroyed him completely. Mr. Mercer, Reeves said quietly, would you like the jury to see the remaining 6 minutes? Daniel's confidence vanished, not dramatically, worse, silently. Predators fear exposure more than punishment because exposure destroys the identity they built, the illusion, and Daniel Mercer realized the illusion was dying in real time. Hayes stood suddenly. Your Honor, my client wishes to amend his testimony. Reeves smiled slightly. Too late. I allowed continuation. Daniel looked exhausted now, not emotionally, strategically. Cornered minds become dangerous. Then he said the words that stunned everyone. I didn't mean for her to fall. Complete silence. Rebecca began sobbing uncontrollably. Jurors stared at Daniel like strangers finally seeing his real face. Reeves approached carefully. You pushed Olivia Bennett? Daniel shook his head slowly. She attacked me first. Classic minimization. Even then, even trapped beneath overwhelming evidence. He continued trying to preserve control over the narrative. Then came the final revelation. And believe me, nothing in my career prepared me for it. Reeves displayed a forensic enhancement of the final seconds from Olivia's cell phone recording, audio clean, brutal, isolated. The courtroom listened carefully as Olivia screamed. Then Daniel's voice emerged clearly behind her, cold, calm, deadly. "No one will believe you." A sound escaped from the gallery I still remember. Not a gasp, not a cry, something deeper. This sound human beings make when evil finally removes its mask. Daniel closed his eyes, and for the first time since the trial began, he looked defeated, not remorseful, defeated. There's a difference, a profound difference. I dismissed court early that evening because several jurors were emotionally overwhelmed. But before deputies escorted Daniel out, he turned toward Rebecca one final time and quietly said, "You should have trusted me." Even now, those words haunt me more than the confession itself because they revealed everything. To Daniel Mercer, love meant obedience, trust meant silence, and control meant ownership. The next morning, I would sentence him, but what Rebecca Mercer revealed to me privately before sentencing would change how I understood this entire case forever. I have delivered hundreds of sentences in my career. Some felt procedural, some felt tragic, a few felt righteous. But only once have I looked down at a defendant and realized the courtroom had barely stopped something far worse from happening. That realization came the morning I sentenced Daniel Mercer. And even now, years later, I still think about what Rebecca Mercer told me before I entered that courtroom. I arrived at chambers before sunrise. The courthouse was already surrounded by media trucks. Reporters crowded the sidewalks despite freezing rain. Nationwide headlines had transformed the case into a public obsession overnight. Controlled, use-banned, convicted. The Blackwater Ridge killer, the video that shocked the courtroom. But the public still didn't understand the most disturbing part of the case because the real horror was never the murder alone. It was how close Daniel Mercer came to getting away with it. People imagine dangerous individuals as obvious monsters, violent, chaotic, easy to identify. Reality is far more unsettling. The most manipulative people often appear disciplined, intelligent, charming, dependable. They build trust carefully, then weaponize it quietly. Daniel Mercer understood human psychology with frightening precision. That was what kept me awake at night. At 7:40 a.m., before sentencing began, Rebecca Mercer requested a private judicial meeting with attorneys present, standard precautions. She entered chambers looking completely different from the woman I first saw during trial, still exhausted, still grieving, but no longer afraid, and there was something powerful about watching fear finally leave someone's eyes. She carried a small cardboard box in both hands. Her fingers trembled slightly as she placed it on the table. "I found these after the trial," she whispered. Inside were dozens of notebooks, meticulously organized, dates, times, schedules. Every movement Rebecca made over nearly 7 years of marriage had been documented by Daniel Mercer upon calls, gas purchases, conversations, arguments, expenses, even emotional reactions. One page stopped me cold. Rebecca cried after speaking to Olivia today. Possible loyalty issue developing. I remember staring at those words for a long moment, not because they sounded angry, because they sounded clinical, like observations from a scientist studying behavior. Rebecca swallowed hard before continuing. He used to say relationships fail because people stop managing them correctly. Managing them, not loving them, managing them. Then she revealed something that shook everyone in chambers. 3 months before Olivia's death, Daniel Mercer had purchased property in another state under a false LLC, large rural property, remote, isolated, and investigators later discovered survival supplies stored there, generators, fuel, unregistered firearms, enough provisions for nearly a year. The room became completely silent. Michael Reeves leaned forward slowly. "You think he planned to disappear?" Rebecca looked down at the floor. "No," she whispered. "I think he planned to take me with him." I felt a genuine chill hearing those words, because suddenly the entire case transformed in my mind. Olivia Bennett had not simply threatened Daniel Mercer's reputation. She threatened his control. And manipulative people often escalate dangerously when they sense control slipping away. Rebecca continued, speaking softly. "Olivia kept telling me something was wrong. I thought she was overreacting." Tears formed again, but she saw him clearly long before I did. That sentence stayed with me because victims inside controlling relationships often normalize behavior gradually. The manipulation becomes incremental, invisible, until someone outside the system notices the danger. Olivia noticed, and it cost her life. At 9 a.m., I entered the courtroom for sentencing. I have rarely felt tension like that room carried. Every seat filled, complete silence. Daniel Mercer stood at the defense table in county custody uniform now instead of tailored suits. But strangely, he still carried himself with composure. That disturbed me because some people remain emotionally detached even when their entire lives collapse. Not due to strength, due to absence of empathy. Christopher Hayes looked destroyed professionally and personally. Our investigations had already begun regarding misconduct allegations tied to the trial. He barely spoke. Daniel requested permission to address the court before sentencing. I granted it, and what he said revealed more about human darkness than any evidence presented during the trial. He stood slowly, looked directly toward the jury first, then Olivia's parents, then Rebecca, finally me. I know everyone here wants remorse, he said calmly, but remorse doesn't change outcomes. No emotion, no grief, only cold analysis. I made mistakes. Mistakes, that word triggered visible outrage throughout the courtroom. Not murder, not violence, my stakes, Daniel continued. People are emotional. They exaggerate fear. Olivia escalated conflict constantly. Even then, even after conviction, he continued blaming the victim. That is another truth many people fail to understand about manipulative personalities. Some never truly believe they are wrong. They simply believe they lost. Daniel looked toward Rebecca again. I tried to build a stable life for you. Rebecca started crying silently, but you listen to weak people, not concerned people, not loving people, weak people. Everything in Daniel Mercer's worldview revolved around dominance and control. Then he said something that made the courtroom collectively uneasy. If Olivia had walked away that night, none of this would have happened. There it was, the final mask removed completely, not accountability, not remorse. Responsibility transferred onto the victim herself. Even now, remembering it makes my stomach tighten. I began sentencing immediately afterward. And I spoke longer than I usually do, because some cases require more than punishment. They require recognition of truth. I remember every word. Mr. Mercer, this court has observed not merely acts of violence, but a sustained pattern of psychological domination, manipulation, coercion, and calculated intimidation. Daniel remained expressionless. You viewed human beings as possessions to manage rather than lives to respect. Silence filled the courtroom. You murdered Olivia Bennett because she threatened your control over Rebecca Mercer. And even now, you continue minimizing the destruction you caused. I looked toward Olivia's parents, then Rebecca, then back to Daniel. In 26 years on this bench, few defendants have concerned me the way you do, not because of rage, but because of your absence of conscience. Complete silence. Then I imposed sentence, life imprisonment without possibility of parole. No reaction. That's what unsettled me most. Daniel Mercer simply nodded once, as though acknowledging a business transaction. Deputies moved to escort him away. Then suddenly he stopped walking and turned toward me one final time. You know what the worst part is, Judge? The courtroom froze again. Daniel smiled faintly. She almost stayed. Even now I can still hear those words. She almost stayed, not because she loved him, because fear had nearly trapped her permanently. That was the true horror of the case, not merely murder control so powerful it nearly erased someone's ability to escape. Daniel Mercer disappeared through the courtroom doors moments later, and just like that, it was over, or at least legally over. But certain trials never really leave you. People ask judges whether cases become easier over time. The answer is no. You simply become better at carrying them. Yet some remain heavier than others. This one stayed with me because it exposed something deeply uncomfortable about human nature. Evil does not always arrive screaming. Sometimes it arrives smiling, polite, educated, patient. And by the time people recognize the danger, they are already trapped inside it. A year after sentencing, Rebecca Mercer sent me a letter. Short-silled, she wrote, Olivia saved my life. I just understood it too late. I kept that letter. Still have it because beneath all the legal arguments, forensic evidence, and courtroom drama, that sentence captured the entire truth. Olivia Bennett died trying to pull her sister out of darkness, and in the end, she succeeded, but at a terrible cost. I have presided over hundreds of cases since then, yet every so often, when a defendant enters my courtroom too calm, too controlled, too rehearsed, AP, remember Daniel Mercer. And I remind myself of something this case taught me forever. The most dangerous people are often the ones who know exactly how to appear harmless. And believe me, that realization changes the way you look at the world forever. I have presided over thousands of disputes in my courtroom, fraud cases, assault trials, bitter divorces, even murder hearings that left seasoned detectives unable to sleep at night. But there was one case, one particular afternoon inside my courtroom, that still follows me home, not because of violence, not because of bloodshed, but because of how easily human cruelty can hide behind a smile, luxury, and millions of followers online. The woman sitting at the defendant's table that morning was one of the most recognizable social media influencers in the country. Millions watched her every day. Millions admired her lifestyle, private jets, luxury handbags to toss her clothes, perfect vacations, perfect relationships, perfect life. At least that's what people believed. And then there was the man standing across from her, a delivery driver named Daniel Carter, 43 years old, divorced, worked 12-hour shifts 6 days a week, quiet voice, nervous posture, the kind of man most people would never notice walking down the street. But I noticed him immediately because when he walked into my courtroom, he looked terrified, not angry, not aggressive, terrified. And after 22 years on the bench, I've learned something important about fear. Real fear rarely comes from guilty people. It comes from people who've been humiliated for too long. The courtroom was unusually crowded that day. Even before I entered, spectators lined the back walls whispering to each other. Reporters filled the media benches. Phones buzzed constantly despite repeated warnings from security officers. Everyone wanted to witness the case, not because of the legal dispute itself, but because the defendant was Olivia Bennett, one of the biggest lifestyle influencers in America. At the time, she had nearly 18 million followers across social media platforms. To the public, Olivia Bennett represented success, beauty, confidence, perfection. But when she walked into my courtroom wearing oversized sunglasses and an expensive white suit, I noticed something the cameras probably never would have caught. She never once looked at Daniel Carter, not once. That bothered me immediately. You see, innocent people usually look toward the person accusing them. They react emotionally, they stare, they shake their heads, they defend themselves instinctively. But Olivia Bennett behaved differently. She acted as though Daniel Carter didn't even exist, as though he were beneath acknowledgement. And believe me, that detail mattered more than anyone realized at the time. I adjusted my glasses and reviewed the case summary in front of me while the courtroom settled into silence. At first glance, it looked like a simple civil dispute. Daniel Carter claimed Olivia Bennett publicly humiliated him during a live stream incident that ultimately destroyed his job, reputation, and mental health. He was suing for emotional distress, defamation, and damages. Simple enough, at least on paper. But then I reached the attached evidence notes. That's when my attention sharpened, because the plaintiff had submitted over 73 separate video clips. And according to the filings, millions of viewers had watched the incident unfold live. I remember leaning back slightly in my chair thinking, what could possibly happen during a food delivery that became this serious? That question stayed in my mind as proceedings began. Olivia's attorney stood first, Christopher Hale, one of the smoothest litigators I had ever encountered, expensive watch, tailored suit, controlled voice, the kind of lawyer juries often trust within seconds. Your Honor, he began calmly, this case is an unfortunate attempt to exploit my client's public visibility for financial gain. Olivia remained perfectly composed beside him, no emotion, no concern, almost bored. Christopher continued. The plaintiff willingly entered a public environment while performing a commercial service. My client exercised free speech during a live stream broadcast viewed voluntarily by her audience. He paused carefully before delivering the sentence he clearly rehearsed. Embarrassment is not illegal. Several people in the gallery nodded quietly and honestly. From a purely legal standpoint, he wasn't entirely wrong, at least not yet. Then Daniel's attorney stood up, Rachel Morgan's smaller firm, less polished, but sharp eyes. The very sharp eyes. I've learned over the years never to underestimate attorneys who speak softly. They're usually the dangerous ones. Rachel walked toward the evidence monitor slowly. Your Honor, she said, this case is not about embarrassment. She clicked a remote. The courtroom screen illuminated instantly, and suddenly the entire room changed. The first video began playing. Olivia Bennett appeared on screen inside her mansion kitchen during a live stream titled, Spending $10 in one day because I'm bored. The courtroom murmured immediately. I watched Daniel lower his eyes toward the floor. Olivia still showed no emotion. The video continued. Olivia laughed while talking to viewers. Then the doorbell rang. She grabbed her phone camera excitedly and walked toward the front entrance. And that's when Daniel Carter appeared on screen for the first time, wearing a faded delivery uniform, holding 2 paper bags, carefully trying not to look directly into the camera. What happened next seemed harmless at first. Olivia looked Daniel up and down slowly before laughing, not politely, cruelly. "Oh my God," she told her audience. "Look how nervous he is." A few uncomfortable shifts came from the jury box. Then Olivia zoomed the camera closer toward Daniel's face. "Sir, are you okay? You look like you've never seen a mansion before." Daniel quietly attempted to hand her the order, but Olivia didn't take it. Instead, she kept filming him, mucking him, analyzing him, like he wasn't even human anymore. And I remember the exact moment my instincts began warning me something was deeply wrong, because Daniel wasn't reacting with anger. He looked trapped, cornered, like a man trying desperately to survive humiliation without losing his job. In my courtroom, I told the audience years later during a judicial conference, I've seen witnesses lie under oath with less discomfort than what I saw on that man's face. The video continued. Olivia suddenly asked Daniel how much money he made delivering food. The courtroom became very still. Daniel hesitated. Depends on the week, Mom." Olivia smirked directly into the camera. "That means not enough." A few people in the gallery visibly cringed, but then something happened that changed the energy inside the courtroom completely. Olivia stepped aside dramatically and pointed her camera toward her luxury kitchen, marble countertops, gold fixtures, massive chandeliers, everything designed to display wealth. And then she said the sentence that would eventually make national headlines. You know what's crazy? Some people work their entire lives and still never escape being poor. Silence, heavy silence. Even before the clip ended, I could already feel the jury changing emotionally, because humiliation affects people differently when they witness it directly, especially public humiliation, especially when power is involved. Rachel paused the video. Then she turned toward me carefully. "Your Honor, that live stream did not end there." I remember looking toward Daniel again. His hands were shaking now, not dramatically, subtly, the kind of shaking people try desperately to hide. And that's when I realized something important. This man wasn't simply reliving embarrassment. He was reliving trauma. But I still didn't yet understand why. Not fully. None of us did, because the truly disturbing part of this case hadn't even happened yet. I remember staring at Daniel Carter while the courtroom lights reflected against the evidence screen behind him. The man looked exhausted, not physically, emotionally, like someone who had spent months carrying humiliation so heavy it had started changing the way he walked, the way he breathed, even the way he looked at other people. And believe me, after decades on the bench, I've learned to recognize emotional damage long before attorneys start arguing about it. What troubled me most that morning was this. Daniel still seemed afraid of Olivia Bennett, even inside a courtroom, even with cameras off, even with the law standing between them. That kind of fear doesn't come from a single insult. It comes from sustained psychological pressure. Rachel Morgan resumed the footage. The live stream continued playing across the massive courtroom monitor while every juror watched in complete silence. Olivia leaned casually against her kitchen island while Daniel remained standing awkwardly near the front door holding the food bags. She hadn't tipped him, hadn't thanked him, hadn't even accepted the order yet. Instead, she kept talking to her audience about him as though he were part of the entertainment. "You guys," she laughed, reading comments from viewers. "Someone just said he looks like he sleeps in his car." A few nervous chuckles came from the live stream audience heard through the speakers, but nobody inside my courtroom laughed. Not even Olivia's attorney, because humiliation changes when removed from social media and placed inside a legal setting. Online people forget there are human beings involved. Inside a courtroom, humanity becomes unavoidable. Daniel finally spoke in the video, quickly, respectfully. "I really need to complete the delivery." Olivia tilted her head slightly. That expression, I will never forget it. It wasn't anger. It wasn't even arrogance. It was amusement. The kind powerful people sometimes develop when they stop seeing ordinary people as equals. "You're in a hurry?" she asked him. Daniel nodded carefully. And then Olivia smiled directly into the camera. "Guys, should I give him a huge tip?" The live stream exploded with comments racing across the screen. "Tip him. Help him. 1,000 tip. Dow it." I watched several jurors exchange uncomfortable glances because they already understood something important. This wasn't generosity. This was performance. Olivia walked toward her purse dramatically while thousands of live stream viewers encouraged her. Then she pulled out several $100 bills. Daniel looked stunned, hopeful. And that's when the atmosphere in my courtroom shifted again, because every single person watching knew what desperation looked like. Daniel tried to remain professional, but his expression changed instantly when he saw the money. People working exhausting jobs often become experts at hiding financial stress, but hope exposes them immediately. Olivia held the cash toward him. then pulled it away at the last second. The courtroom became dead silent. She laughed, actually laughed. "Oh, relax," she told him. "I'm kidding." I noticed one juror physically recoil in disgust. Another shook his head slowly, and beside me, even the bailiff's expression hardened. But the worst part still hadn't happened. Rachel paused the footage again and approached the jury carefully. "Your Honor," she said softly, "the plaintiff initially attempted no legal action whatsoever after this incident. That caught my attention immediately because most public humiliation lawsuits begin quickly. Anger drives them. Emotion drives them. But delayed lawsuits usually mean something else happened afterward. Something bigger, something worse." Rachel continued. "For 3 days following the live stream, millions of clips circulated online mocking Mr. Carter." She clicked another file. Suddenly, the courtroom monitor filled with social media compilations, edited videos, reaction clips, me's commentary channels, strangers laughing at Daniel's appearance, his nervous voice, his uniform, his financial situation. And then I saw something deeply disturbing. People had identified him, his full name, his workplace, his delivery routes, his personal social media accounts. The courtroom grew increasingly tense as video after video played. One creator called him the broke delivery guy. Another created parody videos mocking the way he stood at Olivia's door. Someone edited fake crying sounds over his face. Millions of views. Millions. That number stayed in my mind. Because humiliation changes psychologically when it becomes mass entertainment. One insult hurts. Millions of strangers laughing at you simultaneously, that destroys people. I glanced toward Olivia Bennett again, still emotionless, still detached, and that disturbed me more than outrage would have. Experienced judges learn something dangerous about emotionally controlled defendants. Sometimes calmness is maturity, sometimes it's calculation. Rachel lowered her voice. 3 days after the live stream, Mr. Carter lost his employment. The courtroom reacted immediately. Christopher Hale stood up fast. "Objection, Your Honor. Misleading causation. Sustained in part," I replied. "Rephrase." Rachel nodded calmly. Mr. Carter's employer terminated him following widespread online attention related to the live stream. A better, cleaner, legal precision matters. But emotionally, the damage was already done. She played another clip. This one showed Daniel's former supervisor giving a statement to local media. "We simply felt the public attention had become disruptive." That sentence irritated me instantly. Corporate language often hides cowardice behind professionalism. Disruptive. Not harmful to Daniel, not unfair. Disruptive, meaning the company found humiliation inconvenient. Rachel then submitted employment records, lost wages, medical therapy expenses, psychological evaluations, C disorder diagnosis, severe anxiety documentation. And that's when I noticed Olivia Bennett finally reacting for the first time all day. Not guilt, not sympathy, a nice tiny shift in posture, small sigh, eyes briefly rolling upward as though this entire proceeding bored her. Believe me, juries notice things like that, and judges do too. Rachel approached Daniel gently. "Mr. Carter," she asked, "why didn't you simply leave during the live stream?" Daniel swallowed hard before answering. "I needed the job." Simple answer. Powerful answer. The courtroom became very quiet again. Rachel continued carefully. "How much were you earning weekly at the time?" "About $600. "And were you supporting anyone?" Daniel hesitated. That hesitation mattered, because emotional truths often arrive slower than rehearsed lies. "My daughter." Rachel nodded softly. "How old?" 11. And suddenly the case stopped feeling like internet drama. Now it felt personal. Now it felt human. Daniel explained how he had been working double shifts trying to afford medical treatment for his daughter Lily's autoimmune condition. Medication costs, doctor visits, insurance problems, late bills, overtime hours. As he spoke, his voice never became angry. That's what affected me most. People expect wounded individuals to explode emotionally, but truly exhausted people rarely do. They just sound tired. "I just wanted to finish the delivery and leave," he said quietly. Noticed several jurors staring directly at Olivia now. Not Daniel Olivia to psychology inside courtrooms shifts subtly. At first, jurors evaluate evidence logically, but eventually they begin evaluating character instinctively. And Olivia Bennett was losing that battle badly. Then Rachel asked one question I still remember word for word. "Mr. Carter, what hurt you the most?" Daniel looked down for several seconds. When he finally answered, "Even I struggled to remain emotionally detached. My daughter saw the videos. Silence, pure silence, no typing from reporters, no whispering, nothing." Daniel rubbed his hands together nervously. "She asked me why everybody hated me. I saw one female juror cover her mouth instantly. Another lowered his eyes. And for the first time all day, Olivia Bennett stopped looking confident. Only for a second, but I saw it. Fear very small, very brief, but real. That's when my instincts sharpened completely, because experienced judges know something important. People become nervous when cases stop being about money and start becoming about morality. But the moment that truly changed everything happened minutes later, because Rachel Morgan reached beneath her table and revealed a sealed evidence envelope the defense clearly had not expected. And when Christopher Hale saw it, his face lost color immediately. That reaction alone told me whatever was inside that envelope was dangerous, very dangerous. I leaned forward slowly. "Counselor," I said, "what exactly are we about to see?" Rachel looked directly toward me, then toward the jury, then finally toward Olivia Bennett. "Your Honor, this is the footage the defendant believed had been deleted forever." And suddenly, even Olivia Bennett looked afraid. I have watched hardened criminals remain calm while facing life sentences. I have seen fraud executives smile through indictments worth millions of dollars. But the moment Rachel Morgan mentioned deleted footage, Olivia Bennett's composure cracked for the first time, only slightly, a tightening around the jaw, a quick inhale. With eyes darting briefly toward her attorney, most people inside the courtroom probably missed it. I didn't, and neither did the jury. Believe me, jurors pay attention to fear, especially sudden fear. Christopher Hale immediately stood. "Your Honor, we object to any material not previously authenticated through discovery." His voice remained polished, but faster now. That mattered. Experienced litigators slow down under pressure. Inexperienced ones speed up. Rachel remained perfectly calm. "The footage was authenticated this morning through forensic recovery analysis submitted to opposing counsel 2 hours ago." She handed documents to the bailiff. I reviewed them carefully. Nutmetor Devetsu extraction reports, Dutsport verification. Everything appeared procedurally sound. Christopher objected again, but this time I noticed something else. He wasn't defending Olivia emotionally anymore. He was containing damage. There's a difference. Defense attorneys protecting innocent clients usually fight aggressively. Defense attorneys protecting dangerous information fight strategically. I allowed the footage, and I will never forget what happened to that courtroom afterward. Rachel dimmed the lights slightly. The recovered video appeared on screen. Unlike the polished live stream footage, this recording looked raw, unedited, private, probably captured accidentally before Olivia officially began streaming. At first, the footage showed nothing unusual. Olivia standing near her kitchen counter, preparing the live stream setup, assistant staff moving around in the background, lighting adjustments, microphone testing. Then a male voice off camera asked, "Are you actually posting another delivery prank?" Olivia laughed casually. "Of course, prank." That word immediately changed the emotional atmosphere in the room, because suddenly this no longer sounded spontaneous. Now it sounded planned. The unseen voice spoke again. "You got destroyed online after the last one." Olivia shrugged while applying makeup in a mirror. "That's why engagement triples." Several jurors shifted in their seats. I noticed Daniel staring downward again, almost like he already knew how painful the next few minutes would become. Then Olivia said something that made my stomach tighten. People love watching poor people get uncomfortable. The courtroom froze. No exaggeration. Frozen. Even Christopher Hale slowly closed his eyes for half a second, and that told me everything. He hadn't known the footage contained this. Rachel didn't interrupt. She let the silence sit there. Smart move, because powerful evidence becomes even stronger when people are forced to emotionally process it. The recording continued. Another assistant asked carefully, "What if somebody complains?" Olivia laughed again. That laugh, cold, detached, calculated. They signed up for public interaction the second they accepted the delivery. I remember studying the jury carefully at that moment. Not one person looked sympathetic toward Olivia anymore. Not one. And then the footage became even worse. Olivia walked toward the front entrance before Daniel arrived. She adjusted the camera angle, deliberately positioned the lighting, chalked her appearance. Then she said, "Watch this." Guys like him always panic when attractive women talk to them. Several audible gasps came from the gallery. One juror physically shook his head in disbelief. Another leaned backward with crossed arms, a posture I've often associated with emotional rejection during trials. Psychology matters enormously inside courtrooms. Jurors rarely announce the exact moment they stop trusting someone, but judges learn to see it happening. And Olivia Bennett was collapsing in real time. The footage kept playing. Then came the part that changed the case completely. A production assistant asked, "What if he gets upset?" Olivia smiled. "He won't." "Why not?" And then Olivia delivered the sentence that haunted me long after the trial ended. "Because people like him can't afford dignity." The silence afterward felt suffocating, not dramatic silence. the not cinematic silence, human silence, the kind that appears when people witness cruelty too honest to deny. I looked toward Daniel Carter instinctively. His eyes were wet now, but he still wasn't crying. That's important. People expect emotional breakdowns to look explosive. In reality, emotional devastation often looks incredibly controlled, like someone trying desperately not to fall apart in public. Rachel finally paused the footage. Nobody moved, nobody whispered. Even reporters had stopped typing. That almost never happens in modern courtrooms, but everyone understood instinctively. We had crossed beyond internet controversy. This was psychological exploitation, deliberate humiliation for profit. And Olivia Bennett knew exactly what she was doing. Christopher Hale rose slowly. I could see him recalculating strategy in real time, a very intelligent lawyer. Unfortunately for him, facts are stubborn things. Your Honor, he began carefully, while my client's language may appear insensitive in private conversation, private speech is not equivalent to legal liability. Reasonable argument, legally speaking, he wasn't wrong. Cruelty alone is not always unlawful. But then Rachel Morgan did something brilliant. She approached Olivia directly. Ms. Bennett, she asked calmly, how much revenue did your live stream generate? Christopher objected immediately. I overruled him. Olivia adjusted in her seat before answering. I don't know exactly. Rachel handed her a financial statement. Would this refresh your memory? Olivia glanced down, tiny hesitation, then approximately $130,000. A murmur spread across the courtroom instantly. Rachel nodded. In a single live stream? Yes. And how much did you pay Mr. Carter for appearing in that content? Olivia's jaw tightened. We didn't hire him. Rachel stepped closer, but you monetized him. That sentence landed heavily, very heavily, because suddenly the jury wasn't viewing Daniel merely as a victim of insults. Now they saw exploitation, commercial exploitation, and psychologically, that changes everything. Rachel continued carefully. You earned over $100,000 broadcasting Mr. Carter's humiliation to millions of viewers, while he earned $600 weekly delivering food. Olivia remained silent. Rachel turned toward the jury. No further questions. Christopher Hale immediately redirected smartly. He needed to regain emotional control before the jury fully hardened against Olivia. Ms. Bennett, he said gently, did you ever instruct viewers to threaten or harass Mr. Carter? No. Did you tell his employer to terminate him? No. Did you create the internet memes mocking him afterward? No. Christopher nodded confidently toward the jury. And honestly, legally, this mattered. Causation is everything in civil court. Public cruelty doesn't automatically equal liability for third-party actions. I could feel the jury wrestling internally now. Emotion versus legal standards, sympathy versus responsibility, that conflict defines many difficult trials. But then Christopher made a mistake, a very dangerous mistake. He asked Olivia, did you ever believe Mr. Carter would suffer serious emotional harm? Olivia answered too quickly. No. Never answer too quickly under oath. Fast answers often come from ego instead of thought. Rachel stood immediately. Your Honor, rebuttal evidence. Christopher looked irritated now. That irritation worried me because skilled attorneys become irritated when they sense control slipping away. Rachel approached the evidence screen one final time. This, she said quietly, was uploaded by the defendant herself 2 hours after the live stream ended. A podcast clip appeared on screen. Olivia sat laughing with another influencer during an interview. Then the interviewer asked, so what happened with that delivery guy afterward? Olivia smirked, and what she said next caused audible outrage inside the courtroom. He probably cried himself to sleep. Several people gasped. One spectator muttered, Jesus Christ. I struck the gavel immediately, but internally, even I felt disturbed. Not because the statement was vulgar, because it revealed awareness. Olivia knew humiliation would hurt him. She expected it, maybe even enjoyed it. And then came the detail that truly changed my perception of the entire case. Rachel lowered her voice. Your Honor, the plaintiff attempted suicide 11 days after that podcast aired. The courtroom exploded in chaos, gasps, whispers, reporters scrambling. Christopher Hale standing instantly, Olivia's face turning completely pale, and Daniel Carter simply lowered his head like a man exhausted by surviving something he never expected to survive at all. That was the moment I realized this case was no longer about social media. It was about what happens when human beings stop seeing each other as human. But what truly shocked me was what Daniel revealed next under oath. Because according to him, the live stream humiliation wasn't even the first time Olivia Bennett had targeted him. I remember gripping my pen tighter when Rachel Morgan asked Daniel Carter to remain seated. Because suddenly, The entire courtroom understood this case was far darker than anyone originally believed. Until that moment, most people assumed Olivia Bennett had simply crossed a moral line during one reckless live stream, cruel, humiliating, arrogant. But isolated, now that assumption was collapsing, and I could feel the jury sensing it too. The atmosphere inside my courtroom had changed completely. Nobody viewed Daniel as a man chasing money anymore. Now they were looking at him like a survivor. Rachel approached carefully. "Mr. Carter," she asked softly, "have you encountered Miss Bennett before the live stream incident?" Daniel hesitated. That hesitation mattered, because trauma victims often pause before revealing information they've spent months trying to suppress. Finally, he nodded. "Yes." Rachel let the silence breathe. "When?" Daniel swallowed hard. 3 months earlier. Every juror leaned forward slightly. Even Olivia Bennett stopped pretending boredom now. I watched her hands closely. People reveal truth through their hands long before their mouths. Her fingers had started tightening against the defense table. "Small detail. Important detail," Rachel continued. "Please explain to the court how you first met Miss Bennett." Daniel stared toward the floor several seconds before answering. "I delivered groceries to her house. Simple beginning. Ordinary. That's what made everything afterward feel so disturbing. She recognized me during the live stream because she'd seen me before," he explained quietly. Rachel nodded. "And during that earlier delivery, did anything unusual happen?" Daniel's breathing changed instantly, shallower, faster. I noticed it immediately. So did the jury. Trauma has physical fingerprints. People can fake outrage. They struggle to fake involuntary fear responses, Daniel finally answered. "She recorded me then too." A ripple moved across the gallery. Rachel approached the evidence table and lifted another folder. "Your Honor, we recently obtained security footage from the plaintiff's former employer." Christopher Hale objected again immediately, but his objection sounded weaker now, not legally weaker, emotionally weaker. There's a difference. I allowed the footage, and believe me, what we saw next disturbed me more than any viral clip ever could. The screen displayed security camera footage from inside a luxury apartment complex. Timestamped 3 months before the live stream, Daniel entered carrying grocery bags, nothing unusual. Then Olivia Bennett appeared from the elevator lobby holding her phone camera openly toward him. Even without audio, her body language revealed familiarity. Comfort, confidence, predatory confidence. The footage showed Daniel attempting to complete the delivery quickly, but Olivia repeatedly blocked his path, recording him talking, lawing. Then something happened that made several jurors visibly uncomfortable. Olivia reached toward Daniel's uniform name tag and forced the camera closer to it, zooming in deliberately, capturing his full name. Rachel paused the footage. "Your Honor," she said carefully, "this was the first time the defendant publicly posted content involving Mr. Carter." The courtroom became very still because suddenly the live stream no longer looked spontaneous. Now it looked targeted, deliberate, repeated. Rachel displayed screenshots from Olivia's older content, posts mocking creepy delivery guys, awkward poor men, people with no future, millions of likes, millions. And that's when a dangerous realization settled into my mind. Olivia Bennett hadn't merely humiliated Daniel Carter. She had built audience engagement around humiliating people like him. That distinction matters psychologically. Cruel behavior becomes far more dangerous once it turns systematic. Rachel asked Daniel another question. After the first encounter, did online harassment begin? Daniel nodded slowly. At first, it was small. What kind of harassment? Messages. He paused. People showing up during deliveries. Rachel approached gently. "Please explain." Daniel rubbed his hands together nervously. "People recognized me from her videos." The jury listened silently. Some customers recorded me. Some laughed. Some asked if I was the poor delivery guy. I watched Olivia carefully again. Still no remorse. Only tension, now controlled tension. And honestly, that disturbed me even more, because genuine regret usually surfaces naturally once consequences become visible. But Olivia Bennett looked worried about herself. Not Daniel, never Daniel. Rachel then introduced testimony from Daniel's former coworker, statements describing customers requesting the famous delivery guy, teenagers filming him secretly, drivers mocking him at work. One coworker reported Daniel began avoiding eye contact entirely after the videos spread online. Another described him eating lunch alone in his car. As I listened, I kept thinking about something many people misunderstand regarding humiliation. Humiliation is rarely about one moment. It's about repetition. Public repetition destroys identity slowly, especially when millions participate. Rachel finally asked the question hanging over the courtroom all afternoon. "Mr. Carter, why didn't you report Ms. Bennett earlier?" Daniel gave an answer I will never forget. Who would believe me over her? Silence again. That answer cut deeper than people realize because he wasn't wrong. Society often protects popularity instinctively, especially digital popularity. Millions of followers create perceived credibility, power, influence, and ordinary people learn very quickly how powerless they are against it. Rachel nodded slowly. Did Ms. Bennett ever contact you privately after the live stream? Daniel looked up for the first time in several minutes. Yes. That changed everything again. The courtroom shifted immediately because private contact after public humiliation suggests awareness, potential guilt, potential intimidation. Rachel carefully removed a printed document from her folder. Your Honor, these are verified text communications between the plaintiff and defendant. Christopher Hale stood instantly. Objection. Context incomplete. I reviewed the authentication paperwork. Admissible. Rachel handed copies to the jury. Then the messages appeared on screen. The first text came from Olivia Bennett 2 days after the live stream. You're getting a lot of attention, lol. Daniel's response arrived hours later. Please stop posting about me. Then Olivia replied, relax. People forget losers fast online. The courtroom reacted audibly. And honestly, I almost interrupted proceedings myself, not from bias, from disbelief. Some statements reveal character more clearly than years of testimony. Rachel displayed another message. Daniel, my daughter is seeing these videos. Olivia, that sounds like a parenting issue. Several jurors physically recoiled. One older male juror removed his glasses slowly and rubbed his eyes. Another woman stared directly at Olivia with unmistakable disgust. And here's what fascinated me psychologically. Olivia still didn't appear shamed, cornered. Yes, angry? Absolutely. But remorseful? No, that distinction stayed with me throughout the trial. Rachel then approached the witness stand slowly. Mr. Carter, she asked quietly, did there come a point where you feared Ms. Bennett? Daniel answered immediately this time. Yes, no hesitation, pure honesty. Rachel lowered her voice further. Why? Daniel's eyes finally lifted toward Olivia for the first time all day, and what happened next sent chills through that courtroom because she enjoyed it. Silence, heavy silence. People often assume cruelty comes from anger. It doesn't always. Sometimes the most dangerous people hurt others because they enjoy control, enjoy humiliation, enjoy watching emotional reactions. And when Daniel spoke those words, even I felt something deeply unsettling settle over the room. Christopher Hale attempted recovery during cross-examination. Smart lawyer, very smart. He focused aggressively on causation, no direct threats, no instructions for harassment, no physical violence. Legally, he still had arguments, but emotionally, the juries were slipping away fast. Then Christopher made another mistake. He asked Daniel, isn't it true you benefited financially from media attention afterward? Wrong question. Terrible question, because Daniel's response was devastating. I traded my wedding ring for therapy medication. You could feel the emotional impact instantly. Raw truth affects juries differently than rehearsed testimony. Christopher stopped speaking for several seconds afterward. And in court, silence from an attorney can be catastrophic. But the moment that truly shattered the defense happened near the end of the day, because Rachel Morgan revealed one final witness, a former employee from Olivia Bennett's content production team, a young woman named Madison Reed, and the second Madison entered the courtroom. Olivia Bennett looked genuinely terrified for the first time, not nervous, terrified. That reaction caught my attention immediately, because defendants usually fear evidence. They fear witnesses even more, especially former insiders. Madison sat down carefully, visibly anxious. Rachel approached slowly. Ms. Reed, she asked, how long did you work for Olivia Bennett? Almost 2 years. And during your employment, did you observe how viral content involving ordinary workers was created? Madison looked toward Olivia briefly, then back toward Rachel, and what she said next changed the entire direction of the trial. Yes, Rachel paused. Please explain to the court what the defendant called those people internally. Madison's voice trembled slightly. She called them NPCs. The courtroom fell silent again. Some jurors looked confused. I wasn't. I knew exactly what that meant. The non-playable characters, Brackle people existing only to entertain the main character. And suddenly, it be understood the real horror behind this case. Olivia Bennett had stopped viewing ordinary people as human beings entirely. But what Madison revealed next was far worse than anyone expected. I have spent most of my life inside courtrooms, long enough to understand something many people never learn until it's too late. The law can punish actions. But sometimes it struggles to measure cruelty, and as Madison Reed sat trembling in the witness chair that afternoon, I realized this case was about far more than a viral live stream. It was about what happens when fame removes accountability from the human soul. The courtroom was so silent I could hear papers shifting near the jury box. Madison looked terrified, not nervous, terrified. She kept avoiding eye contact with Olivia Bennett entirely. That detail mattered to me immediately. Fear between former colleagues usually means one of two things. Either loyalty was broken or secrets were buried. Rachel Morgan approached carefully. Miss Reed, she asked softly, you testified that Miss Bennett referred to ordinary people as NPCs. Madison nodded weakly. Yes, and what did she mean by that? Madison swallowed hard. She said they weren't real people to her. The jury stiffened instantly. Rachel continued. Please explain. Madison's voice shook slightly now. Olivia used to say most people only existed to make content. I glanced toward Olivia, still silent, still composed, but I noticed something else now, anger. Cold anger, not embarrassment, not regret. She looked angry that someone was exposing her. And believe me, there's a dangerous difference between people who regret causing pain and people who merely regret getting caught. Madison continued speaking. She had categories for people. Rachel frowned slightly. What kind of categories? Madison hesitated, then answered, people she thought viewers would enjoy humiliating. The courtroom erupted into whispers. I struck the gavel immediately, but internally, even I felt disturbed because suddenly Daniel Carter no longer appeared random. He appeared selected, targeted. The chosen Rachel approached the evidence monitor again. Did Ms. Bennett ever discuss Mr. Carter specifically before the live stream? Madison nodded immediately. Yes. Olivia's attorney closed his eyes briefly. He already knew damage control was impossible now. Rachel displayed internal production messages recovered from Madison's work phone, and when those messages appeared on screen, A.B. watched the entire jury emotionally turn against Olivia Bennett in real time. One message from Olivia read, the delivery guy from last time is coming again tonight. Another, he looks depressed already, lol. Then another, this one will go viral. A female juror whispered, oh my God. And honestly, that reaction mirrored exactly what I felt. Not because the messages were shocking individually, but because they revealed planning, anticipation, enjoyment. Olivia Bennett hadn't impulsively humiliated a struggling man. She engineered the moment deliberately for entertainment. Rachel asked the question everyone was thinking. Ms. Reed, did Olivia Bennett understand that Mr. Carter was financially struggling? Madison answered instantly, yes. How? Because she researched him. The courtroom exploded again. Christopher Hale stood up fast. Objection. But even his voice lacked conviction now. I allowed the testimony to continue. Rachel looked stunned herself. Explain what you mean by researched. Madison looked toward the jury nervously. Olivia had assistants collect information on people before filming content sometimes. Rachel's eyes narrowed. For what purpose? To figure out emotional weak points. I will never forget that sentence. Emotional weak points, not personalities, not backgrounds. Weak points, that language sounded less like entertainment and more like psychological hunting. Rachel displayed another internal message. This one from Olivia herself. Single dad. Broke. Perfect sympathy bait. A visible gasp spread through the courtroom. Daniel lowered his head again instantly, and suddenly I understood why he had seemed so emotionally destroyed from the beginning, because humiliation is painful, but discovering your pain was strategically planned, that breaks people differently. Rachel spoke softly now. Did Olivia Bennett ever express remorse afterward? Madison looked directly at Olivia for the first time. No, the answer echoed heavily. Rachel paused. Did she discuss Mr. Carter after the suicide attempt? That question changed everything again. Madison's face visibly tightened, and that's when I knew something terrible was coming. Yes. The courtroom leaned into silence. Rachel lowered her voice. What did she say? Madison hesitated several seconds before answering. Then quietly, she said the story was making her engagement numbers explode. Complete silence. Docile silence. I looked toward the jury carefully. Some appeared angry, some disturbed. One woman looked physically emotional, and Olivia Bennett, for the first time since entering my courtroom, she looked genuinely afraid because now the case had become moral poison. No lawyer on earth can fully defend indifference toward human suffering. Christopher Hale attempted one final defense, and honestly, he tried well. He argued lack of direct causation, lack of intent for self-harm, no explicit encouragement of harassment. Legally, portions of his argument held weight, but then something happened I did not expect. Daniel Carter requested permission to speak directly, not through his attorney, not through questions, directly. I allowed it. And what he said next silenced that courtroom more completely than any evidence had all week. Daniel stood slowly, hands trembling slightly, eyes exhausted. I don't hate her, he said quietly. That surprised everyone. including Olivia. Daniel looked toward the jury, then finally toward me. I just wanted someone to say what she did was wrong. No anger, no performance, just honesty, pure honesty. And in my experience, honest pain is one of the most powerful things a courtroom can witness. Daniel continued, for months I thought maybe I deserved it. Several jurors lowered their eyes instantly. My daughter stopped inviting friends over because kids at school showed her the videos. He paused briefly. She thought being poor was embarrassing. The room felt heavy now, painfully heavy. Daniel looked toward Olivia again. You had millions of people listening to you. His voice cracked slightly for the first time. You made them believe people like me were less human. And there it was. The true heart of the case, not money, not internet fame, human value, whether dignity belongs only to the rich or to everyone. I have heard thousands of statements in courtrooms over the years, but that one stayed with me because he was right. Influence carries responsibility, and millions of followers magnify cruelty into something catastrophic. Then came the final moment, the moment people online would later replay millions of times. I turned toward Olivia Bennett directly. Ms. Bennett, I asked, you wish to say anything before this court reaches judgment? For the first time all trial, Olivia hesitated, and I studied her carefully because judges learn to recognize the exact moment people confront themselves. Sometimes it produces remorse, sometimes denial, sometimes nothing at all. Olivia finally spoke quietly. I didn't think it would go this far. Wrong answer. The courtroom felt it immediately, not because the sentence sounded evil, because it lacked accountability. She still centered consequences, not Daniel, not his daughter, not the destruction, just the fallout. I leaned forward slowly, and I remember every word I said next. Ms. Bennett, the most dangerous form of cruelty is the kind performed for applause. Silence. You built an empire convincing millions of people that wealth made you superior to others. Olivia stared downward now, but this courtroom measures character differently. I looked toward the jury, then toward Daniel, then finally back at Olivia Bennett. Fame does not excuse humiliation. The courtroom remained frozen. Money does not purchase dignity at the expense of others. Even the reporters had stopped typing again. And influence without humanity becomes abuse. I entered judgment in favor of Daniel Carter. Substantial damages, psychological injury recognition, punitive financial penalties. But honestly, the money wasn't what mattered most. What mattered was what happened afterward, because for the first time since the live stream, Daniel Carter cried, not loudly, not dramatically, just quietly, like a man finally realizing strangers no longer viewed him as a joke, but as a human being. And Olivia Bennett, her empire collapsed within months, sponsors disappeared, followers vanished, former employees came forward publicly. The internet that once rewarded cruelty suddenly turned against her, but what stayed with me most wasn't her downfall, it was Daniel's daughter. Several months after the trial ended, I received a handwritten letter, children's handwriting, messy small. The letter said, "Thank you for helping my dad smile again." I sat alone in chambers after reading it, and for the first time in a very long time, I found myself staring silently at the courtroom window, thinking about how dangerous modern humiliation has become. Because today, people don't need weapons to destroy someone. Sometimes all they need is a camera and an audience willing to laugh. I have sentenced violent men. I have seen real evil. But believe me when I tell you this, a society that turns suffering into entertainment eventually forgets how to be human at all.